Yes, yes.
Thank you, Chair. Turning then, Mr. Sullivan, to your statement, you open your statement by giving an introduction and your profile, which you have annexed as Annexure A. This speaks to your background, your qualifications, and professional trajectory. Would you like to turn to that document, Annexure A, your profile?
As the annex.
And yes, it's your Annexure A, and highlight from that document such aspects that you think are particularly relevant to bring to the attention of the commissioners. If I may, that would be at your page 1 of the big file.
That's correct.
Yes.
Commissioners, I can just say briefly that if you have a look at page 2 thereof, you will see that my crime-fighting efforts go back some 40 or 50 years, in fact. So 1978, I received an award from Scotland Yard for preventing a crime in place and arresting a suspect. And then there's a whole lot of other annexes, we don't need to go through them, which will demonstrate that for the last 36 years in South Africa, I have been involved as a good citizen, attempting to play my part. My late father used to say, if a country is good enough to live in, it's good enough to fight for. And I took that quite literally when I joined the police back in 1990, which is now 36 years ago. And I gave of my time freely on a regular basis. Most reservist police officials would put in between 8 and 15 or 8 and 20 hours a month. You were required to do 8. I regularly did 60 to 80 hours a month. Not because I was bored, but because I had business activities which compensated me very well. And I just wanted to give something back to the community. And during that first, shall we say, 10 or 12 or 14 years, I made a number of arrests as a police official. And in fact, I was shot on duty 3 times. So I went through the rigmarole of doing what I did, and then I started focusing on drug cartels, and I also started focusing on organized crime insofar as corruption is concerned. And my career in the police came to a rapid end when I was dismissed by then Commissioner of Police Jackie Salebi, and the rest of it after that is history. I decided to open an investigation into Commissioner Salebi, and as is known, he was found guilty of corruption and sent to jail for 15 years. And on after that, Commissioners, I got involved in further crime-fighting activities, not as a police official, but as a volunteer. I formed a charity called Forensics for Justice, which I financed myself. And Forensics for Justice focused on dealing with corruption within the criminal justice system. And we're not talking here about a traffic cop asking for a bribe to avoid charging you for speeding. We're talking about serious corruption at general level within the police and at high level within the prosecution service. And those activities have been going on for another 15 years after the Jackie Salebi matter was finalized. And while all that was going on, Commissioners, it should be pointed out that I'm actually an engineer by profession, and I've been running my own property business both here and overseas, which has been my main form of income, property development and property speculation. But the reality is, I've been able to sustain my...
Ready for your next ride? With our massive variety, you're bound to find the one. Simply head to a We Buy Cars near you.
Sullivan, your involvement in the SAPS, I see at page 4. of that bundle, there's a letter from the SAPS which speaks to your position that you hold, and this is an SAPS letter. It says you currently, as a date of that letter, at least, which is 97 June 26, that you hold the position of lecturer. You see where I'm reading?
That's correct, Commissioner.
Is this what you employed? Were you ever operational at any point?
In fact, at the time that I was a lecturer at the Police Training Centre, I was also carrying out policing at the airport in the Border Police. So there was a reservist unit at the airport which I helped form, which comprised of about 35 volunteer members, and I selected people that spoke different languages so that we could have some impact on the crimes that were taking place at the airport. But during the period in question here, I was the head lecturer at the Police Training Centre, and in fact, one of the other pages, you will see that one of my students, in fact, on the next page, page 5, one of my students was the now President of South Africa, Cyril Ramaphosa. So it gives you an idea of the sort of activity we were involved in.
Thank you. Thank you, Mr. Sullivan.
Thanks, Commissioner Baloyi. And before we leave your CV at page 1, just to clarify, you indicate that having previously worked as an engineer, you are also or was a police officer for many years. Was that in South Africa or in the UK or both?
No, it was overseas. So I was in the United Nations Police for a spell. I was working for the British government. I was seconded to the United Nations Police, and that ultimately I ended up being seconded for a period to the BSAP, which was the police in what was then called Rhodesia, is now called Zimbabwe.
But you were never a police officer in the SAP or SAPS?
Correct.
Thank you. We then
Being seconded
invite
for a
us to
period
turn to
the BSAP.
the content of your statement. At page 1, you have listed under 8 topics the areas you would like to testify to.
Yeah.
You start, on my understanding, with paragraph 1.1, which are general comments to the nature of the testimony you'll be giving.
Yeah.
I invite you then to speak to the contents of paragraph 1.1 or to read them into the record if it suits you better.
Thank you, Commissioners. What I've done to speed this process up is I've gone through my statement and highlighted what I consider to be the relevant, vital components. So 1.1, I've used the headline, penetration of the criminal justice system by organised crime is not new. And then I've said, despite General Mkhwanazi's dramatic press conference where he purported to blow the whistle on infiltration of the criminal justice system by organised crime, criminals have been able to successfully penetrate the criminal justice system long before 6th of July 2025. There are many instances of such, and I will deal with some very well-known matters below. And then I've said the point needs to be clear. This is not a new phenomenon. It's been going on for very many years. Not only is it not new, but it will also be my evidence that General Mkhwanazi has known about the links between organised crime and the police for many years. It's not something he suddenly became aware of last year. I will also testify that one of the cornerstones of General Mkhwanazi's complaint, interference by the Minister of Police, is something that happened way back in 2011, at which time General Mkhwanazi elected to unlawfully comply with said ministerial interference. And I'll come back to that later, Commissioners.
Thank you. Just 2 questions for me before we move to the next topic. You suggest that, as you call it, the penetration of criminal justice system by organized crime is not new. Would it be a fair comment to say, at least on this score, you agree with General Mkhwanazi? That his testimony was that over a period of time, the criminal justice system appears to have been infiltrated by organized crime.
Yes.
And he testified to the extent he went to try and shine light on the problem. So, because you say it's not a new phenomenon, just on that aspect, I just want to find out if technically then you agree with General Mkhwanazi in that regard.
Nibola, my area of divergence is that it's not new. Of course, General Mkhwanazi brought it up on 6th of July last year, but it's nothing new. In fact, I've given an example of the 1990s, when the head of organized crime in KZN, Superintendent Piet Meyer, was sent to prison for 10 years for colluding with drug traffickers. So it's not new. It's been going on for a long, long time.
What's the point of diverging? What are you seeking to establish, or what are you seeking to convey to us by diverging on this?
Commissioner, if one looks at, and later we will come to it because I've had the media conference of General Mkhwanazi transcribed. If one looks at the transcript, it looks like, wow, this is something that's going on, it's just happening. But actually it's been going on for donkey's years. And to have it suddenly thrust into the public eye on the 6th of July last year, I will be later explaining that in my opinion, that actually there's another motive for what happened last year, and we'll come to that later, Commissioner.
Thank you, Chair. And in fact, the point about Senior Superintendent Piet Meyer you make at your page 3, at the top of page 3, that first paragraph, what you just alluded to.
Yes, I mentioned, sorry, ma'am, I didn't catch
No,
it.
I was saying the point about the arrest of Senior Superintendent Piet Meyer
yes.
you make at the top of
I've
page
covered that
3.
as an example, so I've gone way back.
Yes.
In the 90s. And then I come forward with a couple of examples in the last 20 years, serious examples, which are common cause.
And my second question is in relation to the statement you make about General Mkhwanazi, and you say at the bottom of your page 1, General Mkhwanazi has known about the links between organized crime and SAPS for many years. My reading of your statement, unless I missed it, does not seem to cover the knowledge that you attribute to General Mkhwanazi in this regard. Do you deal with this aspect in your statement? His knowledge of links between organized crime and SAPS?
Yes, I think what we'll come to later is not only his knowledge, but the steps he took, in my opinion, unlawful steps, to deal with one of the senior police officials that was involved in the penetration of organized crime into the criminal justice system. But I think I'll come back to that later.
All right. Thank you for that. That then would bring us to your paragraph 1.2. Having then said something about Senior Superintendent Piet Meyer and the events of 1990 to make the point that the problem is historical, you then at page 3, 1.2, deal with Mr. Glenn Agliotti and Commissioner Jackie Silebi. As you are aware, I think that is that relationship and its outcome has been ventilated for a long time and quite in depth in the public domain. So with that in mind, would you like to deal with your contents of paragraph 1.2,
Yes.
perhaps by way of summary?
Thank you. Commissioners, I'm not going to read the whole of 1.2 out because it's just, it's common course. But I've underlined a couple of important portions. 1.2.3, I've said Mr. Agliotti made his immoral living out of importing and exporting narcotics and counterfeit cigarettes. He often moved drugs and/or counterfeit cigarettes with a police escort arranged by a certain Captain Paul Stammet. Captain Stammet was not even a real police officer. He had been appointed by Commissioner Silebi at Mr. Agliotti's request. He was not even on the police's payroll system and had never undergone any police training or fitting out of uniform. But the sad part about it is he had a police identity badge that was issued by Commissioner Silebi. And then I've said Mr. Agliotti's other accomplices, and this is common cause, it's in the judgments which we'll refer to, included security company owner Mr. Clinton Nassif. Mr. Nassif also bribed Commissioner Celebi so that he could expedite the issue of firearm licenses for a security company. Mr. Nassif later supplied the same firearm that was used to murder Mr. Brett Kebble in September 2005. Commissioner Celebi interfered in the investigation by allowing Mr. Kebble's Mercedes, in which he was murdered, to be removed from Norwood Police Station by a brother-in-law of one of the murderers to a car body workshop where it was cleaned of all forensic trace evidence. And then I've attached, I refer on page 5 of my statement, I've referred to documents which are attached, which make sober reading. Annexure B1 is the first draft confession made by Mr. Agliotti to the Scorpions in his attempt to obtain indemnity in return for implicating Commissioner Celebi. Annexure B2 was the judgment of the High Court on sentencing Commissioner Celebi, and Annexure B3 is the judgment of the Supreme Court of Appeal dismissing the appeal of Commissioner Celebi against his sentence. And I think it's common cause, Commissioners, that the level of penetration was such, and it's made clear in Annexure B, which is referenced on page 4 at 1.2.7, it's made clear that the value of the drugs that were seized were 200 million rand. And those were seized by the what was then called the Scorpions, or the DSO, the Directorate for Special Operations. And that was based on information which I supplied to them at the time when I had infiltrated that drug cartel for the purpose of having those drugs seized. And it's documented on the Annexure B. Thank you, Commissioner.
And so if one has regard to your paragraph 1.2.3 and 1.2.4, where you make the conclusions that Mr. Celebi or Commissioner Celebi maintained relations with persons such as Mr. Agliotti and Captain Paul Stemmet, who made an immoral living out of importing and exporting narcotics and counterfeit cigarettes. That's on the one. And Mr. Celebi, Commissioner Celebi rather, being bribed by one Mr. Clinton Nassif. Those facts you do not know, you don't have personal knowledge of, you derive from the documents that you listed your paragraph 1.2.10.
But I've used the documents to prove that personal knowledge. In fact, the morning after Brett Kebble was murdered, which I still, very distinct in my head, he was murdered on the 15th of September, 2005. And on the morning of the 16th of September, 2005, I met with a source at the McDonald's at Bruma who gave me the information about the gun that was used to kill Mr. Kebble. So all that information is not hearsay, but it happens to be contained in the court judgments. So it actually confirms my personal knowledge.
But for purposes of your testimony to the Commission today, you rely on these documents specifically?
That is correct.
Thank you. Is there any other comment you'd like to make regarding the relationship between Commissioner Celebi and Mr. Agliotti before we turn to your paragraph 1.3, where you deal with another relationship?
Now, I'm really happy for the commissioners to, in their own time, to read the evidence and draw their own conclusions, because I believe it's quite compelling.
Yes. Then if we stay with your paragraph 5, your page 5 rather, at paragraph 1.3, you have a subtopic, Radovan Krecher, General Mabasa, and Colonel Steyn. Now, at page 6, you give quite an extensive background to this particular topic. It's at page 7, you then deal directly with the relationship between Mr. Krecher and General Mabasa on the one hand, and further on at page 9, you deal with Mr. Krecher and Colonel Steyn. So let's take it.
Let me just place on record that I was involved in a totally different capacity on issues relating to Mr. Aglioti, the murder of Mr. Brett Kerbel, issues that related to Mr. Stemmet and even Mr. Nassif, but the context related to the decision that had been taken by Mr. Vusi Pikoli to prosecute General Silebi. And then Mr. Mshe, or Advocate Mshe, came in to replace Mr. Pikoli, but he was an acting NDPP. And this is how I then got involved. Advocate Mshe wanted to know whether or not he should reverse the decision of Advocate Pikoli. A 4-person panel was appointed to look at that decision by Mr. Pikoli and to pronounce on whether the 4 people were of the view that Mr. Pikoli was correct in taking the decision. I chaired that 4-person panel, and our decision was that Mr. Pikoli's decision was correct. I thought I should just place it on record that I had that involvement on some of the issues or some of the facts that you are touching on.
Thank you, Chair. Understood.
Thank you.
In fact, thank you, Commissioner, for that. I was fully aware of all that, so I'm grateful that you still have that memory at the time. And in some ways, it's rather unfortunate or coincidental that we are sitting here today in the college named after the then Justice Minister, who took, in my opinion, an unlawful step together with the then President in suspending Vusi Pikoli, because I understood that suspension, in fact, was aimed at preventing the arrest and charging of Commissioner Silebi. However, that's my opinion. But obviously, I was very happy when in January of 2008, that 4-man committee issued the...
It was a 4-person, we actually had a woman.
There you go. I used the word man as in human. So I was very happy with the outcome of it, because I had actually left the country because there was a threat against my life for raising all those issues. So I had temporarily exited myself from the country for my own safety. So that was how tight things were in those days. Thank you.
Thank you, Chair. Thank you, Mr. Sullivan. But as I understand, your testimony today doesn't relate to that part of things that the Chair highlights. He's just placing it on record. You are dealing with the criminal charges and trials that subsequently took place.
And I think if you want to get the crux of what I'm saying, it is that the Aglioti syndicate, which was a drug cartel and counterfeit cigarette cartel, they had well and truly infiltrated the criminal justice system and were utilizing, at the highest level in the criminal justice system, their contacts to enable them to continue with their criminal activities undetected.
Thank you. If you are ready, then we're ready to turn to the next set of relationships, and this time it's between Rodovan Krecha and General Mabasa on the one hand, and Colonel Steyn on the other.
Yes.
I would perhaps suggest that you consider reading paragraph 1.3 and overleaf under the heading 1.3 at page 5.
Yes.
That would give us an introduction into the topic. And then you could highlight what you consider particularly important under background at page 6. You don't have to deal with that page extensively.
So for that purpose, I'll just read out 1.3. And I say that in this section, I will first give background information on Mr. Krecha. Then I will deal with senior police officials who I identified were on Radovan Krecha's payroll. I refer to the case of Krecha for 3 reasons. First, it is another obvious example showing that the issue of criminals infiltrating the police, ostensibly prompting the press conference of General Mkhwanazi, is nothing new. Second, it involved multiple attempts on my life. Third, it involved a corrupt police officer who resurfaced as a witness at this commission. Now, when I refer to him as a corrupt police officer, that is my opinion, because he hasn't been convicted of that, but I'll explain why I refer to him as a corrupt police officer. And then, if I may move forward.
Staying on top of the core concepts of sustainable investing can add value to your clients, your team, and your organization. Confidently communicate with stakeholders, build technical fluency in assessing climate-related risks and opportunities, and learn how sustainability factors affect investment performance. Start today to gain the insights and skills you need wherever you are on your sustainable investing journey. CFA Institute. Set the standard.
Written there.
Yes, please.
What happened was, I was investigating Radovan Krejcir for a myriad of crimes, lots of crimes. And by the way, I was doing this as a public interest matter. You will notice from my CV that I received awards in 2000 and 2001 from the Canadian government and the Australian government for activities that I used to expose and deal with human trafficking in South Africa, not in other parts of the world. But I got those award commendations from the Australian and Canadian governments because they recognized the work that I was doing. And I had identified Radovan Krejcir as being heavily involved with a gentleman from a chain of strip clubs known as Teasers. And I had identified that he was involved with importing, for the want of a better expression, ladies to work in these type of clubs. And I was trying to get the police to take action against him. And in every turn I was failing. I couldn't get the police to pay any attention to it. And I had written to Anwar Dramat, who at the time was the head of DPCI, and I sent him a very detailed breakdown of what I believed Radovan Krejcir was up to. And then all of a sudden I got a call out of the blue one day from the crime intelligence head in Gauteng, which was Major General Joey Mabasa. And he phoned me out of the blue. I hadn't been in communication with him ever before that. And he invited me to his office. I went there and he told me, no, he heard I've got information about Radovan Krejcir and he wants to take down Radovan Krejcir. I thought, wow, this is great. So I gave him a file on Radovan Krejcir. An hour later, I get a phone call from a source who's present in a meeting with Radovan Krejcir and tells me, Paul, that guy you just met with, you don't know what you're doing. I said, what do you mean? He said, that guy is on his way to see Radovan Krejcir with the file that you've given him. So I thought, wow, this Major General in the police is now going to see this criminal that I'm investigating. So let me see what's going on here. So I carried out my own investigation into General Mabasa. And what do I find? I find that his wife is a director of a company with Radovan Krejcir's wife. I was shocked. So of course I exposed all this, and what I find to be ironical, and it's covered on page, at the bottom of page 7 and page 8, is that the wife of General Mabasa became a director of that company on the 10th of October 2009. And she resigned as a director of that company on the 30th of June 2010. And it's no coincidence that the date of her resignation is 2 weeks after I had exposed the fact that General Mabasa's wife was in business with Radovan Krejcir's wife. And it was all over the media, and then she promptly resigned. Needless to say, my complaint, which is a very serious complaint, which I sent to General Zermatt and General Sabir at the time was the head of DPCI in Gauteng, and I sent them a very serious complaint, and within a week or two General Mabasa was suspended, and then he was later given a golden handshake. But what was interesting to me is that the registered address of that company was 64 First Avenue in Edenvale. And it came out during the trial of the murder of Uwe Gambella, a German who had been kidnapped from the airport and murdered. It came out during the trial that he was actually murdered at 64 First Avenue in Edenvale. So when you start putting all the pieces of the jigsaw together, it meant that General Mabasa was now heavily involved with Radovan Krejcir. And I think if you have a look at the annexes, which I've referred to, on page 8, 1.3.7, there's an Annex E, which deals with the actual murder of Lolly Jackson, this owner of the strip clubs. That's worth reading. It explains exactly what happened and how he was murdered by Radovan Krejcir, and how, after the murder, this fellow Smith, whose real name was Luca, met with General Mabasa, and General Mabasa told him he better pack his bags and get out of the country quick. And then Annex F deals with the, it's a newspaper cutting that deals with the fact that General Mabasa left the police unceremoniously and was paid out a 3.5 million golden handshake, when in fact he should have been arrested and prosecuted for corruption, but nothing of that happened. And the point, and I'm going to make it again later on, that whenever you get these senior generals, in the cases that I'm referring to, who should have been arrested and charged with corruption, they're in fact getting golden handshakes and let off the hook, and they go. So what you don't have is you don't have the, what I call the head on the pike that you need to have in the police service, so that if a person steps out of line, there needs to be some demonstration that if you step out of line, you're going to be in trouble. But actually in the police, if you step out of line, you either get moved to another department within the police, and I'm going to come to examples of that later, or you get a golden handshake and you're released from the police.
Before we deal with that detail then, that would take us to your Annexure G and H, which are affidavits you obtained at page 9. But before we turn to that detail, if I could just clarify a few things with you. At your paragraph 1.3.5, you indicate that you received an unsolicited telephone call from Major General Mabasa, who then was the Gauteng Provincial Head of Crime Intelligence. You had a meeting with him, and then you testified that you, after he had engaged you on the investigations you were doing on Mr. Krejcir, you gave him your file on your investigations.
Correct.
My question is, did you give him the original file? Did you retain a copy for yourself? Are you able to share with the commission the contents of that file as you gave it to General Mabasa?
Obviously, I can share it with the commission. I don't have it with me right now, but it was effectively, in fact, I didn't give him the whole file, because some aspects of the work I was doing I hadn't completed. So what I gave him was what I had completed at that stage. And that was the file that dealt with the money laundering that was going on with a gentleman by the name of Alekos Panayai, who was the bank manager for Cyprus Bank in South Africa, who was doing money laundering between Radovan Krejcir and Lolly Jackson. And that's what led to the murder of Lolly Jackson, because Radovan Krejcir would pay an amount of money into a bank in Cyprus, and then Lolly Jackson would give him a bag, a duffel bag or whatever, with the equivalent amount of rand. So he would get a bag with 2-3 million rand, and he would do a transfer. And what happened is what led to the murder. And if you look at these Annex E, you will see it. It details the fact that actually the final transfer they did, Radovan Krejcir presented a fake document indicating that he had transferred money into the Bank of Cyprus, when in fact he hadn't transferred any money at all. And Lolly Jackson then handed over a duffel bag full of rands in cash, and there was no concomitant transfer into his bank in Cyprus. So that caused the animosity between them, which ultimately led to the murder of Lolly Jackson.
Now, that is what you were investigating at the time.
That's exactly, and that's what I handed over to General Mabasa. Because I'd interviewed this bank manager, and I'd taken a very detailed sworn statement from him, and I supplied that to General Mabasa. As a result of what I found out, I then phoned that witness and told him to go into hiding, because I believed that they would have tried to murder him.
Now, at your paragraph 1.3.6,
Maybe before you do 1.3.6,
Yes.
Mr. Sullivan, you in 1.3.5, you said that you received this call from Mr. Mabasa unsolicited after you had given, I think you said, General Dramat. In your statement, you say General Shadrach Sibia.
Yes.
Is that a correction? Is it Sibia or Dramat?
I think it was both of them.
Well, later on, you do speak of giving them both a report.
Yes.
But here at the beginning, where you speak about what results in the unsolicited telephone call from
Yes.
General Mabasa, you say you had shared information of your investigation with Sibia. I just want to correct the fact. Is it General Sibia? Is it Dramat?
It was
Is
General
both?
Sibia and General Dramat.
At this point.
Yes.
Okay, thank you.
Whatever I supplied to General Sibia at that moment in time, I used to also supply to General Dramat, because I didn't want a single point of entry. I wanted there to be knowledge at different levels within the police about what was going on. In fact, I even went to the office of General Dramat and had a meeting with him about Radovan Kretschmer.
Thank you. Thank you, Mr.
Thank you, Commissioner Baloyi. At your paragraph 1.3.6, you say about an hour after you left General Mabasa's office, you got a call from a source advising you that he has been informed by Mr. Kretschmer that General Mabasa was on his way to see him with a file he had obtained from you. Now, I'm not going to ask you who your source is, but we have your say-so that this engagement took place. That's all we have.
Yeah.
Okay.
Absolutely, but that's my say-so, and it's more than my say-so, because as a result of that phone call, it caused me to investigate General Mabasa, and then I got that information on General Mabasa, which I then shared with General Sibia and General Dramat.
Now, having shared that file with General Sibia, who you say was DPCI Gauteng provincial head, and General Dramat, what position did he hold at the time?
He was the national head of DPCI.
National. What were you hoping to gain by sharing it further with General Mabasa, who, as you say, called you without any solicitation? Did you have a relationship with General Mabasa that allowed for a sharing of the results of your investigations? On what basis do you give him this?
Yeah, it's a very valid point. I wrongly came to the conclusion, and I should have checked, I wrongly came to the conclusion that General Dramat and General Sibia had instructed crime intelligence to get to the bottom of this matter. And I assumed, therefore, that General Mabasa was reaching out to me because he had knowledge. So if you've got this knowledge, then you must be involved in it. So I readily gave him this file.
And did you ever engage Generals Dramat and Sibia about this matter and whether or not they had an
Immediately
engagement
afterwards.
with?
So, Commissioners, if you have a look, on the same day that I met with
Mr. O'Sullivan, you should wait until...
Oh, sorry.
Yeah, if you speak at the same time, there will be problems with the transcription.
So I thought you'd finished.
No, my question was, after then your source called you to inform you that Mr. Kretschmer has just had a telephonic discussion with General Mabasa about a file you had given to General Mabasa. When you learned that, did you ever have a conversation with General Sibia and Dramat about the turn of events? Who are the people you say you had initially engaged around this matter?
Yes, but I didn't do it the same day. So what happened was I got this phone call. Then I thought, wow, if this is true, because you don't take everything you're told as being the gospel truth, you have to look into it. But what it prompted me to do was to look into General Mabasa. And coincidentally, when I went to meet him at the Diagonal Street building, being the type of person I am, he'd arranged parking there for me. And when I went to park there, I saw a parking bay. And it's not in my statement, but I'm just recollecting this. I saw a parking bay marked up for General Mabasa. And I made a note of the registration number of the vehicle that was parked there, just for my own interests, because it looked like a very fancy double cab. So I made a note of the registration number of that vehicle. And then what happened, when I get this phone call, I then start to carry out investigations. And I immediately found out that General Mabasa's wife was in business with Radovan Kretsch's wife. They were directors of the same company. And I could not think of any logical reason other than it was to conceal some form of corruption. And then when I ran the checks on the motor vehicle, I found that the vehicle, well, I phoned the dealer, I found that the vehicle had been purchased by Radovan Kretscher for General Mabasa. So you put the pieces of the jigsaw together, which I did. And I then went and met with General Dramat. I phoned General Sabia and told him what I'd found, and I went and met General Dramat because I was so keen to make sure that they did something urgent about it. And I think a week later, General Mabasa was suspended.
Did you do an in-artist check on the vehicle, the registration of the vehicle?
Correct.
Yeah.
Yes, correct.
Is it not so that all that this would have shown you is in whose name the vehicle was registered? Why I'm asking that is, how did you then establish who had purchased
So we're able to, Commissioner, we're able to do various checks. The one check you can do is just to get the ownership of a vehicle. Another check you can do is to get the history of the vehicle. It wasn't a brand new vehicle, it was a used vehicle. And the previous owner of it was Groep Twee Beleggings, which was Radovan Kretscher's company. So you put two and two together.
Thank you.
My question was going to try and understand the checks that you say you conduct. Are these the checks that normally are reserved for law enforcement to undertake, or do you have access to the system? And
Yes,
if so, in what capacity?
Let me explain to you. We don't have access to the NITIS system. We have access to what we call closed source data banks. So we have to sign a code of conduct with, so they're accessible by certified fraud examiners, forensic investigators. It's not the same system that the police use. It's a private system that's used, for example, TransUnion. I don't actually do the checks myself. I have staff that do it, but I don't know the systems we use, but they are all above board and all lawful. We have to sign a code of conduct so that we're not, shall we say, becoming information peddlers where people can't come and pay us for information. And we have to stipulate that the investigation is being done for a particular purpose. So it's fraud. So if you're investigating fraud or corruption, you have access to these databases, and it's all above board.
And you say this, you have access to these systems as a certified fraud examiner. Who certifies and registers examiners for that purpose? And what is the name of your entity that is so registered?
The Association of Certified Fraud Examiners. There's a South African chapter. There's a chapter in most countries in the world. And it's a very rigorous process to go through. You have to have a first degree, you have to do 2 years of work in the fraud field, and then you have to sit exams. So it's quite a process. You can't just wake up one morning and decide, oh, I'm going to be a certified fraud examiner. It's quite a rigorous process to get through. And by the way, when you enter into these code of conduct contracts with the Information Bureau, they carry out checks on you to make sure that you don't have criminal record and stuff like that. So it's quite a tight system. It's used by lawyers, it's used by certified fraud examiners, and it's used by chartered accountants that are working in the forensic accounting field. And it's necessary, by the way, because unfortunately the level of fraud and white-collar crime in South Africa, the police just don't have the ability to cope with the level of investigations required.
And perhaps just to conclude on that point, is there a particular regulator that regulates the activities of these fraud examiners? Is there?
Yes.
What is that? What's
It's
the
the
authority?
Association of Certified Fraud Examiners.
It's not a state regulator, is that? That's an
Not a state regulator, no.
I was asking from the perspective of state and law enforcement.
It's
Is
the
there
same
any
like chartered
regulator?
accountants. There's no state regulator. It's the same like, well, I suppose with attorneys you've got the LPC,
Yes.
but it is very well regulated, trust me. And they have, if you look into it, for example, the Association of Certified.
My work is easy because I use ClickUp. Here's how I keep track of all my tasks. I start by brain dumping everything I need to get done in a list view. Next, I set a priority and a due date to keep things on track. I create custom statuses to organize my progress exactly how I want it. I like to add the action items field so AI can show me the next steps. I add my teammates as watchers so they're in the loop. ClickUp makes work easy, from personal projects to running a multi-billion-dollar company. Click the link below to create your workspace for free.
Were shareholders in the company?
So we didn't get the share register. We could just see that
directors.
they were both directors.
Directors.
Share register is harder to get. One has to do what we call a Section 26 application. Section 26 of the Companies Act, where you write to the company and you give them notice and they have to give you details of the share register within 14 days.
Yes.
We didn't go to that length, but I was satisfied that the two of them were directors of a company, and that was more than just a coincidence.
At page 8 then, at paragraph 1.3.7, you deal with the murder of Mr. Lolly Jackson.
Yep.
You see where I pick it up, at your page 8.
Yes. So, Commissioners, it's set out in some detail in Annexure E, and I commend you to read that. It's quite clear. In Annexure E, it's quite clear what happened there, and it's...
That Annexure E is at page 174 of the big file.
174, yes. Now, if you skip the first 2 pages of 174 and just go straight to page 176.
Yes.
Because the first couple of pages is more of an introduction. 176 explains exactly the relationship between this fellow Smith, whose real name was Luca. He was an illegal immigrant, by the way. He was in the country unlawfully. He was a Cypriot. And by the way, he was wanted in Cyprus as well. And he talks about the relationship between Jackson, Radovan Krecher, and this fellow Panay. And Panay was the gentleman I interviewed over a period of 2 or 3 days and taken a very detailed statement from in connection with the money laundering that was going on. That's the statement which I'd, apart from supplying to the DPC, I had given to General Mabasa. And then if you go then to page
186?
180, and you look at paragraph 45, 44, or 43, Krecher arrived after some 5 or 6 minutes later and was also offered a drink. Within moments, Jackson had begun to shout at Kretcher and to waive the copy of the SWIFT transfer. This was a forged SWIFT transfer. And Jackson swore at Radovan Kretcher. I'm not going to swear here, but it shows what he said. Kretcher lunged forward to grab the SWIFT transfer from Jackson, who held it out of reach. At this point, Kretcher pulled out a firearm and shot Jackson once. Jackson fell into the back of the sofa, positioned directly behind him. Jackson looked shocked and began to plead and beg for his life. Kretcher crossed the floor towards him, standing over him, and kicked him in the side of his chest and said the following words to him. Quote, "You want to know who I am? I will show you who I am, you effing cockroach." Kretcher then proceeded to fire many shots into Jackson. I don't remember how many, but there were several shots. Jackson appeared to be dead and lay in a pool of blood. I was horrified and frightened. And then he carries on a bit more and a bit more. And then he talks about paragraph 59 on page 182. I got back into the car and drove away, exiting through the booms at the entrance to our suburb, and then called General Mabasa from my phone, telling him what I had just witnessed, Kretcher killing Jackson, and to ask for his help. He asked me who was present at the time of Jackson's murder, and I told him that Kretcher and Cyril were there. The Cyril referred to, commissioners, is Cyril Beaker. He also passed away a couple of weeks after this, so he was shot and killed a couple of weeks after this. He asked me where I was. I told him I was driving Jackson's Jeep. He suggested I meet him at Bedford Center and I should speak to Kretcher as soon as possible. Mabasa knew of the problems between Kretcher and Jackson, having already been approached by Jackson to intervene and assist in facilitating a meeting with Kretcher. So here you have General Mabasa getting involved in a dispute between two shady characters, the one being Radovan Kretcher and the other being Lolly Jackson. I too had spoken with Mabasa about the need for a meeting to be arranged. I didn't drive immediately to, this is page 183, I didn't drive immediately to Bedford Center, but drove around for a while. Radovan was calling me on the phone. I didn't take his calls at first. Later, I called him as advised by Mabasa. He asked me to meet him at Yanni Lucas Engine Garage near to Linksfield. We met there. When we got there he got there before me and I met him behind the garage. He wanted me to calm down, but I was extremely angry with him for what he had just done and didn't want to listen to his stories. He asked me why I'd driven off and left the house. He said that I was supposed to have helped him put the body in the car and then dump it. I drove off and headed for the Harbour Cafe in order to meet with Mabasa. Upon my arrival, I saw several people, including Cyril Beaker, who was sitting with Hein Mitrovic in the smoking area. I asked him whether Mabasa was there. And it goes on. And then eventually, if you go on to page 184, Kretcher arrived at 10 p.m. This was at the Nickel Hotel in Bedford View, and told me I had no choice but to leave the country. As he put it, Lolly was murdered in your house. You were there when it happened. You are up and there's nothing you can do about it. He reminded me that I was due to appear in court the following day. So to cut a long story short, this guy packed his bags. He got taken over the border into Mozambique, and indirectly flights ended up in Cyprus.
Yes. If we could just stay with that affidavit, and you have covered it quite extensively. If we go back to your paragraph 1.3.7,
Yep.
where you introduce the murder of Mr. Jackson,
Yes.
you continue.
Yes.
General Mabasa was later at that crime scene as part of a conspiracy of Mr. George Luca, aka George Smith. You see where I'm reading?
Yep.
And you then reference Annexure E, which is this affidavit we're looking at.
Correct.
My reading of Annexure E is slightly different. If we start at paragraph 42,
Yeah.
which is the arrival of Mr. Smith,
Yes.
and then inviting Mr. Jackson into a living room.
Yes, if I can explain that.
Yes.
It's very easy to explain. When I say General Mabasa later dishonestly claimed that Mr. Smith had called him to confess, That
No,
wasn't-
no, you are ahead of me. I made the statement prior to that.
Yes, but it wasn't pertaining to that statement. It was pertaining to the media. It's what General Mabasa said to the media. So it was published in the media that General Mabasa had said that George Smith had phoned him to confess to murdering Lolly Jackson. So it wasn't in the statement of Smith, and Smith would probably, on his way out of the country, would not have known of that. The very next day, it was in the media, and that can be found if it's requested. I can find those media links.
Just to make sure we're not talking at cross purposes, I was more interested in the statement you make that General Mabasa later arrived at the crime scene as part of the conspiracy to cover the fact that Mr. Krecha himself had murdered Jackson.
Yes.
And that fact is not in here because the narrative by Mr. Smith places Mr. Mabasa nowhere near the house where Mr. Jackson was supposedly murdered.
Correct. There are other statements from other people that place General Mabasa outside the crime scene while the crime scene was being investigated by the police. And I haven't obtained those statements and supply them.
I just wanted to be clear that it's not an extra E,
No,
because
it's
my
not in
reading
his
of an extra
statement.
E
No, he
doesn't
wouldn't-
lead
he
me to
wouldn't
that
have been
conclusion.
aware.
Okay.
Smith wouldn't have been aware of that.
Yes. You continue at paragraph 138, where you say you later established evidence of a corrupt relationship between General Mabasa and Mr. Krecha, and you reference this Toyota Hilux double cab. Is that the vehicle you say you found parked in General Mabasa's bay when you went to meet him in center Johannesburg? Or is that a different vehicle now?
Pardon? It's the same vehicle that was parked in his parking bay at Diagonal House or Diagonal Street. It was the old Stock Exchange building.
Okay. And then I think you did touch on your Annexure F, which is the article.
It's a media article.
The media article from page 186 that speaks to the settlement
It
to
refers
General Mabasa.
Yeah,
You've made the point.
The headline there is 3.5 million for dodgy cop.
And then at 139, then it's basically...
If I can.
Absolutely.
It's not mentioned in my statement, but it's just reading this again reminded me of something. It's quite important. The 3.5 million for the dodgy cop, that payment was authorized by General Ndluli. So that's quite important to remember because we'll be coming to General Ndluli later.
And
what was his position at the time? General Ndluli, what was his position at the time?
Pardon me?
What was General Ndluli's position at the time?
He was the Divisional Commissioner of Crime Intelligence. So what happened was, during the Celebi investigation, General Ndluli was the Provincial Commissioner of Crime Intelligence, and the Divisional Commissioner was Lieutenant General Madlanga Mpejo. And Madlanga Mpejo was arrested by the Scorpions for interfering in the Jackie Celebi investigation. And while he was on suspension, he resigned and left. And then General Ndluli was promoted to Lieutenant General and became the Divisional Commissioner, and General Mabasa became the Provincial Commissioner.
Thank you. A different question. This Smith affidavit, it was prepared for what purpose? Is it for the police or for you, your investigations?
If you look at the Smith affidavit, Commissioners, you will see it's a standard pattern Section 204 affidavit. So it's not the only affidavit that was made by Smith. There were other affidavits.
So it was for the prosecution or
So
for the
if
police?
you have a look at the affidavit itself, it says Affidavit of George Smith, number 5, there were a total of 5 affidavits. Now, at the time these affidavits were made, because of the level of organised crime that Smith knew about, which didn't just deal with General Mabasa, it was decided by the DPCI to compartmentalize his affidavits, not have it all in one big affidavit. So this was the affidavit that relates particularly to the murder of Lolly Jackson. So there are other affidavits which I've not put here because they don't really take the matter any further. But if the commissioners wish to see them, I do. I have them all.
Thank you, Mr. Sullivan.
Thank you, Commissioner. And we're still at Annexure F, unless it's a case of perhaps this being in another document. Annexure F doesn't indicate that 3.5 million golden handshake for General Mabasa was approved by General Mdluli. That's not in that particular annexure.
No, I didn't.
Okay.
I didn't put it in my statement, and it's not mentioned in here. But at the time, I remember
from your recollection.
That payment was authorized by General Mdluli.
Yes. Then at page 9, you introduced 2 affidavits, Annexure G and H.
Yes. Sorry.
Annexure G and H,
Yes.
your 2 annexures. If I understood you correctly, these 2 documents now deal with attempts to murder you. So we have sort of moved away from what you call a corrupt relationship between General Mabasa and Krecha. These 2.
In fact, they are mixed because what I'm going to say here, Commissioners, if you look at page 8 at the bottom, 1.3.9,
Yes.
I say there, in summary, I find it apposite to state that Mr. Krecha, because of his corrupt friends in the police, considered himself above the law and therefore free to engage in any criminal activity he chose, including, not limited to, murder. I should record that Krecha has now been sent to prison for 35 years and is still to be tried in respect of multiple attempts to murder me. He's been arrested and charged for, even though he's in prison, he's been arrested and charged for conspiracy to murder me, along with 7 others, which includes police officials, by the way. And the statements of this fellow Potiska, who's residing in the Czech Republic, the one statement deals with the conspiracy to murder me, which is Annexure G. And again, these statements are compartmentalized so that you don't have everything all in one document. But if you look at Annexure H deals only with the relationship between Radovan Krecha and General Mabasa. The Annexure G deals only with Radovan Krecha's conspiracy to murder me.
Yes. So then let's turn to General Annexure H, which would appear, or at least sound, to be more relevant to this relationship you are dealing with.
Page 193.
Page 193. And I would like to refer you to paragraph 5.
Yes. Sorry, I thought you wanted me to read.
No. My understanding, again, my reading of this, it's Mr. Poteska commenting about the relationship between General Mabasa and Mr. Krecha. It must be over a 2-year period, because at paragraph 2, he says, I was during the period of September 2010 until 2012, 02, 03, living in South Africa. So it can only be specifically for that period. And from paragraph 5, he then details the nature of this relationship. And as I understand it, it's about picking up General Mabasa from a small shell garage near Eastgate, delivering him to where Mr. Krecha was, and basically where General Mabasa would collect 5,000 to 10,000. And further down at 7, he speaks about his own personal experience where he had to hand over some money to Mr. Mabasa.
Yes.
At 8, he then introduces a different concept, and he says these guys from the police started helping Krecha smuggle cigarettes from Zimbabwe into South Africa. Thereafter, Krecha used them for drug trafficking too. But there is no substantiation for that allegation. Now, this affidavit would seem in large part to be about payment of some monies, 5,000 to 10,000, by Mr. Krecha to General Mabasa. Would I be correct to say that's about the sum total of it?
That's correct, Commissioners. I want to mention, if I can briefly, that there's 2 statements here from this fellow Putiska. Both statements, up until paragraph 4, are identical. Believe it or not, there were 5 such statements again, dealing with different issues.
Yes.
So these are the 2 statements which were considered relevant for this commission, but if they require to see the other statements, they are available. But the reality is that this person who was interviewed, I was present when he was interviewed. Also present was Brigadier Geninda and Deputy Director of Prosecutions Lawrence Khaber. And the interview took place in Prague. And I arranged the interviews because they couldn't get access to this person. He didn't want to talk to the police or the prosecution authority without somebody being present that he trusted. And I had reached out to this person and convinced him to give evidence. So those statements were taken. I was present, but they interviewed him, and the statements were taken in their presence. And this woman, Eva, whatever her name was, I can't say it, Motiskova, she commissioned the statements because she's a sworn translator, because the individual in question doesn't speak English very well.
So these statements, you're saying they were actually taken by, I missed the rank of Geninda.
Brigadier Geninda.
Brigadier, was he the investigating officer in this?
Yes, he was the lead investigator of the Radovan Krecha matters.
So they would be found in the docket?
Absolutely.
Okay. All right. Noted. To the extent that it's necessary, we may seek to obtain the remainder of the statements. You then, at page 9, introduce a slightly different.
Sure, much better.
Right?
Driver, this Bentley is gonna last me the whole day. It's fine.
Italics, generally speaking, would be classed as hearsay because it's what somebody phoned and told me. And then, having received that hearsay, I became acutely aware of the fact that Radovan Krecha was now in possession of my cellular phone records, to the extent that he was looking at the people I was talking to on the phone. And remember, in those days, we didn't have all these smartphones that we had today. They were just starting to come out. So WhatsApp, I don't think it even existed then. So whatever phone calls you made, it was on your phone records. And what had happened was this person was called in to a meeting at a restaurant in Bedford View, just across the road from the police station. At the time, it's no longer there. It was called News 24 Cafe or News Cafe or something like this. News Cafe, I think it was called. And this fellow phoned me and he explained to me exactly what went on. And he said that he was called in, he sat there. There's Radovan Krecha and all these, wherever Radovan Krecha went, he had these heavy persons, you know, stocky fellows. And sitting next to Radovan Krecha, according to him, was Colonel Sambo, who was the station commander at Bedfordview Police Station in uniform. And Radovan Krejcir is alleged to have said to him, listen, on such and such a date, you phoned O'Sullivan 25 times. What's going on? And he was very quick on his feet, and he explained that he was trying to sell me a car. Of course, that nothing of the kind was going on. He was actually helping me out with inside information about the movement of Radovan Krejcir, because he was going to be arrested at that time. In fact, he was arrested. So Radovan Krejcir leaned across the table and said to him, if I find out you're lying, he put his finger on his forehead, if I find out you're lying, I can put a bullet hole there. So kind of scaring the guy. And he made the comment to me that Colonel Sambo just sat there quietly while all this was going on. And this person asked, well, how do you know that I made all these phone calls? He said, well, I've got your cell phone records. So at the time, I planned to launch an application. It was going to be an urgent application against Vodacom. And I drafted, and it's this Annexure J. I drafted a sworn statement for it, but I never actually launched. And the reason I never launched was because when I got senior counsel's opinion, he said that I might fail with that application. So I decided to keep my powder dry. But then what happened? About 2 years later, I got a tip-off from a person who was working at the organized crime office at Germiston, which is the same office which Colonel Steyn was the commander of. He was in charge of that organized crime office. And he told me that he needed an urgent meeting with him. I went and met with him. And he told me in no uncertain terms that Colonel Steyn was arranging to have my telephone number as part of the normal work in progress that the organized crime unit in Germiston was doing. And then that prompted me to write, by the way, before that, I'd written to Vodacom. And if I can refer the commissioners to Annexure F, page 206. Page 206. Now, you have to look at page 207 and 208. Because what we have here is a trail of emails, and they go in sequential order, with the most recent being the top page. But if you go back to page 209, it's an email that I've received from Vodacom. And if I can read it into the record, commissioners, it's dated 13th of June 2011. And this is after I found out about my cellular phone records being in the possession of Radovan Krejcir. I've contacted a chap by the name of Bradley Smith at Vodacom, and he's written to me. He said, "Good afternoon, Paul. Thank you for your mail. As discussed, we have received Section 205s for information relating to your call data related information." I'm just reading there's some typos here, but I'm just reading it the way it is, Commissioners. And Vodacom is obligated to disclose this information if we receive a Section 205 to do so. Unfortunately, as mentioned, this is a matter that you'll need to take up with the police and the Justice Department collectively. As to the authentication of the 205 and the content thereof, in doing so, I can advise you that there were 3 applications made. And then he gives the case numbers. Primrose case 709/3/2011, kidnapping, assault and theft. Then there's Tukosa case 268/04/2011, armed robbery. And the third one is Tukosa case 31/06/2011, murder. So the inference is that my cellular phone records were needed because of these investigations into a murder and an armed robbery in Tukosa. and a kidnapping, assault and theft that took place in Primrose. So what I did when I got this information was I sent an email to General Sabia, who at the time was the head of what do you call it?
Was it the
DPCI.
DPCI in Gauteng?
Yeah, I'm trying to look for that email.
Which
Yeah, in
email?
fact, I only wrote to him later. I supplied it probably by hand to him in a meeting. But later on, in November 2021, 21 November 2013, I write...
Sorry. Just a moment. Is it not
Sorry.
210?
I was going to suggest 210, an extra K. That's the
Page 210.
email, yes.
Yes, sorry.
From you to General Sibia dated 21st November 2013.
Yes. And I explain there that, and I say, by the, bless you, this is dated 21st of November. And I say, as you will see, in my email, I say, as you will see. But I was referring to what I knew would happen the next day when I said that. And I'll explain why in a moment. I said, as you will see, Colonel Francois Steyn admitted to a Mail and Guardian journalist today, in the presence of my attorney, Gary Massahan, that he had made a significant loan, that he had been made a significant loan by Radovan Krejcir's company, Groep 2 Beleggings. The money was used to pay off a registered bond on his property. Now, just why would a senior cop borrow money from an unregistered loan shark to pay installments on his bond account? As part of an attempt to cover his tracks, he said that Cyril Beaker made the loan via this company and he did not know that it was a Krejcir company. Anyway, with the death of Cyril Beaker and the fact that Krejcir is a suspect therein, because Radovan Krejcir was a suspect in the murder of Cyril Beaker, it is simply inconceivable that Steyn thought he could get away with this. I believe that having now admitted to receiving a very substantial loan, he has committed a very serious offence in terms of Act 12 of 2004, and I request a very urgent investigation with a suspension from duties in the meantime. I hope you can deal with this matter quickly, thereby placating the public who are starting to feel Krejcir can get away with anything he likes. And I finish off by saying the fact that yet another senior cop has put my life at risk by supplying my private information to gangsters is something that also needs to be addressed, and I reserve my rights in that regard. And copied to that email is an email that I had sent to the lawyers of Radovan Krejcir. I don't propose to read the whole thing out, but I do say, halfway down the page, I can now prove that Steyn supplied Krejcir with my cellular phone records, thereby further putting my life at risk. Back in 2012, and that's a typo, it should have been 2011, I just thought it was Steyn. Now I know it was Steyn. I've written to the Hawks requesting that Steyn be suspended and stand trial along with Krejcir for their disgraceful conduct. And if we now refer to Annexure L, which is page 213, this is a Mail and Guardian article which came out the day after I sent this email. And the reason it came out the day after I sent the email was because I had spoken to the journalists. When you get into a position where you believe these criminals are working with dirty cops to have you murdered, your best line of defense is to involve the media. And I had spoken to the journalists and they ran this story. And the headline, as you can say, is Krejcir's 400,000 Rand loan to top cop. And it explains in some detail about the loan and the excuse which Steyn had given to the journalists. But the reality is he admitted that there was a loan. Now, only when I saw Colonel Steyn giving evidence at this commission, I nearly fell off my chair because I thought he'd been suspended and dismissed. back in 2013. And now I suddenly saw him sitting at this commission. I thought, wow. And now he's talking about drug trafficking. He was working, he was on the payroll of a drug trafficker, in my opinion, back in 2011, because he received this money from Radovan Kreća. So now, suddenly, a complete turnaround. So I thought it was necessary to include mention of this, commissioners. Now, that's really all I have to say about that.
Let's just quickly deal with paragraphs 1.3.12 and following. There are two issues here.
Sorry, just give me the paragraph number again.
1.3.12 at your page 10.
1.3.12.
Yes.
Yes.
Now, right through to 1.3.15. As I understand, there are two distinct issues here. The first is your complaint regarding intrusion into your privacy by obtaining or seeking to obtain your records. And if we go to page 209, which is that email you wrote to Vodacom.
Correct.
No, which is what the email Vodacom wrote to you. Vodacom lists the 3 cases on the basis of which the Section 205 was obtained.
Correct.
I suppose inter alia in respect of your records.
Correct.
Why do you then say, no, let me ask differently. Have you ever seen the application for that 205 and supporting documentation to know the relevance of your number to any of the 3 cases?
So this is the difficulty. I had prepared the application against Vodacom, commissioners. And when I consulted with senior counsel, they said that bringing an application to force the state to show the content of a Section 205 application to obtain your cell phone records would be almost impossible to get such an order. And the court would err on the side of safety and not grant. And the reason given was, supposing I was a suspect in these cases, and now I'm bringing an application to find out what statements lie. Because when you bring a 205 application, you have to state this person is suspected of murder or armed robbery or whatever the case may be. So without having seen those 205s, it's just guesswork. But the reality is, I wasn't kidnapping people in Tokoza or murdering people or robbing people in Tokoza in that period. And if you look at the period in question, it's 1 month, 1 month, 1 month. So for 3 months, they were able to get my cellular phone records, and it fits straight in with the period that Radovan Kreća was arrested and there were raids on his house in Bedford View, and he was arrested. And during that whole period now, he's got my cellular phone records. So you can just put 2 and 2 together.
I appreciate your challenges, but I'm sure you'll also appreciate my challenges this end, that it has to also, in the absence of the 205 applications, it also has to be guesswork that Colonel Steyn unlawfully dropped your number in these 205 applications, because we do not know how your telephone number is said to be associated with any of the 3 cases.
Yes, if I didn't receive this phone call from Warrant Officer Steenkamp, he unfortunately passed away during COVID. But if I hadn't have received that phone call, and by the way, I don't name him in my email, but the fact that I sent the email to Radovan Kreća's lawyers, and the fact that I forwarded that email to General Sabir and General Zermatt to say, listen guys, look what's going on here, doesn't prove, but it makes it clear that, watch the media, by the way, you will see, and it was out in the media the next day, that he admitted having a 408,000 Rand loan from Radovan Kreća's company. So if you put all the pieces of the jigsaw together, it's circumstantial evidence, but when you put it all together, it's a very interesting picture, and somebody would have to explain what happened there. And I don't know if the Commission has the ability to get the police to hand over those Section 205 applications, but I'm pretty sure they would make very interesting reading.
Yes. Now, that was the first point. The second then you make is about this loan that you say was for Mr. Stein's mortgage bond account. Did you say that at your paragraph 1.3.12 of your statement?
1.3 point?
12. The conclusion of that paragraph. Then you introduce an extra K, which is your email chain to General Sibia.
Correct.
At paragraph 1.3.14, that an extra L, which is the actual Mail and Guardian article you reference, you say, Colonel Stein admitted to receiving the loan in question, but claimed not to have been aware that the company providing it was linked to Mr. Krecher. Then you conclude his story was not only feeble, but it could also not be reasonably true. I'm reading at your paragraph 1.3.14.
Correct.
If one has regard to the article that you reference and rely on from page 213, you have referenced this company, Groep 2 Beleggings, which is a company, you say, the article says it's controlled by Mr. Krecher. If you go to the bottom of that article, there is an explanation, ostensibly by Colonel Stein, of how the loan came to be. But the long and short of it is Colonel Stein says Mr. Beaker had undertaken to arrange a loan for him through this company. Now, at the next page, at 214, under the heading Professional Relationship, Colonel Stein argues that he has a professional relationship with Mr. Beaker, whatever that means, who was the National Risk Manager for REM, hand-to-hand couriers. And then at page 2015, those paragraphs, he deals with the repayment of this loan. Why do you then conclude, based on the explanation he gave, that his explanation is not only feeble, but it could also not be reasonably possibly true?
Thank you.
What could be the truth?
My take on this, Commissioners, is we have to understand that he's giving this explanation to the media in 2013, and he's passing everything off on this person called Cyril Beaker, who had been murdered in May 2010. So it's very convenient now, because dead men, as we know, cannot speak. So he blames everything on Cyril Beaker. But let's say his story was true. It was common cause in the country at the time that Cyril Beaker was murdered, that Cyril Beaker himself was part of the Cape Town underworld and was running protection rackets in Cape Town. So why on earth would you want to get involved in getting a loan from a person that was involved in protection rackets in Cape Town? And why on earth would you go to a company, the lawyer of a company called Groep 2 Belegging, without finding out who is this company? Now, you're a commander of an organized crime unit in Germiston. And if this hadn't have come out in the media, which it did, and it only came out in the media because I found out about it, then he would have concocted another story, I suppose. But the story is absolutely feeble. And if it was true, what was he doing business with a member of the Cape Town underworld, borrowing 408,000 Rand? So whether he borrowed the money from Radovan Krecher or borrowed it from Cyril Beaker, it's the same difference.
Can I ask a question?
Yes.
You sent an email to General Sibia and I assume to General Dramat. Is it not fair to assume that since you reported the matter to them, in fact, you asked for then Colonel Stein to be suspended? Is it not fair to assume that they looked into the matter and their view was that there was no wrongdoing?
So, thank you, Commissioner. In fact, what happened was Colonel Stein was suspended as a result of this. And this was now in November 2013, okay? And if one looks at what happened after that, unfortunately, my time was taken up with bigger issues, because on January the 9th, 2014, which was 6 weeks later or 7 weeks later, first of all, Radovan Krejcir was arrested at the same time. So we had Radovan Krejcir arrested, we had Colonel Steyn suspended, and then on the 9th of January in 2014, 7 people were arrested just down the road from my house, planning to murder me. So they were planning to take me out. Now, that took my eye off this ball completely. I was more interested in focusing on other issues than a allegedly corrupt police official at Germiston organized crime. However, a few months after this, I was informed that he'd actually left the police. And I therefore decided not to take the matter any further. Because where do you stop? I'm a one-man band. I've got 1 or 2 staff working for me, but all this type of work I'm doing on my own. And I had much bigger fish to fry. So I wish I had pursued it further, but I didn't. So it is what it is.
Thank you, Commissioner Khumalo. Then my question, I think it's close to what Commissioner Khumalo is placed before you. At 1.3.15, 1.3.15, 15, at page 10.
Yes.
You then, having expressed yourself in the terms that you have, you say Colonel Steyn inexplicably managed to avoid being charged criminally or even disciplined by SAPS in relation to this misconduct. My question is, what is the misconduct that you complain of specifically here? Is it receiving that loan? Is that what you consider to be the misconduct?
If one looks at Section 3 of Act 12 of 2004, it describes in some detail what gratification is. And gratification is also classed as a quote-unquote loan. So I was satisfied that this was a breach of Act 12 of 2004. However, given the serious volume of work on my plate at the time, I neglected to pursue it any further. But the reality is, if I hadn't have seen him testify, and somebody sent me a picture, by the way, they said, look, the guy that you thought had been dismissed, he's not dismissed, he's still working in the police, he's just moved to the West Rand from the East Rand. I was shocked. The first thing I did was pick up the phone and phone Advocate Chaskuson. I said, listen, that witness you just had on your stand, you need to know about him. And I sent him the necessary documentation. And that's why I thought it would be best to include this in my evidence, Commissioners. I'm sorry. But I just felt, wow, in that moment in time in my life, he presented me with a lot of problems. When a friend phones me and tells me that they want to shoot them because he's got my cell phone records, of course, Radovan Krejcir was in prison. So I just kind of lost interest in the matter. I should have pushed it further forward. Thank you.
Now, my question was trying to understand what is the misconduct you complain of. You say you call it potential gratification. It's just that your statement doesn't highlight gratification for what, and neither does your Annexure M, being the email you addressed to Sergeant Sitole and
So
Dibia.
if you look at the emails that I sent, I make it clear that it's gratification. I don't necessarily reference Section 3 and what...
No, that's, I'm happy with that.
Okay.
But then if you just perhaps shed some light, gratification in exchange of? He was being paid gratification in exchange for what?
So...
You don't set it out in your statement, it's not in your letter of complaint.
The commissioners would bear with me on this one because I lecture on the subject.
Please don't.
But there doesn't have to be a quid pro quo.
Okay.
There can be what's described as a generally corrupt relationship. And if one looks as an example, the state versus J. Celebi, that's exactly what the trial judge found, that there wasn't a quid pro quo, but there was a generally corrupt relationship. So I'm not in a position to say what the quid pro quo was. But I'm satisfied that there was a generally corrupt relationship. I don't believe that he was paid 400,000 rand for my cell phone records. I think that was just part of the generally corrupt relationship. That's my understanding.
Would it not be a generally corrupt relationship in the sense that there isn't what you get now is not necessarily for something specific. You may get something here, something there, something there. All of those being a gratification. You from your side may also do something there, something there, something there, which is not necessarily related to something that you specifically received for what you are doing. So it's general in that sense. When the corruptor thinks of giving you something, they give it to you.
Correct.
But they expect that at one point or another, you will also do something. So there isn't any correlation between what you get and what you do.
Yes.
You do as and when you feel, let me do something here. And you are given something, not necessarily in relation to something that you are doing now or are to do now or shortly thereafter. But you get it on the understanding that at some point you may have to do something. So it's generally...
I 100% agree
Yes.
with you, Commissioner.
Yes. But I thought you were saying that doesn't necessarily have to be gratification.
So, Commissioner, what I'm saying is, if there's a generally corrupt relationship, you can't pinpoint directly exactly what was done for the 400,000 rand. I remember a few years ago doing an investigation in respect of wildlife permits that were being issued to people that were buying and selling registered game. And the person, I'm not going to mention his name, the person that was issuing the wildlife permits would drag his feet in issuing the permits. It would take a long time to issue the permits. And then one day, the game farmer would phone him and say, listen, I've rounded up these wildebeest. I need to move them. I need the permit urgently. And he said, no, man, I can't come because I'm at the bank. I'm trying to get a loan. Oh, well, listen, we'll give you a loan, but we need you here now to issue the permit. That's how it starts. And it starts like that. So I don't know what took place between Colonel Steyn and Radovan Kretje or Cyril Beaker that resulted in the 408,000 rand loan. If it was a loan, I believe it was just a payment that was used to pay off his bond. And as a result of that payment, he would have provided who knows what services.
Thank you, Chair.
Can I just check this? Mr. Sullivan, about this topic, you have at page 210 that letter that you sent.
Sorry, which page?
210. 210. And that's your Annexure K.
Yes.
That letter there, it speaks to the loan or the alleged loan. Is there anything else that you communicated with whether General Sibia or Dramat?
So what I've done...
Other than
Yes,
this
Commissioner. What I've done, when I've sent this email, it's a email. If you have a look at the top of the email, underneath who it's sent to, it says subject, FW, your client, Radovan Kretje. FW means it's forwarded. So then you look over the next page, which is 211, and that deals with my allegations against Radovan Kretje and Colonel Steyn. So I'm actually forwarding those allegations that I've made.
Okay, maybe my more direct question is, did you communicate to General Sibia or General Dramat the complaint about access to your call information?
Can I just refer you to Page 211.
Yes.
Blah, 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 blah.
This is
One, two,
the
three,
letter.
Fourth paragraph.
This is
It
the
says,
letter to the attorneys.
I can now prove that Steyn supplied Kretcher with my cellular phone records, thereby further putting my life at risk. So that's the message I'm trying to get through. And that's what I'm trying to share with General Sabia and General Dramat.
Can you please read that from the beginning? At the tail end, you spoke at the same time with Commissioner Baloyi. Can you read
Okay,
that? Yeah.
sorry, Commissioner. So in the email, which I've sent to Radovan Kretsch's lawyers, and it's a very tongue-in-cheek, I'm demanding 5 million rand. You know, the purpose of that email is to let Radovan Kretscher know, by the way, at this stage, he's been arrested. He was arrested, I think, the day before this email was sent. It was all happening around the same time. And I thought he would get out of jail on bail, but he never got bail. So I've sent this and I said, I'm giving notice of my intention to sue your client. Of course I didn't sue him. But I explain in detail, I can now prove that Steyn supplied Kretscher with my cellular phone records. And I talk about Radovan Kretscher having corrupted Steyn. So I have now forwarded this email. If you look at the heading of the email, it says your client Radovan Kretscher. If you look at the heading of the mail, the subject line to General Sabia and General Dramat, it's forwarded your client Radovan Kretscher. So it's including that. The two are meant to be read together. And that's the point I'm trying to make. That here you have a policeman who's a colonel in the police, and look at what he's up to. That was the point I'm trying to make. Thank you, Commissioner.
Thank you.
And before we, if I may, before we leave that particular letter that you wrote to the attorneys, that paragraph, was it paragraph 4? You read into the record, I can now prove that Steyn supplied Kretscher with my cellular phone records, thereby further putting my life at risk. Did you ever provide General Sibia and or Dramat with the evidence that you say you have, that you know that can prove that Steyn supplied Kretscher with your cellular phone records?
No, Commissioners, I didn't.
Okay.
So what I'm doing here is I'm bluffing Radovan Kretscher's lawyers. I'm making them think I can prove it.
Okay.
Because I want them to think I've got the evidence. But the reality is I didn't have the evidence. All I had was a phone call and the emails that I had from Vodacom saying these were the 3 case numbers.
Yes.
So I wanted to, it was a case of joining the dots. The evidence would have only been obtained if I could get those Section 205 applications.
Understood. I'm with you. Thank you. If we then turn to page 11, you start a new topic.
Please continue.
Thank you, Chair. I see it's 3:45. There are only, besides the topic we're about to open, 2 other topics for Mr. Sullivan to deal with, and I think it's possible to complete today. If that is the decision that we set beyond 4 to complete his testimony, may I then call for a comfort break, perhaps now, but whatever time the Chair decides. Then when we resume, we take his statement to the end.
Let's adjourn and resume at 4 p.m.
It is 15:59. Please make sure that your devices are off. We are ready to resume. Thank you.
Thank you, Chair. Mr. Sullivan, if we could now turn to your page 11, please switch on your mics, both of them, the microphones. Thank you. We are now at your page 11, at item 1.4, and you have headed this Major General Feroz Khan.
Yes.
You deal with that over the next 2 pages. So if you could highlight for the commissioners the key aspects of this subtopic.
Yeah, if I can suggest that we start with Annexure M.
That will be page 216.
Page 216.
Yes.
Annexure M, Commissioners, is an email that I sent to the then Commissioner of Police, Commissioner Sitoli. Kekla Sitoli was the Commissioner of Police in May 2021. And I copied Lieutenant General Lebea, who at that stage was the head of DPCI. And my email references a tip-off that we had received at Forensics for Justice. So just to be clear, Forensics for Justice has an online tip-off portal, and it also has a telephonic tip-off portal. So people can phone anonymously, and the number is 0800 118 118. And we occasionally get these messages through. And a message came through, and it was a demand to speak to me. And I phoned the person back, and he insisted on providing this information. So what we do, we often get tip-offs, and the information doesn't check out. It doesn't look like something that's genuine. Or sometimes what happens is you'll get a captain who's in dispute with a general, or a colonel who's in dispute with a general, and they'll make spurious complaints. And when we get these tip-offs, before we do anything, we look at the background of it to see if there is anything there. Otherwise, what might be happening is we might be aiding and abetting malicious tip-offs against senior officers. But when we received this tip-off, I met with the person concerned, and the information that was given on the tip-off is listed there. And I'll just read it out quickly on page 216. 1, is involved in facilitating drug trafficking with Nassif Modak of the Western Cape. Well, we know that Nassif Modak of the Western Cape is now in prison. 2, is involved in chop shops and the selling of the products thereof. And now chop shop is a colloquial term meaning places where you dismantle stolen cars into component parts and sell the component parts. He's involved in money laundering for criminals in the underworld. 4, he protects certain criminals, notably Mr. Pregi Padeachi, who is a close friend of ex-Deputy National Commissioner Vinesh Kumar Munu, who is currently alleged to be involved in illicit tobacco trade. And 5, he has no security clearance and would not get security clearance because of his covert criminal activities and questionable business activities. Now, these are allegations. They're not factually sound, but they're allegations. Now, when we got the allegations, we carry out some background checks, as I've mentioned. And in this case, what we did was we decided to have a look at General Khan. So attached to the email that we sent was the document, which is now pages 218, 219, 220, 221, 220, right up until, well, it's all these pages, right up until page 237. Because pages 218 to 224 is our research, it's the research we've done. But when the person gave me the tip-off, the person supplied me with the pages 225 to 237 as what that person considered to be substantiating the allegations. And it's not our position in life to make any findings about these sort of things. So when we get these type of allegations, what we do is we raise it. And the only place to raise such an important matter as this is with the National Commissioner. So we attach all these documents. As I've mentioned, Commissioners, pages 218 to 224 is our own research. And from our own research, we were able to see that at that moment in time, remember we're going back to 2021, General Khan was an active director of 10 companies. Now, when we look at some of those companies, which we obviously did some background checks on, we were able to establish that some of the companies were involved in the spare parts business of motor vehicles. And you can see a couple of them there. One is called Spares Oasis. We were able to trace the premises where spare parts for motor cars are being sold from. Another one is called Magic Motor Spares. So when you look at all this, and by the way, there's a PTY called Spares Oasis, and there's also a CC called Spares Oasis. So we take all this information, and then we look at the lifestyle of the individual concerned. And gave the indication that this was not a person living on a Major General's salary. It was a lifestyle of a person in a much more affluent position. So all we did was simply supply the information and then say, there you are, that's it. We leave you to get on with it. And it's not our job then to go knocking on the door and saying, hey, what have you done about this? What have you done about that? Because our function is just to supply the information. And that's what we did. And that's made clear in my statement on page 11. And in my email, I think I've said, we find it should be impossible for a full-time Major General in the police to be moonlighting as a director of 10 businesses. And at least 2 of those businesses indicate a trade in spare car parts, an activity diametrically opposed to the work of crime intelligence, given the high levels of vehicle crime in Gauteng. So we're just making the point. That's it. And we left it at that.
Okay. You then firstly, did you ever receive a response to your complaint?
No.
You deal with another annexure at paragraph 1.4.2.
Before you do that, Mr. O'Sullivan, I'm looking at your page 218 in that big bundle.
Page 218, yes.
Yes, you've got that list of properties there. I just want to understand, well, it starts at 218 and it goes to 219. So you've got a list of properties and then you've got dates. So if we start at 218, the first property has got a purchase date, right?
Yes.
And then you go to 219.
So what 218 shows 2 properties, and on 219, so when you're doing the search, if you click with your mouse where it says title deed number, it generates the pattern that you see.
The reported
in
219.
So
Okay.
it's giving you an explanation of where that property is and what the purchase price was and whether there's a bond and the transfer document number and so on. So that's the information that you would gain from that. And then,
Yes.
of course, you're able to get the address. And as you see, the one is based in Houghton Estate.
Yes.
And
Let me ask you my question. It's about the dates that I wanted to ask. What is the relationship between the dates in the first box with the heading properties and then the dates in the box with the heading addresses? There's a different...
Oh, yes.
You
So
see
what happens is every time any individual applies for credit or opens an account or anything of that nature where somebody does a credit check, when a person does a credit check on an individual, they list the data that that person supplies when he does a credit check. So you would quite often end up with a situation where here, for example, where it says addresses, that date would relate to when that person supplied that address to either a credit provider or an account provider.
Okay. Thank you.
Thank you, Commissioner Baloy. At paragraph 1.4.2, still at your page 11, you introduce an annexure N.
Yep.
Can you deal with the contents of your paragraph 1.4.2 and perhaps in so doing, place into context how you obtain that annexure N and under what circumstances?
Yes.
Yes,
Thank
please.
you, Commissioner. So when I was preparing my evidence for the Commission, during that process, I had to engage in, I suppose, a toing and froing process with Advocate Chaskelson, where I would be drafting certain things. And I said to him, oh, by the way, you know, this is what happened insofar as Major General Khan is concerned. And he said, did you ever see a letter from Ian Levitt, attorneys, complaining about you? And I said, no, I've never seen such a letter. He said, well, would you be interested to know there is such a letter? And Advocate Chaskelson forwarded this letter to me, and I was quite gobsmacked to see it. Because here I am making a complaint by way of a tip-off, and the information that we've supplied with that tip-off. And I supplied that complaint in, let me have a look at the date.
24th of May 2021.
24th of May. So I supplied that tip-off on the 24th of May. And here we are 30 days later, or 31 days later, a month later, on the 24th of June, with this complaint coming through from Ian Levitt addressed to General Sitoli. And it's coincidental that my email is addressed to General Sitoli. Now, General Sitoli never came back to me about my complaint.
And your annexure N starts at 238. That is then the letter that you say was written, addressed to the National Commissioner.
Yes.
By General Khan's attorneys.
Yes, and I've analysed this letter, and my problem with it, apart from complaining about me highlighting alleged unethical conduct on his part, the lawyer doesn't address any of the allegations whatsoever. No once does he say my client has done nothing wrong. The whole thing is about complaining about Paul O'Sullivan.
Yes. And at page 239, the same document overleaf, this letter advises the National Commissioner that a meeting subsequently took place between their client, I take it Mr. Khan, and yourself.
Yes.
Can you deal with the contents of that first paragraph?
Yes.
That suggests that a solution was reached.
So, thank you. Commissioners, you have to read paragraphs 4 and 5 together because they belong together.
Yes.
In paragraph 4, he makes the statement that he came to see me on the 15th of June, 2021. It could be correct. I can't remember because I can't remember back that far. But I do remember him coming to see me. And I was quite flabbergasted when he came to see me because when he sat in my boardroom, he said, "You've made a complaint against me." I said, "No, I haven't. I'm hardly going to admit that I've laid a complaint against him, because if I say to him, yes, I've made a complaint, here's a copy of it, I may be guilty of the offence of defeating the ends of justice." So I decide, no, I'm just going to deny it. And then he says in this paragraph that at this meeting, I offered to confirm under oath that I hadn't made a complaint against him. Well, I just want to place on record that I never made such an offer. However, if we go on to paragraph 5 of the same letter, the lawyer says, "Pursuant to the meeting, our client made further inquiries and reliably ascertained that Sullivan," they obviously mean O'Sullivan, "was not being truthful, and that in fact not only had Sullivan laid criminal charges with the DPCI, but that Sullivan had accessed our client's personal information in doing so, and in contravention of the Protection of Personal Information Act, POPI." And as I've pointed out earlier, we can access personal information, but not on an arbitrary basis. You can only do it if you're investigating a potential fraud, or for fraud prevention, or for corruption prevention, that sort of thing. So you don't just pick a person at random and say, "Oh, let's dig into this person." There has to be some probable cause, shall we say. So the tip-off was what made us do the look at this situation, and then we supplied the information. So quite clearly, since I'd sent that email to General Sitoli with a copy to General Libia, I've not shared it with anybody else. So either somebody at their office or they themselves have shared that information with General Khan. So I've now got him coming to my office demanding to know why I've laid a complaint against him. So I've had to deal with that issue. But I just denied it. I said, "No, I didn't lay a complaint against you."
Did you ever pursue either General Libea or General Sitole regarding your complaint to establish what had become of it?
So as I mentioned earlier to the commissioners, if I had to pursue every single tip-off that comes through our office to the nth degree, in other words, to keep knocking on the door, well, we're eventually going to become a nuisance to somebody. We receive the information, we validate it, and we pass it on. We package it and we pass it on. That's all we do. It's not our job to investigate it. So we just look at it, pass it on, and then we believe it's up to the police. And in this case, it was up to either General Sitoli or General Libia to look into it. But as I've said in my statement, I didn't hear from them again. So I'm assuming they didn't look into it.
In your statement, page 12, paragraph 1.4.4, you then introduce Annexure P, which would be your correspondence with General Masemula of 31st July 2023.
Yes.
And I understand from that communication that you shared the same Annexure M that you had originally written to General Sitole.
Yes.
With General Masemula. You deal with those issues at your paragraph 1.4.4.
Yes. So what happened there, Commissioners, on the 30th of July, 2023, which is now 2 years after I've laid this formal complaint with General Sitoli. By this stage, the Commissioner of Police is now General Masemola. So on the 30th of July, I look at News 24, and there's this scandalous article, which is attached as Annexure O.
That's at page 241.
241, where it refers to top cop attending EFF gala, a shameful, offensive slap in the face of South Africans. And it talks about General Khan and it talks about the fact that his ticket for General Khan at this EFF gala dinner had been paid for by, shall we say, associates of General Khan, who were allegedly involved in the illicit tobacco trade. So I see this, and I think, wow, this is not good. It's 2 years since I've sent a formal complaint through to General Sitoli and General Libya. Now, I decide I'm not going to engage with General Libya again because I've already engaged with him and he's done nothing. So I write to the new, or then relatively new, Commissioner of Police, which is General Masemola.
Yes.
On the 31st of July, which is the day after I've read this article. And I say, dear General Masemola, it's most disheartening to read in the media about how rotten crime intelligence is. Police management know about this man Feroz Khan, but what is going to be done about it? And by the way, when I send this email, I attach to it, so I'm forwarding the original email that I've sent 2 years earlier. And I said it will take someone explaining to understand how this man can jet around the country in a jet owned by a tobacco smuggling kingpin, Syed. Of course, I could have used the word alleged, but I didn't. And also drive around in Lamborghinis. I said, does it need for him to be caught with a smoking gun for the management to get rid of him? And when I talk about management commissioners, I'm talking about management of the police. And then I say, I'm copying the editor of News 24, as I believe the people of South Africa have a right to know what's been going on. And then I say, I finish the email up with, although General Sitoli did not bother to respond to my mail in May 2021, perhaps you will be able to do so.
Did you receive a response to this communication, and if so, what was, in summary, the response?
No, Commissioners, no response whatsoever. And by that stage, I think it became the order of the day that any such communications were just ignored. So that didn't stop me from making the communications, because later on, when we have a commission of inquiry like this, I can show, but hang on a minute, this is not the first time these things have cropped out of the woodwork. Here we've got the evidence that I've been continually supplying information and evidence, and nothing has been done about it. And that's why you're going to find later in my affidavit, I make it clear that actually police management does not take action against senior police officials unless they have an agenda or motive for doing so. And that is part of the problem that we have with the police service today.
You don't say in your statement, but besides the newspaper articles and the reports you filed following whatever investigations you did around General Khan's companies, was there any evidence that you provided to either General Masemola, General Libya, or General Sitole that constitutes evidence to support the allegations you make in your previous communication to them of May 2021? Or is it what you have shared with the Commission now that you made available to these generals?
I was not able to supply any prima facie evidence. If I had prima facie evidence, Commissioners, apart from notifying the management of the police, I would have opened a criminal docket. But you cannot open a criminal docket based on a hypothesis. So what we would have expected to do as Forensics for Justice, we expected the management of the police to take this and look at it.
Yes.
But unfortunately, nothing was done.
Noted. Is there anything else on that subtopic you would like to highlight, because you start a new one at your page 13?
No, I think we've covered that in sufficient detail.
Okay. Then if we turn to page 13 at paragraph 1.5, you now introduce a different topic. You headed the erstwhile Acting Commissioner Lieutenant General Pahlane. You deal quite extensively with this matter. If you could briefly then address yourself to it.
Yes.
And as you do so, because at your paragraph 1.5.3, you introduced the DPCI judge report, which is your annexure Q. If you could just highlight the relevance of those findings in that report to the terms of reference of the commission. Thank you.
So, what I'm trying to get across here, commissioners, is that if you have an entity such as Forensics for Justice, which at the end of the day, it's a not-for-profit organization or charity, whatever you want to call it, the reality is that we are not out there to conduct ourselves in a malicious manner. We're out there to help bring accountability specifically in the criminal justice system. So the purpose of this section of my evidence is to show that if you step out and expose corruption within the criminal justice system, you actually become a target yourself. And that's exactly what happened here. And if I can place on record that in respect of General Pahlane, that between 2015 and 2017, I carried out extensive investigations and lodged various criminal complaints against General Pahlane with IPID. I supplied copies of my criminal complaint to then Deputy President of South Africa, now President Cyril Ramaphosa. As a result of the complaints I made against General Pahlane, I was singled out for unlawful action by corrupt police officials at the instance of both General Pahlane and other senior officers. The crimes against me included multiple arrests, multiple raids on my home and offices, kidnapping, torture, unlawful imprisonment, and multiple attempts at murder by proxy. And I can go into a lot of detail on that, but to save time, I'm not going to. But we had a situation where the attempts to murder me were being instigated by senior police officials. I was unlawfully arrested and detained over 2 years later for using my Irish passport. The reason I used my Irish passport was because at the time Radovan Krejcir wasn't in jail, but he had cops on his payroll and they were waiting for me to come back into South Africa so they could arrange for me to be murdered. So what I did was I slipped in on my Irish passport instead of my South African passport. And 2 years later, I get arrested for that because that's all they could find to arrest me on. And they detained me for 4 days. We talk about General Pahlane. The evidence will show that he's currently on trial, on various trials, and the sum total of the corrupt contracts exceeds 500 million rand. Now, those trials are ongoing. So, in 2016, as a result of all this unlawful conduct against myself, which was coming from DPCI, and by that stage, I'm saying DPCI was captured and the National Prosecuting Authority was captured. As a result of this unlawful conduct, I laid a formal complaint with the judge for they call him the DPCI judge. He was a retired judge. And I laid a formal complaint comprising 3 lever arch files. And that complaint was laid in 2016, towards the end of 2016. On the 6th of October 2022, the judge released this report.
Sorry. I think paragraph 1.5.3, the last line, an amendment should be made there. It says you laid your complaint in July 2026.
Thank you. It should be 2016.
Thank you.
That's a typo for which I apologize. So, in fact, I laid the complaint in July 2016, and it comprised of 3 lever arch files with all the evidence. And then I left the DPCI judge to get on with it. And the DPCI judge issued a report, which is contained as Annexure Q at 246. Now, that's a very lengthy report, Commissioners. So what I've done, on page 14, I've extracted the relevant sections of the report, and I'd like to read it into the record halfway down page 14, and it continues on page 15, and it finishes at the top of page 16, so it's only about 2 or 3 minutes of reading. And the DPCI judge made the following findings against Major General Mokateri. In respect of Mr. O'Sullivan's arrest and the manner in which it was carried out at OR Tambo International Airport on 01 April 2016 in the presence of his children, needlessly detained for several days for what is a minor infraction of having allegedly contravened Section 26B of the South African Citizens number B803/2016 Kempton Park, for which he was acquitted in terms of Section 174 of the Criminal Procedures Act. Major General Mokateri is found guilty of having seriously and unlawfully infringed the rights of Mr. O'Sullivan as contemplated in Section 17L of the SAPS Act. As far as the cold cases against
Mr. O'Sullivan, here? Yes. Why Mr. General Mokateri? Is it because he's the one that effected the arrest?
So,
was he the complaint? What happened?
No, Commissioner. General Mokateri had been, and I'll be able to prove this, it's not just an allegation, General Mokateri had been unlawfully appointed as the head of DPCI in Gauteng during the state capture process. So you had General Ntlemeza. I'd opened a case against General Ntlemeza before this, by the way. I'd opened a case against General Ntlemeza. I'd opened a case against Lieutenant General Pashlani, who was the acting Commissioner of Police. And I'd opened a case against General Mokateri. So Mokateri was the senior person who led the group of about 30 police officials who targeted me and Forensics for Justice and the staff that worked for me. So there was, as you will see, there was a campaign over several years against us.
Thank you.
Shall I carry on? As far as the cold cases against Mr. O'Sullivan that Major General Mokateri unearthed and reinvestigated are concerned, it's certainly permissible for Major General to have done so. What he has made himself guilty of is falsely claim under oath, as the DPCI judge observes in para 26 above this report, paragraph 61. One has to be extremely gullible to accord any credence to Mokateri's averment that pursuant to O'Sullivan's arrest on 01 April 2016 at OR Tambo International Airport, all the complainants in the cold cases magically came out of the woodwork and urged that charges they laid against O'Sullivan years before be resuscitated or reopened. Such coincidence defies credulity, and I reject this explanation as a figment of his fertile imagination. A conspectus of the facts, circumstances strongly mitigate against it. All 9 reinvestigated cases proved to have been moribund, and none of them survived as far as could be determined. Now, Commissioners, if I can just stop there and explain to you what those cases related to, those 9 moribund cases. Apart from running Forensics for Justice, I have other business activities. I run a property company and I run a forensic practice. And the forensic practice, we carry out forensic investigations for corporations. So if fraud has been committed or corruption has been committed within a corporation, they'll engage our services to carry out an investigation. And quite often, it would entail us then assisting that client to open a criminal docket for fraud or theft or corruption or whatever the case may be. And in the criminal justice system today, we have a situation where quite often, to distract attention away from their own criminal activity, you get the suspects in these cases opening cases against the people who are investigating them. It goes on all the time. And I would say probably over 200-300 investigations that we've carried out. There's probably been 10 or 12 where the suspects have opened cases against us. And those cases have got no legs at all. It's just a distraction. So I just wanted to explain that. Then the DPCI judge goes on to say, it is common cause that the relationship between O'Sullivan and Mokateri was and remains strained, if not acrimonious. I am acutely alive to the fact that Mokateri may have harbored an ulterior motive for reopening the aforesaid cold cases. Then he goes on a bit further. However, I'm satisfied that the reinvestigation of the cases was meant to and did harass O'Sullivan. It was designed to have a chilling effect on his forensic investigations and to fight corruption. Sometimes it appears he acted unconventionally. That's me they're talking about. But so far as the DPCI judge could discern, not unlawfully. Well, of course we act unconventionally. And that's why we have the success ratio that we have, because we step above and beyond what normal people would do. Then he goes on to say, at paragraph 63, which is on page 15, to put Mr. O'Sullivan to such unwarranted great expense to defend the unmeritorious cases was prejudicial to him and seriously and wrongfully infringed his constitutional rights as contemplated in section 17L of the SAPS Act. Then he says at 64, the failure by Mokateri to obtain a security clearance. Now this is the crux of the issue, Commissioners. This is the most important part of this whole story. The failure by Mokateri to obtain a security clearance for almost 3 years is unlawful and a transgression of section 17E of the South African Police Service Act and section 2A of the National Strategic Intelligence Act. Mokateri disgracefully tried to shield behind his employer. However, he had a concomitant duty and responsibility to obtain the clearance. In addition, his appointment set out in paragraph 44.2 above was subject to a security clearance of top secret. And I need to pause there to mention, Commissioners, the law is crystal clear. You cannot be appointed as a provincial commissioner of DPCI if you don't have top secret security clearance. He never had it. And then he says, nevertheless, no direct connection can be made or line drawn between the Mokateri's spurious appointment as provincial head of the Hawks and the woeful treatment meted out to O'Sullivan. Be that as it may, he should never have been appointed to such a lofty position. Least of all, he should not have been given a permanent contract of appointment under the sketched prevailing circumstances. Now, Commissioners, at the end of the report, he makes a conclusion and he recommends to the Commissioner of Police, General Masemola, that Major General Mokateri should be dealt with. And what's interesting here, Commissioners, is that Major General Mokateri was the provincial head of DPCI. Now, DPCI, in terms of the Glenister judgment, is handled in terms of Section 17 of the Police Service Act. So it's a separate section of the police service. It's supposed to be separate. And if you're appointed as provincial head of DPCI, and then you're found wanting and you don't have security clearance, what happened in this case? Instead of him being dismissed, he was just moved sideways into the police service from DPCI. And I wasn't happy about that. In fact, I was quite livid. And I continuously wrote to General Masemola and I requested him, why hasn't this person been dismissed? To cut a long story short, he was eventually dismissed, but not to do with the DPCI judge's report, to do with another matter completely. So I just wanted to record those facts, that General Masemola did not lift a finger to deal with the DPCI judge report, which report was issued in 2022. And General Mokoteri only finally left the service towards the end of 2024, which means he sat on the payroll, the taxpayers' payroll, for a further 2 years, twiddling his thumbs. He wasn't working.
Mr. Sullivan, just a small issue. Your paragraph numbers where you quote the DPCI judge's report.
64, did you say?
Yes. They are incorrect. Sorry, on page 15 of your statement, at least in two respects, you seem to have quoted the unnumbered quotations, but you've given them paragraph numbers. So your paragraph 61 on page 15 in the judge's report is just an unnumbered quotation.
Let me just have a look, sorry.
If you go to page 319 of the annexures, it's just two paragraphs that we need to correct.
I'm just going to have a quick look here. 64, yeah. So it would appear to me, if I can beg for your forgiveness, so what's happened is I've created this on Word,
Yes.
and I've typed it in, and sometimes Word changes the paragraph numbers without your permission. And I think that's what's happened here.
Yes.
So for the purpose of correctness, we probably need to say...
So this is what we will do. Let me assist you. What you have numbered paragraph 61 on page 15 is an unnumbered paragraph in the judge's report. It's just a quotation of the earlier evidence on paragraph 26.
Yep.
So that 61 must go out.
Yep.
Which means what you have as 62
becomes
will
61.
then be 61.
Yep, 63
And then
becomes 62.
What you have as 63, that's
Yep.
another
Yep.
quotation, so we will have to correct that. And then what you have as 64, which says the failure, will be 63 according to the report you see on page 320.
Yep.
Yes, and then what you have as 65 will then be 64, the paragraph that starts with nevertheless.
I have it.
Yes,
Thank you.
thank you.
Thank you, Commissioner Khumalo. My sense is that you have covered everything you have set out in your statement regarding General Patlane, your complaint regarding General Patlane and the DPCI judge report. Is there anything else that you conclude by saying, notwithstanding the referral of that report to General Masemola, General Masemola failed to take action?
Yep.
If I understood the report correctly, the action General Masemola was invited to take was against Major General Prince Mukotedi and not against General Patlane, was it? If you look at your summary at page 16,
your page number, sorry?
Your summary at page 16, paragraph 1.5.6, you quote the conclusion reached by the judge.
Fanny Masemola.
You say this, and it quotes under capital A in parentheses, this is an appropriate DPCI judge's report deserving attention of the National Commission
Correct.
of Police.
This is the conclusion of the DPCI judge's report.
Yes.
If you look towards the end, I should give you the page number there.
We'll locate the page number for you. The point I'm making is that was a conclusion for the purposes of taking action against Major General Mukotedi and not General Patlane. Am I reading it correctly?
I don't mention General Pashlani.
Yes, I'm saying the topic deals with General Pashani. The DPCI judge's report makes findings, is in large part concerning the conduct of Major General Mukotedi, and makes findings as you have tabulated them at page 14.
That's to be seen on page 326
Yes.
of the evidence. It refers to deserving the attention of National Commissioner General Masemola.
Yes. And I'm saying what deserves General Masemola's attention is what you have set out at page 14
Yep.
in the boxes. The following findings against Major General Mukotedi are made. It's
Correct.
those findings that are brought to the attention of General Masemola,
Correct.
and General Masemola is called upon to take appropriate steps.
Which is what should have happened.
Yeah, and the only point I sought to make was that this is not about General Pashlani.
No, it's nothing to do with General Pashlani.
I fully that clarity.
The only thing it's to do about General Pashlani is that all of this conduct happened against me
Yes.
because I opened a criminal complaint against General Pashlani. So everything that's listed here happened against me and others that were connected to me. But the driving force, according to the DPCI judge report, was General Mokotedi. It doesn't say that in the report, but we know it for a fact. General Nklemeza and General Pashlani.
Okay, understood. Yeah, I just wanted to make that clarity.
Yeah.
And are you aware of any steps then that General Masemola took against General Mukotedi?
None at all.
And at your paragraph 1.5.8, you confirm that General Masemola, as you say, quote unquote, did not lift a finger to implement the recommendations of the DPCI judge.
So, sorry, I didn't hear it. 1.5.7, I've said, the relevance of the conclusion in the DPCI judge's report mentioned above is not lost on me and should not be lost on the Commission. General Mokotedi was never, from the date of his unlawful appointment, lawfully in his post, because he never had top secret clearance or secret clearance. Instead of dismissing him, General Abaya unlawfully agreed with General Masemola that it could simply be moved from DPCI to SAPS. So that's moving the problem instead of removing the problem. He was moved to the division known as Inspectorate, which functions or is supposed to function as the internal standards monitoring the police. It can be likened to hiring mice to guard the cheese, because here you have a situation where General Mokotedi has now been moved out of DPCI, where he can't be because he doesn't have top secret clearance. Plus the DPCI judge has said he must be dealt with, and he's moved into the police. They have nowhere else to put him, so they've put him in the Inspectorate. Now the Inspectorate is quite commonly known as the departure lounge in the police. If they haven't got work for a senior person, they stick them in the Inspectorate, and that's often where these generals end up before they find another job somewhere. So that's why it's colloquially referred to as the departure lounge.
Thank you. That would then lead us to your paragraph 1.5.9 at page 17, but you introduced a new topic there.
Yes.
And you heard that General Mkwanazi's unlawful assistance to General Pashani.
Yes.
Before you deal with the contents of that paragraph, you reference an affidavit by a Mr. Humbulani Kuba, which you invite to be tested. Presumably, the invitation is extended to the Commission.
Yes.
Commissioners, that affidavit is not part of your bundle. Mr. Sullivan has made a copy available, and we've got copies for you. Because of where it is referred to, we have an extra Q, which is the DPCI judge report. We propose this be the next document based on the structure of his statement, and we propose that it be marked Q1. so that at least we can associate it with paragraph 1.5.9 easily. Now, Mr. O'Sullivan will talk to this affidavit, but the commissioners will notice that the first document is a 2-page affidavit dated the 16th of January 2026, and that affidavit seeks to introduce an earlier affidavit dated October 2020, according to the narrative, but the copies you have are undated. And it is stated that this particular October 2020 affidavit was prepared for the purposes of the Zondo Commission, but it would appear to have not been either finalized and filed, or the challenges that Mr. O'Sullivan has had is to locate a signed and filed copy of the annexure to this affidavit. So that's the context of these documents. Technically, there are 2 affidavits, the latest one now of 2026, and the 2 that are attached. The difference between the 2, as I understand it, is that the one has got track changes, the second doesn't. It's a clean copy, but it's one and the same document. I hope that will assist in navigating this new annexure.
Yes.
Then, Mr. O'Sullivan, you start at, you may deal with your 1.5.9. You state that you are informed, I don't know by who, that you do not need to go into the details of the unlawful prosecutable conduct of General Mkwanazi pertaining to General Pashani, relating to the offenses I believe were committed in 2017 and 2018. It is in our engagement regarding the allegations you make there that you introduce Mr. Kumba's affidavit, which we now have marked Q1.
Yes.
So you may deal with the issues that you highlight there.
Thank you. So, Commissioners, to get the drift on this, to get an understanding of what took place here, we have to remember that I opened the case against General Pashlani, a criminal complaint. I opened that complaint in February 2016. And in that complaint, I alleged very serious corruption on the part of General Pashlani. And my docket set out chapter and verse. Remember what I said earlier, if I get a tip-off and there's no evidence, we just supply the information. In this case, it was more than a tip-off. I had evidence. And I took all that evidence and I packaged it and I opened a formal docket with IPED. But unfortunately, by that stage, IPED was captured. It was during that state capture period. And IPED was captured by virtue of the fact that 2 crime intelligence officials have been appointed to work in IPED, and they were allegedly controlling all of the investigations that IPED did. And then you had a situation where I opened my case with IPED in February 2016. And the complaint I laid was, a copy of it was supplied to General Pashlani instead of the matter being investigated. And that led to the attacks against myself and my staff. So, but what happened while all that was going on was there was a matter in the Supreme Court of Appeal, in fact, no, sorry, it was the Constitutional Court. And that was the matter of Robert McBride versus the Minister of Police. And the Constitutional Court ruled that the suspension of Robert McBride was unlawful, and it was an overreaching by the Minister of Police. And Robert McBride was given his job back, which meant that in November 2016, 10 months after I've opened this case against General Pashlani, the case suddenly came alive again. So I sat down with the people from IPID and I explained to them exactly what had gone on and the fact that for 10 months there'd been no investigation whatsoever other than supplying General Pashlani with a copy of the docket. So then what happened was IPID formed a small task team. And my understanding is that the task team was headed up by this gentleman, Hambulani Innocent Kuba. And he is currently the Limpopo director of IPID. At the time, I believe he was also the Limpopo director of IPID. But he was brought to Pretoria because they wanted somebody from outside the province to case manage my complaint against General Pashlani. And that's what Hambulani Kuba did. And he reported directly to Matthew Sissoko, who was the head of investigations at IPID. So what happened was, there were a number of legs where General Pashlani attempted to derail the investigations into him. And those legs took various forms. One of the forms, and I'll say it briefly, was the appointment of the so-called Northwest team, which was General Mabula and a whole lot of brigadiers and colonels. And their job was to try and find dirt on the IPID investigators and myself. And they were quite busy with that. In fact, I was unlawfully arrested and charged, which is part of those other cases that eventually blew away. But what happened as well during that period was we had, according to Hambulani Kuba, we had the unlawful conduct of General Mkunazi. And I would like to just explain these pages that have been given to you now. I've got page numbers 333.1, 333.2, and so on. Now, 333.1 and 333.2 is a sworn affidavit saying that, look here, I can't find the original affidavit that I submitted in 2020 to the Zondo Commission. However, what I have been able to locate are the emails from the Zondo Commission giving me my draft affidavit. And I want to say that when I attach this affidavit, everything in there is true. And therefore, as you would know, making affidavits for a commission, it's an iterative process. It's not something that you just do and you're finished. You draft and then you add a bit and then you know, it's an iterative process. And this is the evidence. If you look at page 333.8, it's an email from Garth Holly, who was one of the evidence leaders at the State Capture Commission. And he's saying, "Hi, Innocent, please consider the attached statement that I drafted based on our consultation. We need to get as much corroboration as possible. I've raised a few issues on the papers. Please get back to me." This is what Mr. Kuba has been able to find. We've been in touch with Garth Holly, and unfortunately, the State Capture Commission, as you know, is wound down, and it's not possible to find the original statement that Hambulani Kuba made. And that's why I've suggested that I believe this person could be and possibly should be, briefly, because it's not a long story he has here, it's a very short story. And if you capture his story quickly, it's basically saying that in February 2018, he got a phone call from Major General Nemathansela of Crime Intelligence. By the way, when you see all these issues, I just want to reiterate, most of these issues emanate from crime intelligence. It's always, 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 there's something to do with crime intelligence. He stated that he blah, 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 he wanted to meet with me. He provided me, on page 333.4, if we look at paragraph 10, I remained in the lobby, so he's now at a hotel somewhere in Pretoria. I remained in the lobby while we waited for the anonymous witness. So Mr. Kuba thought he was going to be meeting a witness. He was in telephonic discussion with the witness. In one of his discussions with this person, I recall him explaining that we are already seated here waiting for you. Nemeth and Shela and I had drinks, juice, while we waited for the anonymous witness. After one of his calls, this is now paragraph 11 on page 333.5, after one of his calls, Nemeth and Shela said to me that we could go now. We took the lift and went up to one of the floors. I do not recall which floor it was. When we got out of the lift, I saw Lieutenant General Mkonazi. I immediately recognized him. I had interviewed him in the rendition matter. Mkonazi asked us to switch off our cell phones and hand them to him. He took the phones and placed them in an adjacent room. Present in the meeting was General Mkonazi, Nemeth and Shela, and me. So there's 3 of them in the room. I do not recall precisely how long the meeting lasted. I imagine that it took approximately 1 to 1.5 hours. I was present in the meeting with Mkonazi and Nemeth and Shela. Mkonazi started the meeting by talking about politics. He later explained that there were 2 IPID officials who had given Section 204 statements, Nkabindi and Mshlangu. Now, we all know who Nkabindi is. It's the same Cedric Nkabindi, who was subsequently dismissed or resigned from IPID and subsequently surfaced as the Chief of Staff for the Minister of Police. And he talks about Mashlangu. Mashlangu was one of the IPID investigators. His name was Mandla Mashlangu. It doesn't say that here, but I know who it is because I knew the person. He was approached also to give a witness statement. Unfortunately, he can't testify today because after he refused to sign the witness statement, he was subsequently murdered. And then it goes on at paragraph 15. Mkonazi asked me for information that could implicate McBride in criminal wrongdoing involving Mr. Paul O'Sullivan. So the narrative, I should mention at this stage, that was being driven by General Pashlani was that I had captured IPID, that I had taken over IPID. And General Pashlani would even go on TV and refer to it as OPID. He went into Parliament on the 17th of May in 2017 and referred to IPID as being OPID. Very sarcastic. He wanted to know what they were involved in and how they were involved. He's talking about General Mkonazi asking him about myself and McBride. I explained to him that I did not spend time with McBride socially and was accordingly not in a position to provide him with details of McBride's relationships with O'Sullivan. I should emphasize that at that point, at no point did he suggest that I should lie. I pause at this stage, Commissioners, to mention the only relationship I ever had with Robert McBride was the fact that he was the head of IPID. And after he was reinstated by the Constitutional Court, I went and met with him and told him about this case against Pashlani that was gathering dust for the previous 10 months. And that's as far as it went. He goes on at paragraph 16. Mkonazi said that I would be taken care of, that I, who held the post of Chief Director, which would be at the rank of Major General in the SAPS, would be promoted to rank of Lieutenant General, which was on the same rank as him. Mkonazi indicated that both Nkabindi and Mashlangu would also be promoted into higher ranks within the SAPS because of their cooperation. He explained that one of them had not yet signed. That was, I can tell you, was Mashlangu, because we know Nkabindi had signed. When I was leaving, he said that I should think about it. He said that he was meeting with Nkabindi and Mashlangu that evening. And then he talks about going back to the office and explaining all this to Matthew Sissoko, who was his direct boss, who was waiting for me. We discussed a lot about whether it was true that these two IPID officials had turned Section 204. We got the sense that Mkunazi was trying to fish to get me to tell him what I knew. My sense was that he wanted to give me the impression that he already knew and that I should tell him, since the information would already be shared by my officials. I returned to my hotel at approximately 21:30. I went to check at the hotel room of Nkabindi. They were in the same hotel. I knocked on his door and he did not answer. I phoned Sissoko and said this might be true because Nkabindi was not there. We were staying in the same hotel called Absolute Farringdon in Hatfield. At about 2400 or 0100, I heard Nkabindi returning to his room. I told myself I was not going to sleep until he returned. We had adjacent rooms. I sent Sissoko a message via WhatsApp saying he'd just come back. Madlanga later told Sissoko that he had been approached. I think Sissoko told McBride, who called a meeting to find out if anyone was approached. Madlanga confirmed that he had been approached. He said that he'd been approached by Como. Now, Como was the crime intelligence official working in ARPID. And the two crime intelligence officials been placed by the Minister of Police into ARPID to manage investigations. In fact, how can you have crime intelligence officials working for a so-called independent body like ARPID? But what in fact happened, and I can just mention this on the record, that when Mr. McBride was reinstated to his position by the Constitutional Court, these two officials absconded from IPID and never came back. They went back to crime intelligence. And then he says, I was expecting him to include Mkunazi, but he did not mention Mkunazi. On the one occasion, he got angry with me for mentioning Mkunazi because he made it clear that he was a family friend. He did not want me to mention the name of Mkunazi. So the point I'm making, Commissioners, is that some sort of credence has to be given to this. Because here you have a situation where on the 6th of July last year, General Mkunazi calls a media briefing, a very dramatic, fantastic media briefing, where he talks about interference in investigations. In fact, according to this statement, that's exactly what he was doing in the Pashlani investigation. He was interfering with IPID and trying to get IPID members to leave IPID and give them some dirt on Robert McBride and allegedly against me as well.
Mr. Sullivan, where do we see in this affidavit that the overture or the approach by General Mkhwanazi related to the Pahlane case? Where do we see that in this affidavit?
So you cannot see that in that statement. You would have to be involved on the ground at the time, as I was, to know what was going on. And all of this was going on at the same time as the Pashlani investigation. And in my opinion, my humble opinion, the only way you're going to get to the bottom of this is either to get a detailed sworn statement from Mr. Kuba or get him to come and testify. I cannot believe it can take long for him to cover these aspects.
It may be so. It may be so that it won't take long, but I'm noting, for example, that Mr. Kuba did this two-page affidavit, the first 2 pages.
Yep.
On the 16th of January 2026, the commission was sitting. I don't know for what purpose he prepared this
My
affidavit.
understanding, Commissioner, is that it was for the ad hoc committee of Parliament.
Yes. The point I'm making is that as recent as January 2026, where he prepares an affidavit, he doesn't say anything about General Mkhwanazi approaching him to interfere as a measure to interfere in the Pahlane investigation. In fact, at paragraph 18, he says, our sense was that he was trying to fish to get me to tell him what I knew. He doesn't say about what, but he has opportunity in January to say more on these earlier affidavits, and in particular, that he felt, even if it's just I felt, he was speaking to me, or he wanted me to interfere, or he was interfering in the Patlane investigation. He doesn't say that. So my question really is, if we rely on these two affidavits, well, including the recent one, so all three, two drafts, and this latest affidavit, there isn't anything in it that speaks to the very specific topic you're speaking to, which you say this is evidence of interference.
So,
And unless I misunderstand your evidence, I thought what you're saying is this is evidence of interference.
these documents themselves would not amount to evidence on their own of the interference. They would have to be read together with the High Court cases that took place at the time, where IPID launched urgent application to stop police interference in their investigation into Pashlani. And they were successful in that they got an order that the police must not do a counter investigation. Now, I was on the ground at this moment in time, so I knew what was going on. So I knew that this related to Mandla Mashtangu, by the way, Cedric and Kabindi. If you look at this, Commissioner, you will see that he does mention that Mkonazi was fishing to see what he could find out about Robert McBride and Paul Sullivan. And my only involvement with Robert McBride at that moment in time was the Pashlani investigation. I had no other involvement. That was it, short and sweet. So it's hard to draw that conclusion, I agree with you, but I do believe it's warranted, if possible, to either get the gentleman in or have one of the investigators take a more detailed sworn statement from him.
Isn't the problem with that proposal that let me start. I can understand when you say you were on the ground, and because you were on the ground, you are able to draw connections between this approach to IPID and what you knew was happening on the ground, including that the General Patlane matter was taking life. So I can see, I'm prepared to accommodate that in your connection of the dots. That's the picture it creates. The difficulty, at least for me, is we have a statement here we have that unsigned affidavit where Mr. Kuba makes no reference to the Patlane matter. And that is compounded by that as recently as January 2026.
Yep.
He gets to prepare another affidavit that attaches the unsigned one, and he doesn't speak to...
No, exactly.
He doesn't make that allegation.
No, I fully agree with you. If I was involved in the preparation of this statement in January 2026, I would have crossed the T's and dotted the I's and made it crystal clear what it was involved in.
Yeah.
We know for a fact that Cedric and Kabindi left IPID, tried to join the police as a brigadier, and I wrote to General Satoli at the time, and I said I would bring a court application if he's appointed in the police. So we know that was the status with Cedric and Kabindi. At the end of the day, this is crying out for further, shall we say, investigation. I understand that on its own, it's not a smoking gun, but I do believe there is a smoking gun to be had here.
Thank you.
Thank you, Commissioner. I have a similar question. Looking at the same affidavit, starting from paragraph 10, what you've basically read into the record.
So what page are we on?
I'm in Annexure Q1, Kuba's affidavit that we have just tendered. I'm at page 333.4. And I say it's only at paragraph 10 that Mr. Kuba deals with the engagement with General Mkwanazi and following.
Yeah.
Now, my reading of that is that what Mr. Mkwanazi wanted is what's reflected in paragraph 15, Mkwanazi asked me for information that could implicate McBride in criminal wrongdoing involving Mr. Paul Sullivan. And if I read the document correctly, that's what seems to be the gist of the engagement between the two. Now, if we look at your statement at page 17, at paragraph 1.5.9, you speak of unlawful prosecutable conduct of General Mkwanazi pertaining to General Pahlani relating to offenses, I believe, were committed in 2017 and 2018 when General Mkwanazi was involved in unlawful attempts to prevent investigations and prosecution of General Pahlani. And then you quote this affidavit. Similarly, this affidavit doesn't help us understand the unlawful prosecutable conduct you reference, unless you suggest that General Mkwanazi inquiring from Mr. Kuba whether he has information that could implicate McBride in criminal wrongdoing involving Mr. Paul Sullivan is the unlawful prosecutable conduct. Is that?
No, so that's why I've suggested, Commissioner, in my paragraph 1.5.9,
yes.
I said I will not therefore canvass the matter. Safe to say that I feel very strongly that the evidence of Mr. Humbulani Kuba in this regard should be tested. In other words, it needs to be tested, because that's the only way you're really going to get to the bottom of the matter. I know what it is, but my knowledge is not evidence. It's just what I know. And I accept that it's not evidence.
I understand what you say. So you are inviting the commission to test and, to the extent necessary, perhaps engage with Mr. Kuba so that we can determine the unlawful prosecutable conduct of General Mkwanazi and his involvement in unlawful attempts to prevent investigations and prosecution of General Pahlani.
That's correct.
Okay, I fully understand. That then brings us to the end of that particular subtopic. And if we could then go to paragraph 1.6 at page 17.
Sorry. You have said you know this or you know about this, but your knowledge all on its own or by itself will not assist. What exactly do you mean when you say you know?
Because, Commissioner, at the time, way back then, when all this was going on, the multiple attempts at trying to derail the investigation by IPID against Pahlani was going into the public domain and making these comments that Paul O'Sullivan was taking over IPID, which of course were false comments, absolutely false. Now you have this situation going on, and you have this parallel conduct in relation to Cedric and Kabindi. Let's just park Cedric and Kabindi to one side, because at the time this took place, Cedric and Kabindi, he went across to the other side. He left IPID and he went into the Pahlani camp, and he was recruited into the Pahlani camp by General Mkwanazi. And he provided a sworn statement in a High Court case where General Pahlani launched an application to try and have the charges against him thrown out of court. And he failed. The court ruled against him. Now, that was Cedric and Kabindi that was making that sworn statement for General Pahlani. But he didn't say, by the way, I was recruited by General Mkwanazi. But if you read this, Humbulani Kuba says that General Mkwanazi tells him, listen, we've already got Cedric and Kabindi on board, and we've already got Mandla Mashlangu on board, but he said one of them hasn't signed. Well, at the time, we found out that it was Mandla Mashlangu who hadn't signed, and he refused to sign. Unfortunately, he was murdered because of it.
Do you have any idea, Mr. O'Sullivan, for what purpose this statement was made for the ad hoc committee? The short affidavit to which are attached the draft statements.
Yes, Commissioner, because I obtained this affidavit from Robert McBride. Because when this ad hoc committee was going on, you had certain parties going to the ad hoc committee and, for want of a better expression, blowing smoke up their backsides with all these false claims. And you had this situation where they called as witnesses people like Robert McBride, and they tried to impugn his character. And they did the same to me. They tried to impugn my character. But unbeknown to me, and I only found out afterwards, Robert McBride obtained this statement and tried to persuade the ad hoc committee to call Mr. Kuba as a witness, but they didn't. So that's my understanding as to how the statement was obtained.
Also, it was filed with the ad hoc committee at the instance of Mr. McBride.
That's my understanding.
But was the context there to say that General Mkhwanazi had allegedly committed unlawful prosecutable conduct? Was that the purpose for filing this statement, or was the purpose something else? Do you know?
My understanding, Commissioner, is that the ad hoc committee didn't obtain the statement. My understanding is that Robert McBride obtained the statement, and that when he obtained it, with all due respect, he didn't spend long enough cobbling it together. It could have contained a lot more detail. And this was a quick rush job that was done before his appearance at the ad hoc committee. If I was involved in doing it, it would have contained all the relevant data, but I wasn't involved, and I only found out about it later.
But what I'm saying is, I did not suggest that it was filed at the instance of the ad hoc committee, no. I'm saying, was it filed for the purpose of showing that General Mkhwanazi was allegedly guilty of unlawful prosecutable conduct?
That is correct.
Even if it was at the instance of Mr. McBride. Was that the purpose?
My understanding, Commissioner, and I don't have the minutes of when Mr. McBride testified at the ad hoc commission, but his actual words were, "This is evidence of unlawful prosecutable conduct on the part of General Mkhwanazi." And perhaps one of the researchers can find the PMG minutes of the meeting where he states that, because that in fact is what he stated. And when I heard it I didn't listen to him giving his evidence. I heard it later and somebody pointed it out to me, and I said, "Can I get a copy of that statement?" And that's what I got. That's what I
And would this have been prosecutable conduct relating to General Pahlane or yes?
That's what Robert McBride insinuated.
Wanted to, okay. All right, which I think, or rather in respect of which the statement does not seem to assist. No. And that's the point Commissioner Baloyi already took you through.
I agree with the Commissioner.
Yes, okay, all right. Yeah. Thank you.
Thank you, Chair. As I indicated, Mr. O'Sullivan, we're now at your page 17, and we start with the next subtopic, 1.6, General Mkhwanazi, Mr. Kistia, and the Louis Vuitton bags. You reference in this part of your statement Annexure R, which is to be found at page 334. That is the article. That is the newspaper article. And just to confirm on this topic, this is all you rely on. This is all the evidence you have about these supposed gifts by Mr. Kistia.
Yes. So
then if you may just quickly deal
I'm mindful of the time we're spending, so I'll try and be as prompt as I can and succinct as I can. I had knowledge of these allegations from whenever it was, 2022. And I didn't do anything about it because it's just a media article. But what happened was, after the July 2025 media conference of General Mkunazi, I started putting bits and pieces together. And one of the things I did was I instructed my attorneys in November 2026 to issue a subpoena to IDAC. And I've evidenced the subpoena as S1 and S2. S1 being the subpoena and S2 being the reply from IDAC. But the important thing for me is if you look at page 18, the reply to the subpoena sought to obtain evidence of these so-called Louis Vuitton bags. And the reply I got from IDAC to my lawyers was, quote unquote, "These are criminal matters that remain active, and IDAC cannot share any of the information and or documentation requested in paragraphs 1 to 4 of the subpoena." That's all the evidence I have. So it's not a smoking gun. You've got a newspaper article, an attempt by me to validate the newspaper article by issuing a subpoena, and IDAC's response saying, "This is a live investigation. I'm not giving you an answer to your subpoena." And commissioners, I'm saying, surely that gives the impression that there is something here. There's something going on with these Louis Vuitton bags.
Mr. Sullivan, can I ask you this question? In paragraph 1.6.2, you say this gentleman is alleged to have gifted. Do you know who makes these allegations? Do you know who the source of the allegations?
Say again, I didn't catch you.
Paragraph 1.6.2 on page 17 of your statement.
Yep.
The name of the gentleman is mentioned there, and
Mr.
you say,
Kistia.
yes, it is he's alleged to have gifted expensive
It's what's
bags.
in the article.
So you're relying on the article.
I'm relying on the article, and that's why I'm saying this is from the article. Mr. Kistia is alleged to have gifted these Louis Vuitton bags.
But you don't know who makes the allegations. You don't know who the source is.
Commissioner, if you look at the article, it doesn't give a name.
No, I'm
In
asking
fact,
you, Mr. O'Sullivan, forget about the article. I'm asking you sitting here today. Do you know who makes the allegations, or who is the source that makes the allegations?
My understanding, and I've put it here in my statement, is that it was Brigadier Ras, a female brigadier who went on the journey with them. And that's on page 18.
Where he references annexures S1 and S2, Commissioner.
Yeah. So my understanding is that Brigadier Ras was also given a Louis Vuitton bag, but when she returned to South Africa, she handed it in because she said she didn't want it, because she knew that Inbanat and Kistia either was going to be charged, or she knew that there was a corrupted relationship. Inbanat and Kistia is currently on trial with General Pashlani for corruption, involving vast sums of money, millions and millions.
I just wanted to make sure that you are not attributing to her things she did not say.
Yeah. Sorry?
Did she say that, or is that what you assume she said?
I received information that she was on that trip, and she handed the bag in. I've never spoken to her.
Okay.
Okay?
Sorry, Mr. O'Sullivan. I'm looking at what Commissioner Khumalo just referred you to in paragraph 1.6.2. Where Commissioner Khumalo just referred you to, 1.6.2, the part that says, however, I was able to later confirm the allegations from a source. It seems a female brigadier, that's the brigadier you referred to. I think you gave a name just now, or not?
Correct.
Yes.
It's on the next page.
Yes, the brigadier was on the trip to Europe and also received a bag which she then handed to IDEC. I'm comparing that with what appears in the article that you say is your basis
That
for...
doesn't appear here.
Yeah, because at page 335, here's what the article says, the third paragraph at 335. I'm reading the last sentence. The two, that is General Masemula and General Mkwanazi.
So which paragraph?
The third paragraph at page 335.
Yes.
I'm reading the second sentence, which is the last sentence of that paragraph. It says the two returned home with luxurious bags while their colleague, I assume the colleague is the brigadier, or not?
So, Commissioner, in my opinion, this story is possibly slightly wrong, because my understanding is that the person that was snubbed wasn't snubbed, but also got a Louis Vuitton bag and brought it back to South Africa and handed it in with a sworn statement.
Oh, so that part of the article is wrong.
Pardon?
So that part of the article is wrong.
Yes.
Oh, all right. I just wanted to check that because you
That's
basically...
my understanding,
Yeah.
Commissioner. Yeah.
Can I just clarify from your response, the question and response by Commissioner Kumalo, and your reference to that Brigadier Russ, your statement as it reads does not say she reported General Masemula and Mkwanazi.
It
Is
says
that-
on paragraph 1.6.2, Commissioner, it says, however, I was able to later confirm the allegations from a source.
Yes.
It seems a female brigadier was on the trip to Europe and also received the bag, which she then handed to IDAC.
Yes, but that doesn't say she reported the two generals that they received a bag.
Yeah, I could have said together with a sworn statement, but my understanding is there was also a sworn statement.
Is your evidence that the brigadier submitted a sworn statement in which she states?
My understanding, so...
Yeah, let me finish for the record.
Yeah.
I do need to finish. My question is, and I just seek to clarify what you are saying. Is your evidence that Brigadier Russ, who you say also received a Louis Vuitton bag, she declared it to IDEC, or she reported it to IDEC, and she submitted a sworn statement. Are you saying in that sworn statement, she also states that the two generals, Masemula and Mkwanazi, also received Louis Vuitton bags? Is that what you're saying?
I wish I knew, Commissioner, but when I served the subpoena, this is what I sought clarity on.
Okay, so you haven't seen her statement?
No, I haven't seen it. If I'd seen it, you'd be seeing it now too.
Okay.
Because I wouldn't keep information from you. So, to be crystal clear, this, you could say, is just pure hearsay. However, it would be hearsay if I'd have got a feedback from my subpoena that said, listen, I don't know what you're talking about, get lost. That's not what I got.
Yes.
What I got back was, these are criminal matters that remain active, and IDAC cannot share any of the information or documentation requested in paragraphs 1 to 4 of the subpoena. And
Yes.
that tells me there's something going on here. And what I also noticed, and I mentioned it in my statement, is that nowhere in the evidence that he gave, either at the ad hoc committee or at this committee, General Mkwanazi specifically state, by the way, for the record, I've never received a Louis Vuitton bag. Instead, he makes throwaway comments such as, at least my wife now knows what a Louis Vuitton bag is valued at.
Okay, I haven't seen his evidence in the ad hoc committee. He will come back. He will come back to us, and he'll speak to that. I just needed to clarify what I thought I had understood your evidence to be. Thank you.
And your source about the brigadier, was that SAP's source or not? I'm not asking for a name.
Yes, it was a SAP source.
Thank you.
Thank you, Commissioners. Mr. O'Sullivan, if we go to, you make the point at paragraph 1.6.3 regarding IDEC's response to your subpoena.
Correct.
And you suggest that their response and the manner in which it's couched, as you quote there, is what gives either credence to an allegation that there's something, what did you say? They smoke,
Yes.
I think, yeah. But I accept that. I would like us to look at your annexure R. And that is the article at page 334. At page 334, the last paragraph on that page, the article reads, and I quote, "In a case that resembles that of former top cop Jackie Silebi over a decade ago, Masemola and another former National Commissioner Mkwanazi were last week slapped with subpoenas by the investigating Directorate ID to explain why they failed to declare Louis Vuitton handbags they received from controversial Durban businessman and sub-supplier in Banatan Kistia. Apologize if I mispronounced that. So that's what the article claims, that they were served with subpoenas. So would you accept, if the article is correct in that regard, IDEC's response would also be correct in saying that these are criminal matters that remain active in IDEC, if IDEC had issued a subpoena
Thank you.
conducting an investigation?
If you look at page 338
Yes,
of my evidence bundle,
yes.
it's that page of the subpoena. It's listing 4 items. 1, all ID/IDAC communications and or subpoenas sent or served on Lieutenant General Mkwanazi and or General Fanny Masemola, asking them to, so this subpoena is based on that article. It's asking for this clarity. It's asking for any response received from IDAC. It's asking for a photograph certified as a photo of the Louis Vuitton bag currently in the evidence locker or evidence room of ID/IDAC. And finally, a certified copy of the sworn statement provided to ID/IDAC by the brigadier that attended on the overseas trip with General Mkwanazi and General Fanny Masemola, in which she explains the receipt of the Louis Vuitton bag mentioned in 3 above. So the response tends to confirm inadvertently those issues.
But I'm not taking issue with that. I accept, and I say if we accept the correctness of the article, that IDEC issued subpoenas in respect of these bags.
It would appear to be the case.
Yes, and if we accept that that is potentially the case, then the response by IDEC has got to be appropriate, that these are part of ongoing investigations, and they are not in a position to share
Correct.
the requested information with you.
Correct, which is why I decided to raise it at the Commission.
And IDEC's response doesn't imply that the investigations have established as a fact. It simply mentions that the investigations are ongoing.
Correct.
Okay, thank you. And you have testified to the fact that General Mkwanazi's response is what you believe further lends credence to the claim, where you quote him as saying, "At least my wife now knows what a Louis Vuitton bag is valued at." And that's the sum total on which, that's all you can put forward.
The point I was making, Commissioners, is that nowhere could I see him saying, by the way, for the record, I never received any Louis Vuitton bag. Instead, he gives this throwaway comment, "At least my wife now knows what a Louis Vuitton bag is worth."
Is there anything else on that subtopic that you would like us to?
Nothing at all.
Okay, then staying still at page 18, that leads us to the next subtopic at 1.7, General Mkwanazi, political pressure, and Lieutenant General Mdluli. Now, this is quite an involved subtopic. You start at paragraph 1.7.2 by summarizing Annexure T, which is the affidavit at page 336, which is the affidavit. I think my numbering is, no, not 336. I'll find the correct page for you.
345.
345, page
Yep.
345. Thank you. Now you summarize this affidavit in detail over the next couple of pages.
Over the next 4 pages.
Over the next 4 pages, and you contrast that with the papers from the Freedom Under Law application
Yes.
that was launched
Yes.
to review and overturn General Mdluli's reinstatement following his suspension, correct?
Yes.
Can we try and summarize what the key issues arising from these two
Yes. And if I-
substantive documents are?
My summary,
Just a moment,
Sorry.
can I ask that because you're going to summarize that we amend paragraph 1.7.2.11? So
Instead
on
of
page
2 to
21, that
yes.
15 May should be 2012 and not 2021. 1.7.2.11 on page 21.
yes,
Are you there?
yes, I'm there, yeah.
That 15 May date should be 2012, not 2021.
Yes.
Correct.
Well
Thank
spotted.
you, Commissioner.
Thank you.
Thank you. You may proceed, Mr. O'Sullivan.
Okay, thank you. First, I should thank the Commissioner. You know, this was typed very late at night. The essence of this can be found at paragraph 1.7.1.
If I may, I do beg your pardon.
Pardon?
I do beg your pardon for interrupting. Just to point out that your annexure T, that affidavit, General Mkhwanazi has already submitted before the commission when he testified in September. Then commissioners, for the record, is MK22. So we have dealt with that affidavit before, and maybe in a slightly more cursory fashion. So it's not new to the commissioners, this affidavit.
Okay.
They've seen it before. Thanks.
So if I can take the Commissioners to page 18 of my statement, in particular paragraph 1.7.1. So in order to go forward, we have to go back a little bit. And what I'm saying here, if we go back to the media conference of the 6th of July, 2025, there were 2 central themes of General Mkhwanazi's press conference. The one was organized crime's infiltration of the criminal justice system, and the other was political interference in the police by the Minister of Police. Those were the 2 central themes, and I think that's common cause. I've dealt with, in some detail, the examples of infiltration of the underworld into the police and the effect that has had on the police. And I've said it wasn't new. And I'm making the point here by saying, nor was political interference in the SAPS new. The irony of the latter fact is that during his period as acting National Commissioner in 2012, General Mkhwanazi himself turned a blind eye to unlawful political interference relating to the then Divisional Commissioner of Crime Intelligence, Lieutenant General Richard Mdluli. In fact, General Mkhwanazi not only turned a blind eye, but he also acquiesced to patently unlawful instructions, then later helped to cover it up. And that may be considered a very serious allegation. But the evidence I will present will actually bear out this allegation, Commissioners. And first of all, we start with this paragraph 1.7.2, which rambles on. And what it is, it's an analysis of Annexure T. And Annexure T is the self-same affidavit presented by General Mkhwanazi to the State Capture Commission, and it's dated 29th of September 2020. Now, in that affidavit, he makes certain averments under oath. And what I've tried to do here is to capture those averments. In other words, to coin a phrase, explain what it is he was saying under oath. And I want, rather than read out every single one of those sub-paragraphs, I want to jump forward to page 20 of my affidavit and go to sub-paragraph 1.7.2.8. And the last 4 lines of that sub-paragraph states, quote, "Finally, under pressure from the Minister of Police at a meeting to which he called the Inspector General and General Mkhwanazi, the Inspector General," this would be the Inspector General of Intelligence, Commissioners, "the Inspector General reinstated the opinion and recommendation. I cannot think of a more blatant demonstration of unlawful executive overreach." It's me saying that. And then I go on to 1.7.2.9. At the meeting with Minister Mtetwa, and this is based on his affidavit, at the meeting with Minister Mtetwa and the Inspector General of Intelligence, the Minister instructed General Mkhwanazi to uplift the suspension of General Mdluli. General Mkhwanazi later claims to have informed Minister Mtetwa at the meeting that his instruction was illegal. Nevertheless, he acquiesced. General Mkhwanazi has always been deliberately vague about the dates and times of these meetings. Given the importance of same, there can be no legitimate reason for this vagueness. And then we continue on page 21. 1.7.2.10. Following the meeting with the Minister of Police and the unlawful reinstatement of the Inspector General's opinion, bearing in mind, according to his version of events, the Inspector General of Intelligence was like a straw in the wind, flip-flopping, 1 minute saying this and the next minute saying that, and then going back to the original. It says here, General Mkhwanazi uplifted the suspension of General Mdluli on the 27th of March 2012, and he returned to work, where he was also handed the additional responsibility of protecting the President and ministers. So this whole division in the police, called the Security Division of the Police, which is the VIP protection units, was now suddenly handed over to the head, the divisional head of crime intelligence, which is Richard Mdluli. And then, on the 15th of May 2012, thank you, Commissioner, for pointing out the 1 and 2 being the wrong way round, after the Freedom Under Law application was launched, new disciplinary proceedings were instituted against General Mdluli, and on the 25th of May 2012, General Mkhwanazi recanted his earlier decision and suspended General Mdluli again. Public pressure was building. At the start of June, General Mkhwanazi met with President Zuma and appears to have been pressurized to withdraw the new disciplinary proceedings against General Mdluli and his suspension. This is based on his version of events. At the meeting, it was agreed that General Mkhwanazi would not continue as acting National Commissioner beyond the few remaining weeks that were required to appoint a new National Commissioner, General Piega, with zero policing experience, who, well, that's just my throwaway, was duly appointed on the 12th of June. So now suddenly, General Mkhwanazi, who's been the acting Commissioner of Police since the prior year in September, is now suddenly no longer the acting Commissioner of Police. And then I go on to page 22 at 1.7.3. I say, on its own terms, the narrative of General Mkhwanazi shows that he readily succumbed to political pressure and implemented the illegal instruction of the minister to uplift the suspension of General Mdluli, whilst all material times knowing that this instruction was illegal. How do we know, commissioners, that at all material times he knew the instruction was illegal? Because he says so under oath in 2020. But here's the best part. When he enacted this unlawful instruction in 2012, he was invited to Parliament, and on the 19th of April, he was asked at Parliament why he had uplifted the suspension of General Mdluli and put him back to work. And his answer was short and sweet. He said, I acted according to higher authority. And when he was asked what the higher authority was, he declined to say. On the 15th of May, when the freedom of under law application was launched, there were two sections to it, a part A for urgent relief and a part B, which was a confirmatory of the urgent relief. And the urgent relief that freedom under law requested, and I've got all the pleadings, the urgent relief that freedom under law requested was that the decision of General Mkhwanazi was to be declared unlawful and invalid, and that General Mdluli was to be put back on suspension and removed from doing his police work. Now, that Part A application was launched on the 15th of June. It was an urgent application. General Mkhwanazi supplied the answering affidavit. And in the answering affidavit, he doesn't deny that he was acting on a higher authority. In fact, he keeps quiet about it. He keeps quiet about it for 8 years and only comes out with it in 2020. So from 2012 to 2020, nobody in the country knew that he had acted on the unlawful instruction of the then Minister of Police, Nathi Mthethwa. And that is the point I'm making here. So then I say at 1.7.4 on page 22, when regard is had to the facts of the freedom under law application, General Mkhwanazi's collusion with the illegal interference of the minister and the president is even more stark. The chronology of the freedom under law matter is the following, and I set out the chronology. And at 1.7.5, I say the following. There are two noticeable aspects of General Mkhwanazi's conduct in relation to the freedom under law litigation that show he assisted to cover up the executive interference in the SAPs, which he knew to be unlawful. 1.7.5.2. First, in the face of the founding affidavit from Freedom Under Law that specifically alleged executive interference in an attempt to pressurize him to withdraw the disciplinary action against General Mdluli and his suspension, General Mkhwanazi did not admit the relevant facts. Instead, he deposed to an affidavit which did not respond to the allegations, but nevertheless opposed, on spurious grounds, the urgent interdict sought to prevent General Mdluli from executing police functions. And this is found at page, the evidence here, Commissioners, I refer to paragraph 49 of the Supreme Court of Appeal judgment, and paragraph 211 of the High Court judgment. Now, if you go to page 437 of the evidence bundle, you will see that I have highlighted a number of paragraphs because it's quite a lengthy judgment. But if you look at page 437 at paragraph 211, this is now the full application. So what you had was a Part A and a Part B. And the Part A was heard by Justice Makgoba J. And it says here, in paragraph 14 of the judgment in the Part A proceedings, Makgoba J expressed concern about the allegations of political interference in the disciplinary process and noted that Mkhwanazi had not disputed them in his answering affidavit. Now, if you go back to go forward to page 469, which is in the Supreme Court of Appeal, page 469 at paragraph 49. This is now the Supreme Court of Appeal judgment. At paragraph 49, Commissioners, it states, as a factual basis for the challenge of these decisions, Freedom Under Law relied in its founding affidavit on a statement by the then acting Commissioner, Lieutenant General Mkhwanazi, in Parliament that he was instructed by authorities, quote unquote, beyond him to withdraw disciplinary charges and reinstate Mdluli in his office. Freedom Under Law added that in doing so, Mkhwanazi had failed to make an independent decision, which rendered his actions reviewable. Though Mkhwanazi filed an answering affidavit in the interim interdict proceedings in Part A of the notice of motion, he did not deal with these allegations. So you had this situation where General Mkhwanazi is facing litigation based on his conduct to unlawfully act on the instructions of the Minister of Police. And what's the relevance of all this, you may ask? Well, his complaint on the 6th of July last year had two legs to it. One was criminal interference or penetration of the police, and the second leg was the executive overreach, the ministerial interference in the management of the police, which is exactly what happened in 2012, and he was a party to it, and not only was he a party to it, he helped cover it up for the better part of 8 years. And only in 2020 does he come out with it.
Yes. Mr. O'Sullivan, I'm just trying to understand the import of your evidence. Are you saying, because of what you describe as his past conduct, are you saying he should not have spoken up in July? He should not have complained about political interference?
Commissioner, what I'm saying is, you can't change history. He did what he did.
Yes.
But what he didn't do when he came to this commission, he didn't take the commission into his confidence and say, by the way, although I'm speaking out about it now, I just want to inform you that 14 years ago, I was engaged in just the same activity.
So is the criticism, I'm trying to understand, as I say, the import. What are we to do with this evidence that you obviously consider to be important to mention? Are you saying because according to you, he was complicit, and at this point I'm not dealing with whether or not what you're saying he did previously is correct. I'm asking if you're criticizing, as I understand, and please correct me, if you're I understand you to be criticizing him for, on the 6th of July, mentioning or complaining about political overreach or political interference. I understand you to be criticizing him for that. And I'm trying to understand, are you saying, with that criticism, are you saying he should not have spoken as he did about this aspect of things? This second, you say there are two legs to it.
Well, it's hard to come to a informed answer there, other than to say that was I not to produce this evidence here now, this commission would be completely unaware of the fact that the conduct he's now complaining of was exactly the conduct that he was involved in some years back. And if you're going to be a whistleblower, as he claims to be, you should be a whistleblower with clean hands.
Yeah, exactly my confusion. that's why I'm asking you this question, exactly my confusion. Are you saying he is not a clean whistleblower, according to you, because he previously colluded in similar conduct? Therefore, he should not have spoken up. Is that the heart of what you're saying? And maybe let me suggest to you that I ask the question because it's quite conceivable that someone thinks about it this way. The man had a Damascus moment. He previously colluded, according to you, and then come July 2025, he decides not anymore, and he changes his mind. I'm asking from that perspective, are you saying he should have kept quiet forever? Or the other possibilities you are saying, well, because he's got this past conduct, we should disregard his complaint of 2025 and disregard it to the end that he's talking, sorry, I can't think of a better word, he's talking nonsense. There was no political interference in 2025. Is that the point you're making?
So my understanding, Commissioner, and you might have to interrogate me a bit further, but my understanding is quite simply this. If you're going to have a Damascus moment, put that down in writing. Say, look here, by the way, I'm speaking out now because I saw what happened all these years ago. And I was involved, but he didn't do that. He's kept quiet. And therefore, I think it would have been better, rather than speak out at a media conference, to take action without drawing down the public confidence in the criminal justice system, because it's been shattering what's happened in the criminal justice system.
Okay, I guess I've asked my question and you've answered the way you did. I'll accept that's your best answer. The second issue about it, you've referred us to these judgments, and let's start with at 437, page 437, which is Makhoba J's judgment. Are you saying by not, because remember you've highlighted the part and you've read out where the judge says in his answering affidavit.
Sorry, ma'am, if I can just ask the paragraph number?
Looking at page 437.
Yeah, 437.
And then I'm looking, you referred to paragraph 211. And you read there where the judge says, Mkhwanazi had not disputed. Maybe let me start at the beginning. It says in paragraph 14 of his judgment, Makhoba J, well, I think this is the SCA judgment, in fact, you're referring to. Makhoba J expressed concern about the allegations of political interference in the disciplinary process and noted that Mkhwanazi had not disputed them in his answering affidavit. What are you saying there about the conduct of General Mkhwanazi?
What I'm saying here, Commissioner, it's not me saying it, it's the High Court. And it's a scathing judgment against, this is what's referred to as the Murphy judgment. And it's a scathing judgment against the police.
Yes.
And against, in particular, General Pieka and General Mkhwanazi, against both of them. And this judgment hasn't seen the light of day for probably 10 years or more.
Yes. I'm asking the simple question because, you know, another construction, and I think in our practice that is accepted, is if you do not answer to a specific allegation, you have admitted it. So when I read 211, I would have concluded, until you spoke, I would have concluded, well, it means he didn't dispute it. He didn't dispute that there was political interference. But you seem to be reading that paragraph or to be attaching a meaning to it, that he basically was part of the cover-up, unless by not responding or not denying the allegation of ministerial interference, he therefore covered up, unless I misunderstand you, Mr. Sullivan?
Commissioner, you have to look at all the bits that I've highlighted and take them together. But if I go to page 438.
Yes.
at paragraph 215, 216, and 217 and 218.
Yes.
This is scathing. It says Mkhwanazi dropped the disciplinary charges on orders from above is furthermore borne out by the Rule 53 record filed on his behalf. The record he supplied comprises nothing more than 2 letters addressed to Ndluli, one notifying him of the withdrawal of the disciplinary charges against him and the other advising him of his reinstatement to work. It doesn't say to work. There's no charge sheet or correspondence dealing with blah, 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 and it goes on. And then 216, it says, the inescapable finding is that the decision of the acting commissioner to withdraw the disciplinary charges and to reinstate Ndluli as head of crime intelligence were taken in an attitude of subservience pursuant to an unlawful dictation from a person unknown.
Yes.
Who was beyond the acting commissioner. By the way, at this stage, nobody would admit who it was that gave him the instruction. That only came 8 years later.
Yes.
He says, an abdication of power violates the principle that the responsibility for discretionary power rests with the authorized body and no one else. And
Yes.
It goes on to say at 218, to ensure the proper functioning of the SAPS, the Commissioner, in discharging his obligations under Section 11 of the SAPS Act, must protect and give effect to SLAP's discipline regulations. It's a scathing judgment. And the failure, it's not the judgment that's more important, Commissioners. What's more important to the people of this country is that this has been kept hidden. It's been kept under wraps. It should have been part of the evidence. He said, by the way, the reason I did what I did on the 6th of July is because 14 years ago, I was involved in exactly the same state of affairs, and I went along with it and covered it up for 8 years.
I guess, Mr. Sullivan, my question is, what difference does it make? Remember, we consider our terms of reference. I don't know that we can take it any further, but really my question is, even if you are correct in your position that when he testified here, he should have confessed his previous sin of covering up, as you say.
Yes.
I'm still left with the question, okay, what difference does it make to, he has spoken up. We are investigating exactly that as a commission, whether indeed there's been political interference. Does it really make a difference that, and if so, what difference does it make to how we deal with that allegation of his, that when he sat there and testified, he didn't testify to his previous crime of colluding
Yes.
in the similar decision making that he's now complaining about?
Well, except, Commissioner, it's my evidence that not only was he previously involved in that conduct, but for 8 years he covered it up. For 8 whole years. And it only came out when he made his statement at the Zondo Commission. And when he made his statement at the Zondo Commission, he did not go into the nitty-gritty of what actually took place. He gave a version of events, and I obviously have no first-hand knowledge as to whether or not the then Minister of Police in 2024 or 2025 did engage in executive overreach. I have no knowledge of that. It's not something I've been involved in. But if a person is going to become a whistleblower, surely that whistleblower is going to say, by the way, the reason I'm whistleblowing is because I was involved in this conduct 14 years ago and I saw the effect of it.
Thank you.
Thank you.
Thank you, Commissioner Baloyi. If I understand your summaries of both General Mkhwanazi's affidavit before the Zondo Commission and the Freedom Under Law application, that application was brought in 2 parts: the interim relief in Part A,
Yep.
and the main relief, the review in
Yep.
Part B. General Mkhwanazi deposed to the affidavit in Part A, and I think you make the point in your statement that by the time Part B came around, General Pierre was deposing to that
Correct.
affidavit. So when you charge General Mkwanazi of failure to disclose, that he would be required to do in Part B, when by then he had already been transferred or to another department, and General Pierre had taken his position. Do I understand you correctly?
Then I would point the commissioners at page 25, paragraph 1.7.9
Yes.
and 1.7.10, which I
Yes.
would like to read out.
Okay.
This is my testimony. Accordingly, even after he was fully aware of the contents of General Pieka's affidavits in the Freedom Under Law proceedings, General Mkwanazi continued to cover up the illegal instruction he'd been given by Minister Ntetwa and the political interference of both Minister Ntetwa and President Zuma in decisions that he ought to have been able to take, free of any political interference. He could have, at that time, and indeed should have, approached the court with the truth. He failed to do so. He only finally came partly clean when he was interviewed by the investigators at the State Capture Commission, led by Justice Sondo. Even then, his version was a cover-up of the truth, and he fobbed them off by blaming others. Given General Mkwanazi's own collusion in an illegal process of political interference designed to keep General Mdluli in charge of the Division of Crime Intelligence and its regularly stolen secret funds, it is difficult to take seriously his complaints of political interference that he made in his infamous speech on the 6th of July 2025. In fact, General Mkwanazi's own unlawful conduct in 2011/12 make the current complaint he has made pale into insignificance while still sharing commonalities. For example, in 2011-12, General Mkwanazi's conduct was intended to unlawfully protect Crime Intelligence Divisional Head, much the same as his conduct in 2025 is intended to protect the Crime Intelligence Divisional Head and those under him.
If I just take a step back to your paragraph 1.7.9, just to clarify something.
Sorry, just catch that paragraph.
Page 25, paragraph 1.7.9. You state, and this is in response to the point I had raised with you, that the answering affidavit in the review application was deposed to by General Pierre, who had assumed that position by then.
Correct.
You state that even after he, General Mkwanazi, was fully aware of the contents of General Pierre's affidavit and the full proceedings, General Mkwanazi continued to cover up the illegal instruction he had been given by Minister Mtetwa.
Correct.
Now, what form did this cover-up take? On what basis do you say he continued? Firstly, he covered up, and secondly, that he continued to cover up. Thank you.
Maintaining silence. Because what happened, commissioners, while that period between Richard Mdluli being suspended and then having a suspension uplifted and then having a suspension reinstated and the court case is going on, during that period, the whole thing was argued out in court. And when it was argued out in court, it was all over the media. And the Supreme Court of Appeal go into some detail about how General Pierre misled the High Court. And General Mkwanazi kept quiet. He had a duty. He could not ignore that duty. And that duty was to step forward and say, well, hang on a minute. Actually, General Pierre's version of events is not true.
Was he a party to this application?
I'm saying he was. And the reason I say he was is contained within Annexure W.
And Annexure W,
Annexure W,
page 475, that's where it starts.
yes. If you have a look at page 14 of Annexure W, which is page, just bear with me a second. I'm going to have to count the pages. 1, 2.
If you perhaps give a sense of what you are looking for, we might try and assist.
14. Aha. Here we go. It's page 488 of the evidence bundle.
488.
488 of the evidence bundle.
Thank you.
So this is a presentation that was made on the 13th of November 2015 by the Minister of Police.
Yes.
It was, in fact, Mr. Mtleko was the Minister of Police then. This was a presentation by the Minister of Police to Parliament. And it's been uplifted from the Parliamentary Monitoring Group thing. So this was made on the 15th of November, 13th of November.
It speaks of a grievance. It doesn't speak anything about, it's not answering
No,
my
but
question.
what it's showing, Commissioner, is that Lieutenant General Mkhwanazi lodged a grievance against the National Commissioner for lodging false affidavits in court regarding Lieutenant General Mdluli's case. And the point I'm trying to make is this corroborates the fact that other than lodging a grievance, he did nothing about it. He allowed her to lie to the court.
But that grievance has a finding as well further on in the, on the same page. The first point speaks to the grievance lodged by General Mkhwanazi. Then there is a finding.
Yep.
And the finding says the
finding says the National Commissioner informed the court wrongly with regard to Lieutenant General Mkhwanazi's actions on Mdluli matter. So what she actually did, what General Pieka did, was she informed the court, and that's borne out in the judgment. She wrongly informed the court that General Mkhwanazi had not received instructions from a higher authority. She said that was a misunderstanding, and I'm going to supply a confirmatory affidavit from General Mkhwanazi. It was never supplied. There was no, and even when it went to the Supreme Court of Appeal, they still couldn't supply a confirmatory affidavit. So the whole thing was hushed up. And what I'm saying, commissioners, is if there was going to be any transparency here, it should have been a sworn affidavit by General Mkhwanazi informing the court and opening a docket against General Pieka for lying to the court, which in effect, apart from being perjury, is the offense of defeating the ends of justice. And no such event ever took place.
I think my point is he wasn't a party to these proceedings, so he didn't have standing to file any affidavit. That's my point.
He wasn't a party, but he knew what was going on.
Yeah, but he wasn't a party. My question was he a party? And you said yes, and you referred us to this document.
He was a party to the original proceedings.
Yes.
The Part A.
Where you are saying he should have filed an affidavit. I'm saying he wasn't a party to those proceedings where now General Pieka is the party that is being sued. So he wasn't a party. You understand what I'm saying?
I understand.
Yes. I think that's the first point. The second point, in the judgment, in the Murphy judgment, and this I think we accept it was in 2012. I think it was in 2013.
Say again?
In 2013, that's the Murphy judgment, right?
Yes, yes.
And it states at I'll read it for you.
What's the page number?
Page 436. And this is about the point of you saying he didn't speak up for a whole 28 years, I think you say, and spoke up for the first time in 2020 before the so-called Zondo Commission. And I'm reading this just to say it seems to suggest differently from what you're saying. At page 436, paragraph 207, it says, in paragraph 45 of the founding affidavit, FUL alleged that the acting commissioner publicly stated in Parliament that he took the decision to withdraw the disciplinary charges on instructions from authorities beyond him. And then Full added that by acting on the instructions of authorities beyond him, the acting commissioner failed to act independently. So it seems that at least Full, FUL, was aware when they filed their papers that he has spoken publicly, that
In fact,
the decision, let me finish,
Yeah, sorry.
that the decision that he took was imposed on him from higher authority. So why do you say that he kept this quiet until only in 2020?
Because at the parliamentary committee, it was asked what higher authority. He couldn't answer. He should have said the Minister of Police instructed me. Instead, he covered the thing up.
So the criticism is he didn't state it's
He
the
didn't state-
minister.
In fact, what happened, if you look at General Pieka's conduct in the FUL response, she said that actually what he said at Parliament wasn't correct.
Yes.
He made a mistake. What he actually meant was the NPA had decided to withdraw the charges, and that's why he followed suit. The whole thing was a complete lie.
Okay. So that's Pieka. For now, I was just clarifying.
Yes.
I was clarifying that when the FUL prepared its answering affidavit,
Yes.
General Mkhwanazi had already said in Parliament that he made the decision on higher authority, or it was dictated by higher authority. And your criticism, and I hear you.
They couldn't get
you
it
say
out of him.
Your
Parliament
criticism is he didn't say the higher authority is the minister.
That's what he
your
should have
criticism. Okay, thank you. Thanks, Mr.
Thank you.
Just one issue with you, Mr. Sullivan. Going back to page 488.
Page?
488. Remember, throughout this section of your affidavit, the point you sought to make was that General Mkhwanazi has kept quiet for 8 years about the political interference that took place when he was acting national commissioner. Doesn't that paragraph in 1, the bullet point that sets out the grievance that he lodged in 2015, undermine that argument? Because it shows that as far back as 2015, he spoke about the fact that General Pieka misled the court in relation to the Mdluli matter. And then it ties up with what Commissioner Baloyi says, that even prior to that, he had said in Parliament that there was interference. Although he did not say who interfered, but at the very least, he did say there was interference.
I hear you, Commissioner.
So you cannot then, in those circumstances, say for 8 years he did not say anything, because what this presentation at least shows is that when he became aware that General Pieka may have misled the court, he lodged a grievance against her on the very Mdluli matter, so on the subject of the very issue that we are discussing. The detail may not have been there, and because you were not part of the presentation, maybe you would have expected more detail. But it's not correct to say there was complete silence for 8 years. That's the point I'm trying to make with you. That at the very least, there was something, not the detail that you expected.
There was something, Commissioner, but there wasn't transparency. What there was a complaint against Pieka for not telling the truth. But there wasn't, by the way, she wasn't truthful. What she should have said was bang, bang, bang.
Yeah.
He didn't do that.
But he goes a step further
up.
and he says he was not even consulted when the affidavits were prepared. The point being that if he was consulted, he would have stated the true facts.
Well, except for the fact that when he made the first affidavit in the Part A, he kept quiet about the matter. If you look at the pleadings on the FUL matter, on the Freedom Under Law matter, they make it crystal clear that their pleadings, their application is based on the statement he made in Parliament on the 19th of April, where he stated to Parliament, when they said to him, why have you put this man back to job? Why have you lifted the charges against him? He said, I've acted on the basis of a higher authority. And they asked who? He refused to tell them. He couldn't tell them. So I'm saying he covered it up all the way along. And what that cover up comprised of, yes, you can say that this complaint, which was a grievance, there should have been a sworn affidavit stating the chapter and verse. It only came out in 2020. And please listen to this very carefully. What he stated to the Zondo Commission in 2020 was not chapter and verse. What he should have done was given a blow by blow, where the meetings took place, when they took place, the dates and times and everything. He didn't. The thing was kept vague. And I'm saying it was deliberately kept vague.
But in the affidavit before the Zondo Commission, he does mention the days of the meetings. If you go to 376,
376.
Yep. And that's the affidavit before the Zondo Commission.
Correct.
You will see that he mentions the meetings, he mentions the dates.
Paragraph number, sorry?
The dates of the letters.
Yes, that's referring to dates of letters.
Yes.
But the information that's missing, Commissioner, is the dates of the meeting in respect of the police minister. That meeting date has been kept vague. There's no date there.
Yes. But we know that it is March because the letters are the March letters. So when he refers to the IG opinion that was first issued and then was later withdrawn, so he's referring to the March date, and that much is clear from paragraph 48 on page 356, that we are in the March period because we know that the meeting with President Zuma happens in June. So although it doesn't specify the date of the meeting, but it's quite clear that the date is between the
somewhere around then.
It's between the two opinions by the Inspector General. So it would have been between the 6th of March and the 19th of March. That's at least how I read paragraph 48, that the meeting would have happened between those two dates.
Commissioner Khumalo, perhaps what might assist is reference to page 363.
Yes.
At the bottom of 363 is paragraph 39. That gives a date on 23rd April 2012, Lieutenant Drummond authored a further letter. This is in the sequence when he's narrating sequence of events.
Sorry, page?
It's paragraph 39.
Sorry, what page number?
Sorry, I was looking at the wrong version of the document, but it's paragraph 39.
372.
If you go then from 372, paragraph 39, that's where he introduces the date, the letter by Lieutenant General Dramat of 23rd April 2012. And then at 40, he quotes that letter. And then at paragraph 42 under heading H, interference by Minister of Police. It says, a few days after my conversation with Advocate Khadebe, I chaired this meeting at the police headquarters, and he continues. So if one were to follow his timelines, it would give you a good sense of when the meeting, although admittedly it's not dated, took place. Would you have a challenge, a difficulty with that?
Commissioners, the only difficulty I have with that is that if it's such an important meeting, why don't we have a date for the meeting and a time for the meeting that says on this day at this time the following meeting took place? I'm just saying that's the way I see it.
Okay.
It could well be that he's happy with keeping it vague. I'm not happy with keeping it vague.
That's why I was saying your issue is not so much that he did not disclose what happened. Your issue is that he did not give the full detail, including the date.
Yeah, when he disclosed it on the 2020 affidavit, in the 8 years preceding that, he had an opportunity to come out and say, by the way, on this date, at this time, I had a meeting with the Minister of Police who unlawfully instructed me. The only time this comes out is here, 8 years later. It never came out before then. Never. Thank you.
On that score, then, may I invite us to go to your page 23 of your statement?
Page?
Page 23.
22.
23.
Uh-huh.
And paragraph 1.7.5.3, you actually make a much stronger allegation against General Mkhwanazi. You say, second, he appears to have colluded in allowing SAPS to put a dishonest version in their answering affidavit to Part B to the court.
Yep.
When then Commissioner Pierre falsely stated that there had been no instruction to General Mkhwanazi from above.
Yeah. And the reason I'm saying that...
My question is, what must the commissioners look to see the collusion that you reference?
Because at that time, we have to cast our minds back to 2012. So during that whole period, there was a lot of media coverage. Major General Richard Ndluli, or Lieutenant General, Richard Ndluli, was in the media every single week, 2 or 3 times a week. This whole thing, as it was being played out in court, was all over the media. Now, by his own account, he spent 2 years sitting at home twiddling his thumbs during that period, while General Pierre went out and gave a complete pack of lies to the court, which was published. It was all over the media. I'm saying, if I know about something that's wrong and I keep quiet, I'm assisting in the cover-up. And that's the point I'm trying to make. And if you go through the documentation, if you go through the judgments, and you look at the timeline, there's absolutely nothing between his first statement in May 2012 and the Murphy judgment, still nothing. He only comes out with it for the first time 8 years later. Why keep quiet? Keeping quiet for 8 years, I'm saying, is acquiescing to crime.
I think, Mr. Sullivan, it's one thing to say, by keeping quiet, he acquiesced in a lie that he knew about. So firstly, you have to establish he knew that General Pierre in her affidavit has said this, and he chose to keep quiet. So you have to establish that fact first. And I don't know that you have said enough in your testimony that indicates he knew, as a matter of fact, not what you say. He was at home for 2 years, it was playing out in the media, he should have been aware of it. It seems to me that you would first have to establish that he knew, as a matter of fact, indisputable fact, that this was said in the affidavit, and knowing that he made the decision to keep quiet. That's one thing. But if to say that he colluded, and perhaps in fact he does collude if he does that on those facts, if he knew and he chose to keep quiet, he colludes by omission. That's the one form in which he could have colluded. The alternative formulation is he was deliberate. He was part of the cover-up. It's not a case of omission, but it was deliberate. So in a way, it was by commission, right? He knew this is happening, and he chose to be part of that lie. I don't know that beyond your whether you can put it as high as that, and yet your statement here, where you say appears to have colluded in allowing the subs, I'm not sure that it is backed up by anything that you have said. We've gone through a number of instances where he has said and spoken, including up to the grievance that he laid against General Pierre. And in all of that, I haven't seen, I must say, speaking for myself, that I don't see the positive and intentional act that you're seeking to convey in 1753, that he intentionally participated in a General Pierre cover-up.
Okay, I hear what you're saying, Commissioner, and I'd like to draw your attention to what I say at paragraph 1.7.6. Because I'm saying there, in contrast, General Mkhwanazi claims in his affidavit to the State Capture Commission that he was completely unaware of the contents of General Pierre's affidavit. I'm saying I find that claim in that affidavit unconvincing. And the reason I find it unconvincing is because he had made a grievance against her for being untruthful in her answering affidavit to the High Court. And I go on to say, General Mkhwanazi therefore knew that the allegation of an unlawful instruction to him was at the center of the application. And the reply from General Pierre would have to admit that central allegation if she was not going to perjure herself.
Thank you.
Sorry.
Yes.
Mr. Sullivan, you give two reasons for what you have just said now. You say, in contrast, General Mkhwanazi claims in his affidavit to the State Capture Commission that he was completely unaware of the contents of General Pierre's affidavit because he was in his period of rest at home in KwaZulu-Natal at the time. I find this claim unconvincing because, and then comes the two reasons,
Yes.
or then come, not comes, the two reasons that you give.
Yes.
Even if I take a bit of time, I will read both. The first one is this. General Mkhwanazi was aware of the allegations in the FUL application because the founding affidavit in the agent application had been served on subs whilst he was acting National Commissioner, and he had deposed to the initial answer in that application, but chose to sidestep the unlawful instruction allegation and simply not comment. General Mkhwanazi therefore knew that the allegation of an unlawful instruction to him was at the center of the application, and the reply from General Pierre would have to admit to that central allegation if she was not going to perjure herself. Let's focus on that reason and not overlap onto the second reason. Yes.
Of course, you can read different things into it.
Yeah.
The way I phrased it.
On what basis would you want to suggest that General Mkhwanazi would have known what General Pierre would say or not say in her answering affidavit on the Part B of the application, going so far as to talk about perjury and so on?
My argument, Commissioner, is very simple. I go to Minister Nhleko's presentation in 2015 to the Parliamentary Portfolio Committee on Police, where he talks about the grievance. And he didn't make the grievance in 2015, he made it earlier than that. So here he was making a grievance about the alleged perjury of General Pierre. But what he wasn't doing was saying it's perjury because this is what really happened. He just said she perjured herself.
But here you are talking about what General Mkhwanazi ought to have known what General Pierre would say, not what she had in fact said, what she would say in deposing to the Part B answering affidavit.
He would have
so
factum. He only knew
so
about it after.
so those are two different things. What may have happened a couple of years later does not answer what General Mkhwanazi should have known with regard to what General Pierre would say in her Part B answering affidavit. That's where I am.
So, yes, Commissioner, but the point I'm making is he knew what the central allegation of the Freedom Under Law application was. He knew. The whole application was
Yes.
found on this allegation that he had received unlawful instructions.
But what's going to be deposed to is not his affidavit. And if nobody invites him to come depose to the affidavit as the person who actually knew what had happened, then on what basis can you fault him with regard to what the content of General Pierre's affidavit was going to be?
Let me give you an analogy, Commissioner.
Yes.
If you look at Section 34 of PRECA, the Prevention and Combating of Corrupt Activities Act, it makes it an offence for a person not to report a particular category of crime. We're talking here about the previous acting commissioner of police, who is now sitting at home twiddling his thumbs, watching all the media coverage. I cannot believe he wasn't able to see what was going on in the media. And instead of stepping up and saying, well, hang on a minute, this is not true, he kept quiet. And the point I'm making is he had ample opportunity to not keep quiet, and he didn't do so. And he was a policeman.
I know right at the beginning of this, himself not become aware, people close to him would surely have told him. So in answering my question with regard to the first reason, I do not think you can peg your answer on him having heard or seen or read what was out there in the media.
Well, of course.
Because then you are contradicting yourself.
No, of course. If the commission gives him the benefit of the doubt.
You first gave him the benefit of the doubt.
I don't necessarily, I'm saying I wasn't convinced by his argument.
Yes.
Okay? And the reason I wasn't convinced of his 2020 affidavit was because in 2015, he was moaning and grievance about Commissioner Pierre lying under oath against him, about him, that he didn't say this, and therefore, he was never offered a confirmatory statement. At the end of the day, Commissioner, what it boils down to, from me as an evidence giver, is it's I suppose, 80% gut feeling. But if you look at the reality of it, there's no evidence between 2012, when he had an opportunity to come clean, when he made the first answering affidavit to the Part A, he had an opportunity to come clean and tell the truth. He kept quiet. And the first time we hear about it was at the State Capture Commission, and that comes out in his affidavit. And it really then is utilized at this commission. But what he doesn't do at this commission is said, by the way, I kept quiet about it for 8 years. I told the State Capture Commission, I just think it should have been a lot more transparent. If we are talking about a junior policeman, I can understand, but we are talking about a person who was the acting commissioner of police. He was in charge of running the police service, and he was the man, nobody else, him. He was the one that unlawfully put Richard Ndluli back to work, forcing civil society to bring urgent applications to get Richard Ndluli back out from his office. And I'm going to paint in my closing argument, or whatever you want to call it, the reality between that and what went on at the 6th of July media conference, because there are similarities here.
Yeah, those are related issues I will immediately accept. But you are dealing with something specific here, which is about why and you keep repeating the words. He was sitting.
My work is easy because I use ClickUp. Here's how I keep track of all my tasks. I start by brain dumping everything I need to get done in a list view. Next, I set a priority and a due date to keep things on track. I create custom statuses to organize my progress exactly how I want it. I like to add the action items field so AI can show me the next steps. I add my teammates as watchers so they're in the loop. ClickUp makes work easy, from personal projects to running a multi-billion-dollar company. Click the link below to create your workspace for free.
Really what you are addressing in 1.7.6.2. So that is, my point is, this is somebody who is sitting at home under the circumstances that we all know, based on the testimony or the material before us. Now, on what basis must he insert himself and say, I'm lifting my hand, here I am, just in case the current incumbent, General Piecha, might perjure herself, I'm offering myself. Why should he have done that? Shouldn't those who were preparing the answer, the Part B answering affidavit, have been the ones who approach him specifically and say, you are the person best placed to answer this, therefore, please tell us what you know so that we file your affidavit as a confirmatory affidavit to what General Piecha is going to be saying?
Well, it's a tricky one, Commissioner. The reality of the situation is that during that period of time, President Zuma was running the country, or running the government, and we had all these things going on. And I cannot say beyond reasonable doubt that he colluded. But what I can say is he would have known that in order for her answering affidavit to be truthful, she would have had to say that which he refused to say, which is that he got an instruction, according to his version of events later, from the commissioner, from the Minister of Police to reappoint General Mdluli. And let's give him the benefit of the doubt and say he wasn't listening to what's going on in the media. Let's just say that he was blind to all these things that were going on. But somehow he was able to make a complaint, a grievance. If I was in his shoes, I would have been beating a path to the door to say, hang on a minute, let's tell the truth here. But he couldn't. And the reason he couldn't was because it was still too short a period after the event where he had acted unlawfully by carrying out the instructions of the Minister of Police. But 8 years later, you know, time has passed, water has gone under the bridge, now we can put it out there. I believe he should have put it out there a lot sooner.
Let's move on to the second reason, 1.7.6.3. I don't think we have much to say there because I already touched on it when we were dealing with the first one. But the point I will make in this regard is that doesn't your second reason become attenuated in the sense that you yourself already accept the possibility that he might not have seen, that is General Mkhwanazi, he might not have seen what was out there in the media?
Well, that possibility, you can say, exists there. But then I counter it by saying, even if he wasn't aware of the news coverage, it's inconceivable that none of his close colleagues in the police would have drawn General Piecha's denial to his attention. And the reality is, he became aware of it somehow because he laid a grievance.
That's speculation of the highest order. We are talking as at the time. I'm engaging you as at the time. That's speculation of the highest order.
Yeah. It's hard to say.
Yes.
The time machine, I guess, would be needed.
Yes. Thank you. Thank you.
Thank you, Chair. Maybe for my understanding, can we go to Page 384. 384 of the bundle, and that we are still in General Mkwanazi's affidavit to the commission, to the State Capture Commission.
384.
384.
Yep.
And he starts at paragraph 67 that on those dates, 17, 18, 19 of April 2012, they appeared before the portfolio committee. I'm interested in what's set out in paragraph 69, where he says, having presented, he concluded with the remarks, other powers decided on convictions, not just the SAPs. Here I was referring to where matters were taken out of control of the police. Is it that quotation that you say means where he's supposed to have said to Parliament that he acted on at the behest of other powers?
Yeah.
Or is it a completely different engagement on that score?
My understanding, Commissioners, is that there he's talking about the criminal charges, not the disciplinary charges. So the criminal charges were not in his domain. They're in the domain of the NPA. And as we know, that was being mismanaged by advocates Mwebi and Jiba. So I opened, by the way, a criminal complaint against them for the mismanagement of that whole mess. So you have this situation where the National Prosecuting Authority under advocates, by the way, at that stage, Advocate Jiba was the acting NDPP. And then Advocate Mwebi, Lawrence Mwebi, was the head, the national head of commercial crime at the NPA. And they took an unlawful decision to withdraw the criminal charges, not only the charges pertaining to the kidnap and murder of his wife's ex-boyfriend or whatever the case may be, but also the alleged fraud and corruption charges. They took those decisions unlawfully, and I believe that's what he's talking about here.
And that's the clarity I was seeking, whether what he states at paragraph 69. So you are saying when he says he stated to Parliament that other powers decided on convictions, not just the subs.
Yeah.
He was referring to the criminal case. It has got
criminal
nothing
case,
to
but
do.
what he doesn't say, Commissioners, is he doesn't say what he said about the disciplinary charges, because that's what he was questioned on in Parliament. And he said a higher authority, that's his words. And when they tried to drill down into that, he said he couldn't go into it.
I accept. I just needed your clarity on this, that quotation I read there, I should not misunderstand as his response to the issue of withdrawal of the disciplinary charges. I should not misunderstand that quotation to relate to that.
I believe this is not to do with the disciplinary charges. I believe this is to do with the criminal charges. He uses the word other powers decided on convictions, not just the police.
Okay. Can I then invite us to page 25, paragraph 1.7.10.
Uh-huh.
You conclude at this paragraph thus, and I quote, given General Mkwanazi's own collusion in an illegal process of political interference designed to keep Ndluli in charge of the Division of Crime Intelligence and its regularly stolen secret funds, it is difficult to take seriously his complaints of political interference.
Yep.
Okay, and you go on. Do I understand you correctly that you suggest General Mkwanazi colluded in retaining General Ndluli in the Division of Crime Intelligence to facilitate the stealing of secret funds? Is that, am I understanding you correctly, or I'm misunderstanding you wholly?
Sorry, I'm not quite...
I was saying my interpretation of what you say there, I wanted to test whether I'm correct or whether I'm misunderstanding.
So what I'm saying is there's similarities.
Yes.
The similarities in 2012 are the same as the similarities in 2025 in July. In 2012, it was to protect the head of crime intelligence, which was Lieutenant General Ndluli. In 2025, in July, it's to protect, I'm saying, and that'll be the next bit that I come on to, that it was to protect crime intelligence.
Oh, so
Those are the similarities.
so a protection of General Mdluli.
I'm
In
saying,
2012, you say was by General Mkhwanazi himself.
yes, I'm saying that in 2011/12, he was protecting one general in crime intelligence. And in 2025, he's protecting 5 generals in crime intelligence.
Okay. Now, you have tendered this affidavit, so I'm sure you are familiar to some extent with it. From paragraph 9 of that affidavit, General Mkhwanazi makes the distinction or seeks to.
So what page?
Paragraph 9, I'll tell you the exact page now. 349, under the heading the Mdluli matter.
So this is one of the annexes.
Yeah, your annexures, yes. We are still with
Page-
the 349.
Page 349.
349, yes.
Yep, got it.
And at paragraph 8, he makes the point that when he was appointed, General Mdluli was the Divisional Commissioner of Crime Intelligence.
Yep.
At 9, he points out that by then he had, as he joined as an acting National Commissioner, General Mdluli had already been on suspension, having been suspended on 29th April 2021.
Correct.
And that suspension related to the alleged murder case.
Uh-huh.
And at 350, he continues that at paragraph 10, on establishing that Lieutenant General Mdluli had not been suspended on the fraud and corruption charges, which he introduces in the paragraph above, he instructed Lieutenant General Stander, the Deputy National Commissioner of Human Resources, to initiate steps to implement disciplinary charges against Lieutenant Mdluli in this regard. Then at paragraph 11, he speaks about General Nebeya, which we can skip. And then at paragraph 12, he says, as part of my briefing on this matter, I was advised that Major General Solil Lazarus, the Chief Financial Officer of the Secret Service account of CI, had already been suspended and charged criminally for fraud and corruption. He continues at 13, I then decided to instruct Lieutenant General Stander to appoint an outside person to assess the available evidence to determine whether it implicated General Mdluli and then to advise me on the way forward. These events took place roughly towards the end of 2011. I attached marked NM1 a copy of the report obtained by Lieutenant General Stander pursuant to my instructions. He then says at paragraph 15, pursuant to this report, disciplinary charges were brought against Lieutenant General Mdluli. This is now for the fraud. Do you accept the facts as set out by General Mkhwanazi in this affidavit, or do you have reason to doubt
In there,
their veracity?
I can't contradict them.
Okay, now in light of that, if you then are forced to accept, is it fair to suggest that he took steps and colluded in a process that will protect General Mdluli and enable the further looting of secret funds? Is that a fair conclusion? If you accept the facts as stated here.
If what he says here is true, then it means he's doing his job. But then along came the minister who said, cut all this up, drop the charges, put him back to work, and he did that. So he may have started off on that course. I guess the best person to ask is him.
Okay.
Can I ask a question, because you introduced the involvement of the minister?
Sorry?
You introduced the involvement of the minister.
Yes.
2 months after the suspension was lifted. So on the same day that FUL launched the urgent application, you are aware that General Mkhwanazi did suspend General Mdluli again.
10 days later, the Freedom Under Law case was launched
Yes.
on the 15th of May.
Yes.
General Mkhwanazi General Mkhwanazi resuspended General Mdluli on the 25th of May.
Yeah, don't confuse the date when he was charged with the date when he was suspended. I had understood, having read the judgment, both the High Court judgment and the
No,
Supreme Court of Appeal judgment.
he was resuspended on the
yeah.
25th of May.
I'm looking at paragraph 95 of the judgment. You may be right because it says the application was launched on the 15th of May 2013. I think that's a typo in the judgment. It's 2012, right?
So
I'm
just-
on page 409.
409.
Yeah.
Let me just go to it.
409.
Yep.
I think this may be a typo in the judgment. That should be 2012, right?
The wording of the paragraph would suggest so.
Yeah.
Which
So,
paragraph, sorry?
Paragraph 95.
95.
Yes.
Uh-huh.
You may be correct. So I think there's a typo there with the date. But your point is that he only resuspended him after the urgent application was launched.
After the Freedom Under Law application was launched, he realized, there's trouble coming.
Yeah.
But contemporaneous with the launching of the Freedom Under Law application, Advocate Chowki was the Director of Public Prosecutions in Johannesburg, and he had given instructions for an inquest into the murder of, or the death of Opa Ramakgobi. So what happened was, during that inquest, in the week after the Freedom Under Law application was launched, and while General Mkhwanazi was having to deal with his answering affidavit, revelations were coming out at the inquest about the conduct and the kidnapping and the beating up of Opa Ramakgobi, allegedly by, in fact, he was convicted by it later.
Mr. O'Sullivan, I want to stick to the theme of the question by Advocate Sillo. So my question in essence is, what do you make then of the fact that during the May period he did suspend General Mdluli again, and in fact he was charged?
Well, he didn't really have much of a choice because he's got this application landed.
Ready for your next ride? With our massive variety, you're bound to find the one. Simply head to a We Buy Cars near you.
He was in a corner. He had no choice. He had to do it.
All right.
Mr. Sullivan, I think you are aware in this affidavit here, you've got where he describes.
Where what?
Where he describes the steps that he took, and
Yep.
that includes engagement with the Inspector General, and the Inspector General at some point instructing that he should lift the suspension and have Mr.
Yep.
Mdluli come back to work,
Yep.
and he didn't agree with that. So you are aware of the steps that he took,
Yep.
but for that he acted on ultimately he acts because the minister is now involved in the matter. You surely couldn't fairly say, disregard everything else that he has done and say, because he followed the minister's instruction and put it as high as that was action he acted to protect Mdluli, who for purpose of plundering the secret fund. You can't. I mean, there's a logic in it. There's a disconnect in that you seem to, in fact, not you seem to, you do as a matter, as you testify there, you disregard all the efforts that he took to discipline General Mdluli. You disregard that, and then you say, well, He followed the minister's instruction ultimately. The minister instructed him, and by following the minister's instruction, he therefore was in fact protecting Mdluli to enable him to continue to plunder the secret fund. I don't understand that logic or that reasoning, because it seems to be quite selective. From where I'm sitting, you seem to be selective in refusing to acknowledge the steps that he took, but also to acknowledge that, in fact, when he did withdraw the uplift, rather, the suspension, it was at the instruction of the minister. You can criticize him for following the minister, just like the court did, right? That he's got the discretion, he's got the power. He should have insisted to exercise his power. Well, he didn't. He followed the minister's instruction. How that translates so easily, in your view, to it being a deliberate decision on his part to protect crime intelligence general for purpose of plundering the secret fund, and then you say in exactly the same way that is done in 2025. I'm battling to see the connect that you seek to make in what seems to be disconnected.
I don't consider that I've disconnected. If I look at it, what happened at the time? He's only given his version of events 8 years later. Nowhere at the time does he explain all these events. He waits 8 years. He could have said in his answering affidavit to the court, he could have outlined these things then. He didn't. He kept quiet about it. He only comes out with it 8 years later. Now, if one has to give some real thought to this and think out of the box, one has to consider the following. He was a senior police official. He was a major general in the police, and he was aged 38. There were probably at least 40 generals in the police.
So, Mr. O'Sullivan, we're not discussing that now, sorry.
Okay.
It's late in the day. We're not discussing what you have addressed in your statement. Our question is really, the theme now is a very, it's a direct theme. It doesn't require you to speak about his promotion that you obviously were not happy about. It is simply this, that you unless you say everything that he says I did, or the steps that he took to discipline, to suspend, unless you say all of that is a lie, right? And I didn't understand you to be saying all of that which he says he did is a lie. Unless you're saying that it's a lie, I don't see how you can fairly say today, knowing what you know. Remember when you draft this affidavit for the commission, you know this history, what he alleges he has done. Knowing all of that, and then you in June, as we sit here, you say, well, that he did not say it's the minister that instructed him, that he did not contradict General Pierre in an affidavit in court. Those two things are evidence that he in fact was colluding. He made the decision to collude to keep General Mdluli in place so that he can continue to plunder the secret fund in the same way that he's doing in 2025. I don't see how you get there. It seems forced to say, well, that's what he was doing in 2015 or whatever year it is.
Yep.
And then you say, well, it repeats, in fact, in 25.
I hear what you're saying,
seems to be forced.
And my point is quite simple.
Yes.
But if the content of his affidavit in 2020 had been included in the content of his affidavit in 2012, I would absolutely agree with you. But it wasn't. The whole thing was kept quiet for 8 years. And I believe it could have been put out into the open 8 years earlier. And who knows what effect it would have had on the police. It might have changed the future.
Thank you.
I think we've traversed this already, but we did clarify that the Freedom Under Law application was brought in two parts. The part A was an urgent interdict, Is my recollection correct?
Correct.
That is the Part A.
Part A, the order was granted.
Yes, I'm aware.
Yeah.
My issue is General Mkhwanazi deposed to an affidavit in regard to the relief sought in Part A. So it's not the main application. The main application is in Part B. The review application,
Yeah,
right?
I agree 100%. The main application was Part B.
Yes, so if we agree on that score, are you suggesting that all these facts that he has set out in the affidavit deposed to before the State Capture Commission, he should have set them out in his answering affidavit to the Part A relief?
Because
Is
the central theme of Freedom Under Law's application was his alleged receipt of instructions from a higher authority. And on that, he kept quiet. So I'm saying that would have been and by the way, he didn't have to go into all the detail he's gone into with the Zondo Commission, but what he could have done was take those crisp elements and say, listen here, this is what happened. It wasn't just me, it was the OIG and it was the minister, and then put it on the table. But no, the whole thing was hushed up for 8 years.
Just then, I guess as a final point on this, page 367, we're still in the affidavit, paragraph 24. He states in that paragraph that during this period, of course, this is after a whole long narrative about what was happening and the IGI's report and what steps he took. So then he says, during this period, I met with Lieutenant General Mdluli. I informed him that I had written to the IGI and had received a response from her regarding the disciplinary matter against him, but was awaiting her response regarding the criminal case against him. Yeah. I gave the same advice to Minister Mthethwa. At paragraph 25, he notes, I disagreed with the IGI's view that Lieutenant General Mdluli should return to work. She had not yet read the criminal case docket or expressed an opinion thereon, and I felt that she ought first to do so before he could be reinstated. I telephoned Advocate Khadebe to inform her that I would not be lifting General Mdluli's suspension until she has perused the criminal case docket, as this might influence her initial decision regarding the disciplinary matter against him. I was also aware that Advocate J. Govender from IGI was an experienced advocate and a former prosecutor, so I had faith that she would assist the IGI in making an informed decision on the status of the criminal case. Now, I was just concluding this conversation we're having, that these are some of the steps he states he took to resist the upliftment of General Mdluli's suspension. Yep. Now, my question is, do you take issue with the veracity of what he claims here?
The only issue I take with this is what I said earlier. This belonged in his answering affidavit.
Okay.
He should have taken the court into his confidence and explained to the court exactly what went on and then it would have resolved not only Part A, but there would have been no need for Part B, because actually Part B was fought hammer, tooth and nail by the police, and it was fought out in the Supreme Court of Appeal. So there would have been no need for all of that if he'd have taken the court into his confidence in May 2012.
Noted. Thank you.
Advocate Sello, Mr. Sullivan, I understand your criticism, and if one reads the SCA judgment, it appears to be the same criticism that one finds at page 470. 470 of the annexures or exhibits. So if you start at 469, paragraph 49, the court says the factual basis for the challenge by FUL is that it relied on statements made by then Acting Commissioner General Mkhwanazi in Parliament that he was instructed by authorities beyond him to withdraw the disciplinary charges and reinstate Mdluli in his office. And then FUL added that in doing so, Mkhwanazi had failed to make an independent decision, which rendered his actions reviewable. So that was the point about the review.
Yep.
And then the court says, this is now SCA, though Mkhwanazi filed an answering affidavit in the interim interdict proceedings in Part A of the notice of motion, he did not deal with these allegations.
Exactly
so this
the
is
point.
your point.
Yeah,
And
exactly
then
the point.
what the court then concludes, we can ignore the rest of that because it relates to General Pierre. In paragraph 50, the second last sentence, the court says, let's start at the fifth line where the court says, I do not believe this finding can be faulted. Moreover, after all is said and done, neither Mkhwanazi nor Pierre gave any reasons for the impugned decision. And then the inevitable conclusion is that the decisions were either dictated to by Mkhwanazi or were taken for no reason at all.
Yep.
And so the court has made a decision that in the absence of an explanation, we can conclude that they were dictated to by somebody
Yes,
else.
and Commissioner, if I can say, what they've done in the Supreme Court of Appeal is they've struck the evidence of Pieka because she stated under oath that this is actually what really happened. And to prove it, I'm going to come with a confirmatory affidavit from General Mkhwanazi. And since there was no confirmatory affidavits, they struck that evidence. They said that's immaterial. Therefore, they go back to game one, which was the answering affidavit submitted by General Mkhwanazi, where he just didn't deal with the issue.
So the point I'm making is because we were not getting anywhere, and I had understood that your criticism, you were taking it from the judgment. Although you added your own flavor to it, I must point that out, that you
Yes.
added your own flavor to it. But the substance of what the SCA found is that because he did not answer the specific allegations
Yep.
made by FUL,
Yep.
the inevitable conclusion is that he was dictated to
Correct.
by those
Correct.
above him.
Yep.
And we leave it there. And I think when General Mkhwanazi comes here the second time, we may then give him the opportunity to respond to
Yep.
your criticism of his conduct. And that's the best way of dealing with it.
I agree.
Thank you, Commissioner Kumalo. You conclude then at paragraph 1.7.10 at page 25 by stating, for example, in 2011-2012, General Mkhwanazi's conduct was intended to unlawfully protect Crime Intelligence Divisional Head, much the same as his conduct in 2025 is intended to protect the Criminal Intelligence Divisional Head and those under him. That then leads you to your next topic at page 26 at paragraph 1.8, and I think we should make a correction there. It reads July 2026 media conference. It should be 2025. The heading,
Yes,
we correct the-
1.8.2.
at 1.8, the main heading, it reads July 2026 media conference. That should read July 2025.
Yes, thank you.
Then you say, in this part of your statement, you are more or less posing a question to the commissioners.
Correct.
And you are not testifying or advancing any factual basis
Yeah.
or suggesting that the media conference was intended to protect criminals. That's not your suggestion.
I'm not.
You are posing a question?
It's not a statement, it's
Yes.
a question.
Okay.
And what I'm asking the commissioners to do is to have an open mind and ask yourselves the question, was that media conference a smokescreen? That's what I'm asking you to do. And in order to guide your thinking on that, I've given my own ideas here. And my ideas are quite simple. I've made it clear that for years and years and years, the epicenter of crime in the police service is the Crime Intelligence Division. It's the epicenter. Everything that goes wrong in the police, it's the Crime Intelligence Division. And why? Because we have a so-called Secret Services account, which is so secret, nobody can know how the money's spent, which is great. Because if you want some money to do other things with, you can do it. And nobody can ask you any questions. No Auditor General has ever given a clean report on the Crime Intelligence Secret Service account. And if one looks at the growth of that fund, by the way, you can pick up from the police budgets the fund itself, but you can't see how it's spent. And in 2012, when General Mkhwanazi was the acting Commissioner of Police, the budget for the Secret Service account was 98 million rand per annum. In 2024, it stood at 600 million rand per annum, which is an increase of 512%, which is 5 times the rate of inflation over that same period. But what we don't have is we don't have a concomitant decrease in crime. What we do have, if you look at the last 14 years, is we have successive heads of crime intelligence being arrested and sent to jail.
Staying on top of the core concepts of sustainable investing can add value to your clients, your team, and your organization. Confidently communicate with stakeholders, build technical fluency in assessing climate-related risks and opportunities, and learn how sustainability factors affect investment performance. Start today to gain the insights and skills you need wherever you are on your sustainable investing journey. CFA Institute. Set the standard. 2025.
They were arrested on the 26th of June. It's no coincidence. In my annexes, I have taken that media briefing of General Mkhwanazi and I've had it transcribed. His transcription is there. And if you look at the theme of the transcription and start looking at the mentioning of crime intelligence, it starts to conjure in your mind, was this a whole smokescreen to protect all of these people in crime intelligence? And when you think about it, and I ask you to keep an open mind, if you look at it, there has to be an answer there somewhere. It cannot be right that this is all linked. By the way, on the 1st of July, I had my attorneys, the attorneys of Forensics for Justice, I had them send a very strong letter to Commissioner Masemola. And the letter is very strongly worded. And it talks about the accused persons, which I refer to in my affidavit as the Crime Intelligence 7. And in that letter, we're demanding that these people are urgently suspended because they've all been charged with corruption. And according to General Mkhwanazi, it's not corruption, it's an HR matter. I don't agree with that. It's corruption. So we have this situation where they're charged with corruption. We send a letter through demanding that they be suspended. An hour later, or 2 hours later, we get a short reply back from General Masemola, which is on page 505 of my evidence bundle, which effectively says, I'll do what has to be done. I'll comply with the law. Not one of them has been suspended. Not one. To this very day, not one of them has been suspended. And by the way, some of them have been charged more than once, because General Lushaba, who's the CFO, he's in charge of the Secret Service account. He was also charged with losing his laptop computer and a firearm, and instructing members under his command to go out and get his laptop and firearm back, and then to doctor the docket that he opened. And when he opened the docket, he said that somebody came in through his window and stole his firearm, his state-issued firearm, and they stole his laptop. But it actually turned out that he'd invited a lady into his premises, and they had a few drinks, and he fell asleep. And she made off with his money, his firearm, and his laptop. He got other police officials at the rank of colonel to go and get his laptop and firearm back, which they did. He's charged for that. He was arrested for it and charged. And what they did, they went and got his laptop and firearm back. But now we had a problem because he'd opened the docket at the police station where he said somebody had climbed in through his open window. So he got those two colonels to go to that police station and get hold of the investigating officer on the case that he'd opened and remove the papers from that docket and replace them with fake papers. So that's the sort of thing that's going on in crime. That's the chief finance officer of crime intelligence. And when you look at all these things going on, and then you analyze, commissioners, the transcription, because nobody's produced the transcription before now. I've produced it. I had it produced within days of his media conference, and it's there at pages 510 to 536. And what's interesting is on page 533. On page 533, he doesn't mention my name. General Mkhwanazi says the following: that's why there's a call in public from a person that I will not necessarily mention his name, that the National Commissioner must bypass the disciplinary regulations of the service, must simply suspend these people because it's inaudible. Why is that call? It's a call that is putting more pressure to make sure the country, hence the handing over to the criminal syndicate. So because I've called for the suspension of these 5 generals and 2 brigadiers, General Mkhwanazi is accusing me of handing the country over to a crime syndicate. In fact, I'm trying to stop this crime syndicate that's active in crime intelligence from carrying on with their crimes.
Mr. Sullivan, can I ask you one question? You say the press conference of 6 July 2025 was a smokescreen.
Was it? It's a question.
Yeah. So let's assume that it was.
Pardon me?
I'm saying let's assume for the purposes of my engagement with you that it was a smokescreen.
Yeah.
Does it mean that the allegations made that day are not true and should not be investigated? Because that's what this commission has been established to do.
Absolutely.
It is to investigate, amongst others, the allegations that were made by General Mkhwanazi on the day. Now, say his motive, for argument's sake, say his motive was to protect the Crime Intelligence 7.
Yeah.
And that was his reason for this press conference. Does that mean the allegations he made are not true and should not be investigated?
Absolutely not. In fact, if you look at me having gone on record, on the 6th of July in the evening, I did a media call. The media contacted me about this whole media conference of his. And the first thing I said was there needs to be a judicial commission of inquiry. I made the point, and I've repeatedly made the point, that the lack of attention by the State Capture Commission to the criminal justice system has resulted in where we are today. And I have absolutely no doubt that a lot of good will come out of the allegations he's made. But were they made for the right reason? That's the question I'm asking. And I don't believe they were. And if you look at the transcript, it starts to come out what actually the purpose of that media conference was. And I don't believe it was just about Minister Mchunu and these various parties, what's his name, Kat Malala, and all these other people. I don't believe it was about that. And the reason I've given in my briefing here today is that I start off by saying, this isn't the first time that we've had criminals penetrating the criminal justice system. It's been going on for years and years. Even during apartheid, it was still going on. So this is not new, but if any good comes out of it, fabulous. But what I'm saying is we need to keep an open mind as to the motive. And that's all I'm requesting.
Is the motive a question that's within our remit, though?
Is the motive, sorry?
Is it a question that's within our remit? Must we answer that question?
If one
Is-
looks
it
at
does-
your,
it
if,
does-
you,
it
if
does-
you look at your,
So does that question fall
If-
within our terms of
yes,
reference?
if you look at your terms of reference,
Yes.
it doesn't go there. However, if you apply, as your colleague did earlier, this novus actus interveniens, what if he didn't call that media conference? Would we be sitting here today? The answer is no. So a sequence of events has taken place, and all I'm saying is not everything is what it's been painted out to be. And I've requested the commissioners to keep an open mind. I keep an open mind on these issues. Of course, I would like to persuade you this way or that way, but the reality is I would never like to persuade you of something that's not right.
We should keep an open mind on matters that fall within our terms of reference.
Exactly.
So that's why I'm engaging you on whether this is something that falls within
Well,
the terms
then
of
you're left with
reference.
the question.
Especially bear in mind that you have said a lot of good has come out of this process, and probably most of it does indeed fall within our terms of reference. So the issue is, all of that, or all of those issues, because we are yet to submit a final report, all of the issues that have arisen are issues that we must keep an open mind on, except those perhaps that are clear and on which everybody has already said something. There is even those that are implicated.
Of course.
Perhaps on those we may make, or rather have sort of final views on such matters, but otherwise we keep an open mind. But that relates to matters that fall within our terms of reference. So you keep saying, you're asking us to keep an open mind. If what you are raising, insofar as the motive is concerned, does not fall within the terms of reference, the issue of us keeping an open mind does not arise at all.
No.
If you accept that the question of the motive does not fall within our terms of reference, but I'm engaging you on whether it does, and I think you've accepted that it does not.
It's chicken and egg, isn't it? Because if the motive was to create a smoke screen, then it possibly does fall within your terms of reference, because you need to know what was that smoke screen all about. And then you start asking other questions. So I prefer myself to be the bringer of information, not the decider of facts. But I brought the information to this commission because I've spent the last 36 years of my life trying to make this a better country to live in for all people in South Africa. And that's why when I saw what was going on, I thought, I need to throw my 10 cents into the mixture as well, especially since I've been named by the protagonist. When General Mkhonasi got up and blamed me, I had nothing to do with this Cat Matlala and these drug cartels and all the rest of it. I had no knowledge of what was going on until I heard about it in the media. But for him to name me, why was he naming me? And I can tell you the reason why. Because I didn't write, I got my attorneys to write a letter to General Masemola and demand that these 5 generals and 2 brigadiers be suspended. That's why I was named.
I would understand the smoke screen point better if it does not go beyond saying This was a smoke screen that was calculated to shield these generals from criminality that they are otherwise involved in. So we don't really get into, was it indeed a smoke screen? That's not before us.
I understand.
That's not before us.
I agree with you. I agree with you that your terms of reference do not ask you to consider whether it was a smoke screen.
Yeah. So the criminality itself would then have to be something that does indeed fall within our terms of reference. The criminality shielded by the smoke screen. Your
Yeah,
comment?
I suppose the acid test will come in time when we see what happens, because we do know.
Yes. Alleged criminality, of course,
Yes,
at this
alleged
stage,
criminality.
yes.
We do know, for example, that last week or the week before, there were allegedly other warrants of arrest for two of the same generals, of two of the same 5 generals apparently are going to be arrested again. I have no knowledge of that, only what I've seen in the media. Hopefully tomorrow will be a peaceful day, and then whatever has to happen will happen. But I do believe that it will all unravel. It normally does. You know, if one looks at the late Commissioner Jackie Celebi, people don't believe me when I tell them, actually, I spent 8 years investigating that matter. And they say, 8 years? How can you spend 8 years? Well, you want to get to the truth, so that's what you do. And in this matter, there's a lot of things coming out of this commission, which is really, really good, because we're seeing generals in the police being exposed for criminality. And that's fantastic. But it doesn't mean the person that's exposing them hasn't been involved in any hanky-panky either.
Thank you, thank you.
Thank you, Chair. Just to clarify 2 things. From your paragraph 1.8.2, you deal with this
Sorry, page number?
26 of your statement. The second paragraph, that's where you introduce the charges brought against Lieutenant General Khumalo and the 6 other members of the service, whom you term the Crime Intelligence 7, right? At the next paragraph, you state that their charges relate to the irregular employment of Ms. Mukwele in a senior ranking position of brigadier in the technical support services of crime intelligence. And then beyond that, you talk about what transpires after they were arrested. The point I want to clarify is the budget and the looting of the Crime Intelligence Fund, alleged, this case has got nothing to do with that. It has no bearing, or in any manner are there allegations that these 7...
This commission?
No, the charges brought against the people you term the Crime Intelligence 7. It's got nothing to do with the looting of the...
For what they were arrested on that day, I agree.
Yes, that's a clarification I seek.
General Pelani Lushaba was arrested 3 weeks before that.
Yes.
And that was pertaining to the crime intelligence funds. And I'm just saying...
Now, let's take it a step at a time, right? We're dealing with these charges here.
Yep.
And I ask this because you start that subject by introducing this 512% increase in the budget, and you pose questions as if there is no legitimate basis for that growth in budget, and therefore insinuating that something untoward is going on. You state that in your 181, and then you follow it up with the charges. So I'm saying, in truth, there is no...
people that are being charged here.
But these people, you say at 1.8.3 that their charges relate to the irregular appointment of Ms. Mukwele, and that's as narrow as it gets.
Absolutely, but as a separate issue, if they can be charged with these acts of corruption, why would you leave them in charge of a 600 million rand budget?
Okay, I will pose that question to subs, but in the
I
meantime,
understand.
then you introduce the second issue of General Lushaba, the
I
second
understand.
charge where you. Then you
Talk about
introduce the second issue of General Lushaba, the second charge where you talk about the computer disappearing under.
May I just very quickly ask a question around the appointment of General Mukwele, Brigadier, I'm very sorry, Dineo Mukwele. Sotho people must please forgive me, I'm not at all sure of the pronunciation of this name. The evidence that was given by General Kumalo is that the position required someone with expert skills. I forget the term he used for this, but he had a special term for the expertise they required for this position. And if I'm not mistaken, I think he said largely that expertise is to be found within motor vehicle manufacturers.
BMW.
Sorry?
So when I found out about this,
I did not get the impression that it was BMW only. The skill is within motor manufacturers.
Right, she was working at BMW head office.
That may be so, but what I'm saying is, what General Kumalo said was that for this position, they required a certain expertise, and that this expertise is to be found within the motor manufacturing industry. Doesn't have to be BMW, it may be BMW, it may be Toyota, it may be Mercedes-Benz, or whatever other company that manufactures motor vehicles. You are with me thus far?
I understand what you're saying.
Yes. And so he said, it's not unheard of within SAPS to appoint someone who has no experience at all in policing. If that person is being appointed for the expertise they possess. And this applies over several types of industries or environments. So it's not just the motor manufacturing industry. And he gave a few examples. And I'm sure that you too, with the experience that you have, you must be aware that there are other people with other forms of expertise who have been appointed by SAPS and not given the rank of constable, but given higher up ranks within SAPS with no policing experience at all. Do you accept that this does happen within SAPS?
I accept that in the police service,
yes,
from time to time,
yes,
people are appointed that have no policing experience.
Yes.
However, they go through a procedure to motivate why that person should be appointed, and there's normally a panel where people are interviewed. It's not my function other than to suggest to the commissioners that the best people to answer these questions would be IDAC, because they're the ones that charge them. And I've seen the charge sheet because it's a matter of public record. And the charge sheet makes it clear that they interfered with the recruitment process to unlawfully appoint this particular woman, when in fact they could have, if she was that important to be appointed, they could have motivated it properly and done it transparently. But it was done without transparency, and it was done behind closed doors, and there was no proper recruitment procedure followed, which is why General Mkunasi said, oh, it's an HR matter. It's not the HR matter. They are alleged to have committed fraud when they hired this lady, and I think IDAC would be best placed to explain why they were arrested and charged rather than myself.
On this having been done behind closed doors, do you mean that there was no advertisement for the position?
That's not what I believe. I don't know. I don't know enough detail about it, Commissioner. All I know is what I saw. I phoned the lady, this Brigadier Makwela, and I explained to her that I'm from Forensics for Justice. I'm speaking to you now because these allegations have been made. I'd like to get your version of events. This is before I made a formal complaint.
But you are basically saying you cannot say that there was no advertisement.
That's what my understanding is, that they didn't follow the correct procedures.
Do you know for a fact whether or not there was an advertisement?
Whether there was what?
Whether there was or there wasn't an advertisement for the position. Do you know?
I don't know. I couldn't find the advertisement.
Or do you know or do you not know? Or you say you did not find the advertisement. My next question was going to be, do you know or do you not know what the requirements were for the position?
Absolutely not. I laid the complaint based on the information I had. And what I asked, but by the way, I don't believe I was the only person that laid a complaint. I believe a member of parliament also laid a complaint. The reality of the situation is that the best place to get the answers to these questions, Commissioner, would be IDAC, not me.
You see, what we got, I'm not even sure from what sources, appeared to be the unsubstantiated complaint that someone with no policing experience had been appointed as a brigadier. That doesn't say much. If we know, as you accept, that within SAPS they can appoint someone with no policing experience to a high-ranking position. So that means nothing on its own.
So, Commissioner, I didn't base my complaint on the fact that this person had no policing experience. My complaint was based on the information that I received. And when I checked it out,
which was what? What was this information?
The information I received was that she was parachuted in, which is an expression meaning bypass all the procedures, appoint her at any costs. That's the information that I received. And that's the report I made.
Do you have any difficulties telling us who or how you received this information?
Pardon me?
Do you have any problems telling us how and from whom you received this information?
So, as I mentioned earlier, Forensics for Justice have a hotline, and we have a web report where you can make a report on the internet without leaving your name, who you are, and you can phone and leave a message on the toll-free number.
Yes.
In this particular matter, it came through on the toll-free number by a person in crime intelligence. You know, I looked into it. I phoned the lady in question to see if she would give me a reasonable explanation. I do believe I may even have the messages that I sent to her.
No. Just give us the substance of.
Okay. So, my phone call was, "We've received this complaint. I'd like to hear your version of events." She said, "No, I can't talk to you. You must speak to head office." I said, "Who at head office?" And she put the phone down. That's not the conduct of a person that's got nothing to hide. So then I obviously ran background checks on this person. I spoke to BMW Motors, and I was able to establish what she was doing there, and that comprised the report which I gave to the OIG, the Office for Inspector General of Intelligence. So when you make these type of complaints, the place because it's crime intelligence, the place you make the complaint is the OIG. And if they don't do anything about it, you might take it further. But I subsequently heard from the OIG, because I had meetings with them, and they told me that they'd referred the matter to IDAC.
Thank you.
And if I may just follow up on this question the chair asked, in response to a question the chair had posed to you, you stated that you inquired from BMW what position she held at BMW.
He's an admin clerk.
So BMW advised you that she's an admin clerk?
Correct.
And not that she held the qualification that the chair earlier referenced, they never told you about that?
And when I asked her about her qualification, she didn't want to discuss it with me, so I couldn't really go any further.
Well, I'm sure it's not very surprising because you are a third party wanting to know about her personal affairs, so she's not duty bound exactly to account to you, is she?
But when I explained it to her, Commissioners, I didn't say, by the way, I want to know about your personal affairs. I explained that we had received a tip-off, and the tip-off implicated her. And I would like her to clear the air by explaining what happened, how she was recruited. And she just told me, you have to speak to head office. I said, who at head office? She said, no, that's your business, you must find out. And then she put the phone down.
Okay. Have you ever...
Sorry. Just for the record, the expertise that was required here is mechatronics.
Say again?
I'm saying the expertise that was required for this position is something called mechatronics. Just for the record, I'm not asking for a response.
May be the case. And I do believe that the best place to get the answer here would be the prosecutor that charged them.
Yes. And lastly, you are not on record as having suggested that she was a tea lady at BMW. That has been bandied about in public. You are not the source of that claim?
Absolutely not.
Okay.
I was able to ascertain that at that time, I'm going back now over a year and a half. At that stage, she was 29 years old.
Yes.
So definitely not a teenager.
No. Tea lady.
Oh, I thought you said teenager.
No. Then I'll repose my question then.
No.
Because I say it is bandied about. Let me explain myself.
I definitely made no mention of her being a tea lady.
Okay.
But what you have in this country, well, you have in every country, is you have this thing called social media, which
Yes.
I don't engage in.
Yes.
But you get somebody on social media who says, oh, they appointed a tea lady as a brigadier. But, definitely I'm not the source of such activity.
And that's what I sought to establish. Commissioner?
Yes, Mr. Sullivan, I ask only because you say you're one of the people, one of two people, I think, who laid a complaint. Now, in respect of Brigadier Mukwele, what was your complaint about her in particular? I'm not asking about the other.
My complaint was that she had been recruited without going through proper recruitment procedures. The informant that came to us told us that this person had been recruited to a position which other people had applied for and were competent to do, but they had bypassed the procedures.
And, I mean, it being a criminal complaint, you consider
It wasn't
that...
a criminal... My complaint wasn't a criminal complaint.
Oh, I see.
It was a complaint to the OIGI that, and by the way, it sat with other aspects of a broader complaint involving properties that were being purchased and other issues,
Yes.
which I haven't brought to this commission because, it wasn't part of your terms of reference.
You have answered me. I was interested in understanding what firstly, I thought your complaint against her in particular was that she committed a criminal offense, and I wanted to know if that
No, I
is
never
so.
said
You
she
never.
committed
All
a
right,
criminal
that's fine.
offense.
Thank you.
Can you just clear up, sorry, Advocate Sello, maybe you may resolve a mystery. Was it you by any chance who slipped the dossier, the investigation dossier, under a certain member of Parliament's door?
Which dossier?
You said you conducted the investigation and then you sent a complaint to the Inspectorate General.
Let me be truthful.
Yes.
I'm not in the business of jumping on a plane and flying to Cape Town to slide a dossier under anybody's door. The information, I've still got the emails on my email system where I report to the OIGI. I don't send any dossiers to, and I know who you're talking about. I don't do that.
But he did not get it from you.
absolutely did not get any dossier from me.
Thank you.
Thank you, Commissioner Kumalo. If I may move then to page 28 of your statement,
Yep.
and maybe some clarification here. At paragraph 1.8.9,
Sorry, Mr. Maybe before you do that.
absolutely.
Mr. Sullivan, in your paragraph 1.8.5, you refer us to the two letters. That's your attorney's letter to General Masemula and his response. And your further response to him is quite scathing. And I think you've spoken to that. Looking at his response to your attorneys.
No.
No, I'm saying I am looking at.
Say again?
I'm looking at his response to your attorneys,
Yes.
which you find at page 505,
Correct.
and which obviously displeased you. And you are, in page 506, you speak quite very strongly against that letter.
Yes.
Now, the last paragraph would have been in his response at 505, would be what offended you. And I just want to ask, what is wrong? What do you consider to be wrong with this response?
Which paragraph?
The last paragraph in 505, General Masemula's response to you, to your attorneys.
What was the purpose of the trip? What?
Page 505, are you there with me?
Oh, 505.
Yes.
Sorry. $505, yes?
Yes, that's General Masemula responding to your attorneys.
Correct.
Yes, and my question is, what do you fault with this kind of response? I mean, I look at the last paragraph of that letter, and it is standard letter. And no, let me finish. It's a standard response about respect for the Labor Relations Act. And all the applicable relevant prescripts.
I used to say, if I hear AI one more time, I'm gonna lose it. But Monday.com is super easy to use and knows how to do AI right. My team quit going through endless documents ourselves. Monday Sidekick handles that now, pulling the crucial info and then prioritizing based on whatever we need. So stuff that takes my team hours is now done before they even open their laptop. I use it for insights and action suggestions constantly, especially on those back-to-back meeting days. All these AI features are built directly into Monday.com and actually use our real data. With Monday.com, AI isn't some over-promising future. It's here. It just works. Like, actually saves us time and resources kind of work.
Monday Sidekick, AI you'll love to use. Start a free trial today at Monday.com.
A little bit. And we talk about the evidence I gave you in respect of General Khan. That's just one example of where I'd laid a complaint and he just ignores me. But on this matter, he sent this letter.
Yes.
And you're looking at a situation where 5 generals and 2 brigadiers, there's going to be no suspension. By the way, they were never suspended.
No. Yeah, sorry, maybe let me clarify what I'm asking. Your attorneys write a letter, right? That's the letter at page 502, in which they demand the suspension of these people. There's no reference to anyone else, any other case. There's no Khan, there's nothing to it. There's just these people, the generals and the 2 brigadiers. And then they demand in the letter that these people must be suspended, otherwise you'll bring an urgent application to court. He responds to you and he says, the National Commissioner is aware of his constitutional duties in terms of the SAPS Act, as well as the SA disciplinary regulations. It must be emphasized that this matter is receiving the necessary attention it deserves, and it's a matter that involves the relationship between employer and employee in line with the Labor Relations Act, as well as all the other relevant prescripts. That's what he says. You respond and you are displeased by it, and you call it a response which you say you describe as an arrogant middle finger response to my attorney's letter of demand. So at this stage, we are speaking about your attorney's letter and his response. That's all we are discussing. And my question is, what do you find wrong and offensive in the manner in which he has responded, which I've just read to you now?
Well, if I put myself in the shoes of a commissioner of police, and I've got 5 generals and 2 brigadiers that have just been arrested and charged with serious crimes, including corruption, I would immediately suspend them. Immediately. And it's good for some police officers get immediate suspension when they do wrong. But these 5 generals and these 2 brigadiers, we get this response saying, I'll do what has to be done, I'll comply with the legislation, but actually nothing was done. They've never been suspended.
The nothing was done, they've never been suspended is post. The nothing was done. You say nothing was done.
Yep.
They were never suspended.
Yep.
That's what you say.
Correct.
But that is after he has written this letter.
Yes.
So he writes to you on the 1st of July and says, that's the position of the law, I'm aware of it. And you, on the 5th of July, you say this response is effectively a middle finger, is to raise a middle finger to your attorney's letter. What I'm asking is, well, maybe let me speak for myself, that I see nothing wrong in his response. It is standard response that says, I will abide with the prescripts. That he later on doesn't suspend them is a different conversation, and I would probably have the same problem as you, that he didn't suspend them after he said, I'm looking at it. But at this point, I'm speaking to the response, and especially because your response to him is quite flowery language.
Yep.
And it's terribly uncharitable response to him. And I'm asking on that basis but what causes you so much offense in this letter that he writes to you?
My response to him was meant to be antagonistic. It was meant to put him under pressure. I realized, because I took legal advice, based on the letter that he'd given, we were ready to bring an urgent application. But based on that letter, damn, we can't bring the urgent application. Now, that letter may look all good and legal and above board, but the reality of the situation, given the seriousness of the crimes for which these people have been arrested, they should have all been suspended. There can be no doubt in my mind. If I was Commissioner of Police, I would have said, sorry guys, you're suspended immediately.
Yeah, except you're not allowed to do that. You see, we have labor laws in this country.
But they do.
No, let me say.
Yeah.
We have labor laws, we have a disciplinary code that regulates processes that lead up to a suspension. So what you say that you would have done, it wouldn't be in accordance with the prescript. Maybe he shouldn't have followed the prescript if that's what you're saying. But what you're saying he should have done is not how it works.
So
how it works is you give the employee an opportunity to make submissions about why they should not be suspended if you're considering to suspend them. And depending on what they say, it depends what they say, because you have to take into account what they say in their submissions, and then you make a decision. Anything other than that is in fact an unfair labor practice, which our law punishes.
Can I respond?
Yes, you may.
So, if we're talking about a work environment, like a company or corporation, or even a government department, I agree with you. But we're talking about people that are supposed to be upholding the law. And there have been multiple occasions where senior police officials have been suspended instantly. And that, what's good for the goose is good for the gander.
And they have been returned. They have been returned to work if a procedure that was followed is not in compliance with their disciplinary code and the law. They have been returned.
Yeah.
All right. The point I'm making, the simple point I'm making is, that he says to you, I will follow due process. Maybe he meant to defeat your agent application. I don't know about that. I'm looking at the letter and especially your response to it, and I don't understand what would have angered you that much that you speak the way you do in your response to him, including telling him that you will take him down. You've taken 2 commissioners previously down, and you will get him removed. I'm trying to make sense of that kind of response to this letter.
Yeah.
But I've heard you. Thank you.
Thank you, Chair. Just a quick one, Mr. O'Sullivan. We don't have to go there. I can read it for you. I take it that you are aware that during his testimony on the 17th of September, General Mkhwanazi, and it's in his statement, paragraphs 8 and 9, indicated as follows: I must emphasize that this briefing was a product of a collective and collaborative efforts of various units within SAPS and the majority of men and women in the service. It is a reflection of the common concerns shared among members of all ranks and a common desire for their resolution to enable these members to serve with honor. At paragraph 9, he says, in presenting the information I shared with the public, I acted both as a member of this collective and the person designated to deliver this collective message. You recall that? Now you hear that.
I can't remember.
Okay, but you've heard what I've just read out to you.
I've heard what you just said, yes.
Now I turn then to page 28, paragraph 1.8.9. My question really, I'm trying to understand what your challenge is at 1.8.9 in the context of what I have just read. You state that in your submission to the ad hoc committee, which was ignored by them, you pointed out that the PowerPoint presentation used by Mkhwanazi had metadata which showed it had been created on a SAPS computer, which is emphasis not Mkhwanazi's computer. It would be wise for the commission to establish the use of the said computer and who typed and where they typed the presentation to the media. Why must we concern ourselves with that exercise?
Well, I'm not saying you have to concern yourselves with it.
The basis for the
I'm suggesting
suggestion?
it would be wise because it may well be that the person that prepared this presentation is not from Mkhwanazi's office at all.
But if you look at the picture, you have
That's the metadata.
the metadata, you have reflected it here. It says the creator is SAPS, then a number there. It gives it's a SAPS computer. So in the context of General Mkhwanazi saying that he acted as a member of a collective within SAPS, and somebody to deliver, does it become an issue that the presentation was not created on his own computer, but on another SAPS computer?
It may not be an issue.
Okay.
But until we know who actually prepared that presentation, why not be transparent about it and say, by the way, on such and such a date, I sat down with this person, that person, and we prepared this presentation. All I'm saying is there's an opportunity to have transparency, and it would be wise to do that. I can't dictate to the Commission what to do. I'm just making a suggestion.
I guess, we don't overpromise and underdeliver. I'm trying to appreciate the value of that exercise, because at 1.8.10 you say, I believe it is in the public interest for the computer's users' details to be obtained and the person interviewed to establish who instructed him, her, what he, she was instructed, and where and when he, she typed out the presentation. The metadata reflects that this is a SAPS computer. General Mkhwanazi says it's a whole lot of us. I was just there as in a representative capacity. Why must the Commission go down that rabbit hole to establish what in particular?
I'm not saying the Commission must go down that road. I'm saying there's an opportunity there to have some transparency and find out who actually put this together.
It's a member of SAPS.
Yeah, but who?
The collective that General Mkhwanazi references in his statement.
One person typed this, not a collective.
Okay.
It would be useful to know who that was, I think.
Okay.
Surely, Mr. O'Sullivan, you have something that you would like to establish. What is it that you would like to establish for us to even consider that?
Commissioner, if one looks at the media briefing, and if one looks at this presentation, I'm saying the missing information is how that presentation came into being. And if we're talking about a collective, who is that collective? How did we form? How did we come together to make this presentation? That information is not in the public domain. And since this whole...
Surely you have your own theories.
I have my own theory.
You would not otherwise be going down that route.
I have my own theory, Commissioner.
That's why I'm asking you, what exactly do you want us to establish?
You see, there's the problem. I have my theory, but I would prefer if that information was provided without my theory being applied, because it may or may not reveal something interesting. That's all I wanted to say.
It's very uninteresting for us to go that route if we have no idea what we want to establish.
So my theory may not be factual. So if I have a hypothesis which hasn't been proven and I publish it, what am I actually doing? It's like Leonardo da Vinci inventing the airplane. Actually, he did it 400 years before the plane was invented. Now, the reality is I have a theory, but I'm not in the business of publishing an untested theory.
I was not even pushing you down that route, not at all. I just wanted to get an idea of...
I just believe
yes.
that there's a lack of transparency around how that presentation came to be.
Just to try on the same theme. If your theory, and I'm not saying it's your theory, if your theory is it's General Mkwanazi and Masemola, and let's say Dimpane, I'm just giving you names randomly. What difference does it make to this which you say we should find out? So you can pick any names and say to us that because what it will reveal is A, B, C, D. It's again trying to understand what really is your issue about this.
Let us say that when I asked this question, it links to a previous question I made about keeping an open mind, about the motive to this media conference, because we have to believe that the motive, according to General Mkwanazi, was that, these are the issues and we want to get it out there and I'm going to become a whistleblower and I'm going to fight for my country and I'll die if I have to and what. Very emotional. And I'm surrounded by people with machine guns and balaclavas and whatnot. And I just believe that there could have been other ways of getting the same amount of attention on this matter without necessarily having this whole media briefing and having all the staff, by the way, from the provincial office there. All those people were sitting there on a Sunday afternoon. And by the way, who would have ever thought that I would receive a copy of that PowerPoint presentation? I didn't even know the media briefing was going on until a journalist phoned me and said, this guy's talking about you after the media. I said, what? Who? Which guy? And he told me. And I said, well, what media briefing? Do you have a copy of it? And he sent it to me. So not realizing I could now check, which I do with a forensic tool, I'm able to pull the metadata from that. And I thought, oh, that's interesting. Now, I'm just saying there's a lack of transparency here, and that transparency may help show the motive behind this whole process that took place. Because it wasn't just a media briefing. It was a lot more than a media briefing. And I just think that whole thing needs to be opened up a little bit. And it's not part of your terms of reference, but I do believe that somewhere along the way, it may come out, okay, this is why it happened, this is what caused it, and these are the people that were involved. What if the theory shows that there was a little third force running around, and that's really what's going on here?
Thank you.
Thank you, Commissioner Baloyi. Mr. O'Sullivan, I think if you turn over to page 29, we've covered the issues that are set out here to your page 29. So effectively, that would bring us to the conclusion of your testimony and the end of your statement. And to say to commissioners that barring any questions there may be for Mr. O'Sullivan, that would be the testimony of Mr. O'Sullivan.
Mr. O'Sullivan, thank you very much for your testimony, and thank you for enduring the very long day.
It's a pleasure.
You are excused.
Thank you.
Thank you. 9:30 tomorrow?
9:30 tomorrow, Chair.
Let's adjourn and resume at 9:30 tomorrow.
I'm good, thanks, and you.
In our briefing, reiterate and stress on the Constitution and the laws of the country and why they must be preserved and respected is precisely to remind South Africans on what is expected of them in terms of Dangerous Weapons Act, in terms of Section 17, that I will reiterate, Section 17 of the same Constitution that all of us as South Africans subscribe to. And because we are a sovereign state, that is expected for those that visit our country, who reside in our country, to respect those laws. So in terms of the Constitution, Section 17, it expressly indicates that rights and so on and so forth. Hence, we want to reiterate and continue to educate our country that that is a constitutional expectation and mandate, that when you so express, where you so demonstrate, make sure that it is done correctly in terms of a date. Dangerous Weapons Act defines what are these acts. I think we had the same briefing and engagement with the media where we did alluded on the fact. Why are they not arrested? We do arrest where it's necessary. We use the laws that are applicable in terms of Public Violence Act, where we have those that continue to brandish and carry violently the weapons. They are being addressed in terms of the numbers that I have been providing earlier. Some of those, if one can look at some of the cases that persons have been charged with, includes public violence, it includes damage to property, includes assault, it includes murder, as I have indicated on the 4 cases that some of these cases do have persons that have been arrested. We also have arrested an individual that was impersonating. We have been reiterating and taking from the strategic objectives that the President has outlined on the 7th of June that we are not going to allow an ordinary South African to be approaching any person and asking for that is within the law enforcement. Only the Defense Force, only the South African Police Service, and the Home Affairs officials can are mandated to ask for documents. How many people have been arrested from March and March? The intention of this briefing is not to label individuals because we will have to go deeper in looking at the affiliation of an individual. The indication of the cases at Rosettenville, it's because of how the individuals presented themselves, how were they wearing during their exercise, and taking from the leaders of March and March that they were pleading for their followers not to be out of line. Hence, we have responded, and we have responded swiftly, and I believe that the organizers and the leadership of March and March will be proud of law enforcement that we will root out the elements that are not representing them. On the 103 cases, I think I've already alluded on the offenses that these people are facing. Are there laws against anti-foreigner sentiments in RSA? There are no laws specifically to say if you do this to the foreigner, it is an offense. Our laws are a blanket laws that look at the rights of every person. You'll recall that we observe the right of every person within the borders of our country. Any offense that is committed to any person, it's illegal. But in terms of the people that are illegal in the country, we also discharge what is contained in the laws, including the immigration laws. Hence, from time to time, there are persons that will be arrested. On the 50,000 numbers that I have alluded to earlier is those that have been charged precisely on immigration laws. Why so much preparation for the march that is coming tomorrow? It is our responsibility and a constitutional mandate and obligation where we know that there will be marches, and perhaps we are now talking about the march that is coming tomorrow. But from time to time, throughout the year, there are sporadic marches and protests that we do police, and we do have such statistics. We even have the breakdown of those that were peaceful and those that required us to exercise and implement some of the rights that are contained in terms of making sure that those that are on the wrong side of the law are facing the full might of the law. However, we also look at the post and previous experiences when a march of this magnitude is planned. Hence, you have heard the appeal to South Africans that let us exercise our rights as contained in Section 16 of the Constitution. However, let us do so responsibly. Let us do so observing other people who do not want to participate, that they should be left with peace. We cannot be forcing people. We can encourage, but you can't force anyone to participate in a march if he or she does not want to do so. So it is from that premise that we will put all measures in place to make sure that we save our country. Said earlier, this is the only country that we have as South Africans, and we have duty, we have the obligation as law enforcement, where we know to protect both marchers and to protect the property, to protect individuals who do not want to partake in the march, to protect those that want to be the observers. It is our duty and our responsibility to do so. Hence, we have put measures in place to make sure that, because we know, we were told that there will be this much, history tells if these things happen, they cannot go unobserved, they cannot go without a law enforcement, they cannot go without the support. Where we get to be notified, we sit around the table, we work out the plan, we guide, we give limitations where we require, limitations in terms of guiding the marchers of the dangers of certain areas or why certain areas cannot be used, And if used, whether we have enough resources, and I must reiterate, Regulations of Gatherings Act, it's very clear on the expectation of those that plan the marches, those that become the organizers, what is expected of them and what is expected of law enforcement.
All right, colleagues, in the interest of time, we're going to take the last round of questions because we do have an early morning tomorrow. We need to rest. Okay, last round. Yeah.
From Newsroom Africa. I think I just want to start with that massive amount of money that has been allocated as part of the security budget. Of course, that's 600 million rand for this particular protest. I think the question is just, where's the money coming from? From what I understand, is that there hasn't been a legislative mandate for emergency or disaster legislation. So just the question is, where has that money been redirected from? Perhaps maybe other departments, but where is it coming from? Another question I think is, as we speak about, General, you've mentioned that these past 24 hours have been absolutely crucial and shown some stability across the country. Overnight, though, what are we expecting? We're really starting to see some demonstrations flaring up in areas of Kakamas in the Northern Cape, Germiston, community alerts coming out from those particular areas. Another issue is regarding the demonstrations. Have we made any preparations in regards to counter demonstrations? Some of the groups that will then be protesting against the likes of March and March. Yeah.
All right, thank you. I think there's one question online from Lisa Lee, News 24. Can you please advise whether the SANDF has been requested or authorized to assist law enforcement in any province? If so, in which provinces will SANDF members be deployed and what role would they be expected to perform? I think that's the last question and then we close it there.
Does that with the last question?
General Jalisi, Major General Joseph Jalisi, as from the SANDF. He is a co-chair of the NAT Joints. Over to you, General.
Yeah, good evening to your viewers. SANDF, as the chair indicated, is in support of the police in enforcing law and order in the country. And we are already in 9 provinces for any eventuality. As she has indicated, there's no form or shape of anarchy that seeks to challenge the authority of the state that will be allowed from any individual. It doesn't matter whether it's a South African or a non-South African, as long as you seem to break the law and challenge the authority of the state. So SANDF is deployed and ready to ensure that the integrity of the state remains intact beyond what we are talking about. Thank you.
Okay. Thank you, General. I'll now hand over to General Musigiri.
Thank you very much. On the question of the massive amount and where the money is coming from, the Acting National Commissioner on Friday, when we were launching the ground forces, did elaborate on the planning and the requirement of the police, because the amount that was communicated, it's the ground forces or the frontline deployment of the police that is estimated at 600 million in terms of the plans that were put in place, what will be expected. And it is not an amount, and I want to reiterate, not an amount of money that is planned for one day. You'll recall that when we are to move operatives from one area to the other, you need to work out what will be the spending in terms of fuel and others. So this amount is inclusive of any operational budget that will be required at this time for the deployment of members, for the equipment that will be used, for the overtime that will be required for those that will be expected to work overtime. There are individuals that will work 24 hours or those that will work 12 hours, which is the operational expected monies that must be paid. So this amount is inclusive of any other cost that will be required for SAPS to discharge its constitutional mandate. The expectation of any other year is to put aside a certain amount of money for an unforeseen. So part of this will come from the unforeseen, and the Acting National Commissioner indicated that where there are shortages, there are those that will be knocked at to ensure that when the dust settles and we have claims that are submitted, individuals and members will be paid what is due to them in terms of the work that it will be expected for whatever period that this operation will be undertaken. Yes, I have indicated that it has been relatively quiet. And to say relatively quiet doesn't mean there are no marches. Even today, there were demonstrations. We do monitor them. They were policed. The past month, since we have started to monitor the marches, we have been monitoring and managing the marches. So they are quiet because they were manageable, and we have seen a lot of them. I think earlier on there was a question that there have been peaceful marches, and we want to thank South Africans who have done those peaceful marches. We have responded on the numbers that I have read out of those that went out of what was expected of them when they were doing marches. That is why we are able to come here today and give you figures of those that are coming from the marches. The total number of arrests that were, it's been extrapolated from the total number of arrests that has been effected through various operations, but we have singled out those that were coming from the marches to say, out of the demonstration and marches, those that were not peaceful, those that required the police to respond and other law enforcement agencies, we have responded, hence those particular individuals were arrested. Every person in this country is expected or is expecting, in terms of Section 12 of the Constitution, to receive a fairly free and non-violent a country with no threats on their personal security. That is the implementation of that right that we want to reiterate to everyone, that you are guaranteed by the Constitution in terms of Section 12 of the right to be free from violence and the threat. I am reiterating this because there is no need for a pushback. There is no need for a counter demonstration, because you are covered by law that your right to be free of violence and threats of your personal safety, it is a guaranteed right in terms of the Constitution. The reason why law enforcement is on the ground is to ensure that nobody is encountering any other person. We cannot be in the country where the other one is fighting and the other one is retaliating. But the state has the duty and obligation to ensure that those that are demonstrating do so peacefully. Those who do not want to demonstrate also live their life free of violence or any threat to their personal being.
All right, thank you, General. Colleagues, I think we've reached the end of our media briefing. See you tomorrow morning, as early as I know, 5 o'clock for most of us. Thank you so much for coming through to our media briefing. Thank you to the generals. As you've heard it, it's a normal working day tomorrow. There's nothing to fear. The state is in control.
Managing IT support is easy because I use ClickUp. Here's how I do it without the ticketing headache. When someone needs help, they just post it in our IT support chat. No forms, no emails. An AI super agent instantly turns that message into a structured ticket with all the right details filled in automatically. It's then routed to the right team, prioritized, and tracked through every status. Now, my team can